Structure comma.
கப்புத்தாங்கல ஐயோ கப்புத்தாங்கல ஹீரோயின் போன் தொலைஞ்சா ரெட் நைன் நியூஸா காங்கல கப்புத்தாங்க வந்தா ரேட்டிங் பிரிண்ட்
Or International School, holistic education hub designed to nurture a child's all-around development with a value-rich learning beyond academics. VIT's 3+ decades of magnificent contribution to education gives birth to Velour International School. VIS is empowered by the vision to nurture and promote unhindered knowledge seeking and make it a premier institution of the nation. VIS stands out with its holistic learning, wisdom, the student profile building program, and personalized house parenting for an extraordinary educational experience. VIS campus, immersed in natural light and surrounded by lush greenery, offers a strong connection with nature. The campus provides a serene and calm atmosphere for the young minds to flourish. The classrooms at VIS enrich experiential learning with innovative and immersive teaching techniques, where the curriculum is designed to create leaders of tomorrow. The library serves as a beacon of knowledge, a sanctuary for curious young minds, instilling a love for learning. Our labs are designed to ignite the innovative mindset in students, introducing them to a world of hands-on learning and a keen interest in science and technology. VIS residential blocks with a dedicated house parent ensure not just safety, but a nurturing environment where every need of the child is attended to at all times. VIS has a dynamic sports program to ensure students in a spirit of competition and team building, creating students ready to conquer challenges on and off the field. VIS is where safety meets nurturing care, ensuring your child takes the first step towards a life of accomplishments. Velour International School. Right place to rise.
VIT Chennai is a globally engaged, competitive, comprehensive, research-enriched university campus strategically positioned to respond to major industrial, social, economic, and environmental demands and challenges. The campus has a cosmopolitan atmosphere with students from all corners of the globe.
The curriculum at VIT is designed to help students discover their strengths and enhance their academic performance. VIT focuses on improving the uniqueness of each student.
Whether you're a coder, creator, or changemaker, this is your launchpad. VIT's Incubation Center transformed my idea into a real product and helped launch my startup journey.
The fully flexible credit system at VIT gives me the opportunity to learn at my own pace. I can choose my own subjects, my own schedules, and choose to learn with the professors who work the best with my learning ability.
VIT Flagship Engineering Institute has been consistently ranked among the best engineering institute of the nation, making it one of the most preferred engineering destinations for students of the nation.
Being part of the research community means continuous learning, experimentation, and the freedom to explore new ideas. VIT offers a wide array of schools and academic programs over various disciplines.
VIT School of Law is one of the leading law schools of the nation that is dedicated to honing and producing tomorrow's lawyers and law practitioners. The unique moot court concepts prepare today's aspiring lawyers for tomorrow's challenges. Simulated court cases are fought and debated as students develop gaining confidence, art of interrogation, communication skills, persuasion skills, and much more. VIT Fashion Institute of Technology is one of the specialized offshoots offering fashion education, where technology is being used to create uniqueness in blending the tradition and the modern designs. The school aims to impart quality fashion education to nourish the young minds with knowledge of fashion and teach them the nuances in this profession. VIT Business School has emerged as a premier business school in India. The programs are designed to infuse strong industry-relevant business principles with deep insights, influencing practice, and actively collaborating with foreign universities and industry.
Joining the college as a fresher who knew nothing about tech. Now, I'm leaving the college as a third-year student with a 1 crore package. From start to finish, VIT helped me throughout the recruitment process with interviews and online assessments.
Spacious hostel rooms, multi-cuisine cafeteria, sports arena, state-of-the-art gymnasium, all affording an opportunity for holistic development of the student.
Come, be a pioneer of change. Be a part of something larger than life. Come to VIT.
Keynote Institute of Technology, a place to learn, a chance to grow.
The next newspaper, Shakkar Kama.
ಗಪ್ಪುತ್ತಾಂಗಲ್ಲ ಅಯ್ಯೋ ಗಪ್ಪುತ್ತಾಂಗಲ್ಲ ಹೀರೋಯಿನ್ ಫೋನ್ ತೊಲಂಗ ಹೆಡ್ಲೈನ್ ನ್ಯೂಸ ಅಯ್ಯೋ ಖಾಂಗಲ್ಲ ಗಪ್ಪುತ್ತಾಂಗಲ್ಲ ಬಂದ ರೇಟಿಂಗ್ ಪ್ರಿಂಟ್.
Valor International School, a holistic education hub designed to nurture a child's all-around development with a value-rich learning beyond academics. VIT's 3+ decades of magnificent contribution to education gives birth to Valor International School. VIS is empowered by the vision to nurture and promote unhindered knowledge seeking and make it a premier institution of the nation. VIS stands out with its holistic learning, wisdom, the student profile building program, and personalized house parenting for an extraordinary educational experience. VIS campus, immersed in natural light and surrounded by lush greenery, offers a strong connection with nature. The campus provides a serene and calm atmosphere for the young minds to flourish. The classrooms at VIS enrich experiential learning with innovative and immersive teaching techniques, where the curriculum is designed to create leaders of tomorrow. The library serves as a beacon of knowledge, a sanctuary for curious young minds, instilling a love for learning. Our labs are designed to ignite the innovative mindset in students, introducing them to a world of hands-on learning and a keen interest in science and technology. VIS residential blocks with a dedicated house parent ensure not just safety, but a nurturing environment where every need of the child is attended to at all times. VIS has a dynamic sports program to ensure students in a spirit of competition and team building, creating students ready to conquer challenges on and off the field. VIS is where safety meets nurturing care, ensuring your child takes the first step towards a life of accomplishments. Delore International School, right place to rise.
VIT Chennai is a globally engaged, competitive, comprehensive, research-enriched university campus strategically positioned to respond to major industrial, social, economic, and environmental demands and challenges. The campus has a cosmopolitan atmosphere with students from all corners of the globe.
The curriculum at VIT is designed to help students discover their strengths and enhance their academic performance. VIT focuses on improving the uniqueness of each student.
Whether you're a coder, creator, or change maker, this is your launchpad. VIT's Incubation Center transformed my idea into a real product and helped launch my startup journey.
The fully flexible credit system at VIT gives me the opportunity to learn at my own pace. I can choose my own subjects, my own schedule, and choose to learn with the professors who work the best with my learning ability.
VIT Flagship Engineering Institute has been consistently ranked among the best engineering institute of the nation, making it one of the most preferred engineering destinations for students of the nation.
Being part of the research community means continuous learning, experimentation, and the freedom to explore new ideas. VIT offers a wide array of schools and academic programs over various disciplines.
VIT School of Law is one of the leading law schools of the nation that is dedicated to honing and producing tomorrow's lawyers and law practitioners. The unique moot court concepts prepare today's aspiring lawyers for tomorrow's challenges. Simulated court cases are fought and debated as students develop gaining confidence, art of interrogation, communication skills, persuasion skills, and much more. VIT Fashion Institute of Technology is one of the specialized offshoots offering fashion education, where technology is being used to create uniqueness in blending the tradition and the modern designs. The school aims to impart quality fashion education to nourish the young minds with knowledge of fashion and teach them the nuances in this profession. VIT Business School has emerged as a premier business school in India. The programs are designed to infuse strong industry-relevant business principles with deep insights, influencing practice, and actively collaborating with foreign universities and industry.
Joining the college as a fresher who knew nothing about tech. Now, I'm leaving the college as a third-year student with a 1 crore package. From start to finish, VIT helped me throughout the recruitment process with interviews and online assessments.
Spacious hostel rooms, multi-cuisine cafeteria, sports arena, state-of-the-art gymnasium, all affording an opportunity for holistic development of the student.
Come, be a pioneer of change. Be a part of something larger than life. Come to VIT.
Window Institute of Technology, a place to learn, a chance to grow.
अनेक न्यूज़पेपर शक्कर कामा
ಗಪ್ಪುತ್ತಾಂಗಲ್ಲ ಅಯ್ಯೋ ಗಪ್ಪುತ್ತಾಂಗಲ್ಲ ಹೀರೋಯಿನ್ ಫೋನ್ ತೊಲಂಜ ಹೆಡ್ಲೈನ್ ನ್ಯೂಸ್ ಕಾಂಗಲ್ಲ ಗಪ್ಪುತ್ತಾಂಗಲ್ಲ வந்த
Or International School, a holistic education hub designed to nurture a child's all-around development with a value-rich learning beyond academics. VIT's 3+ decades of magnificent contribution to education gives birth to Valor International School. VIS is empowered by the vision to nurture and promote unhindered knowledge seeking and make it a premier institution of the nation. VIS stands out with its holistic learning, wisdom, the student profile building program, and personalized house parenting for an extraordinary educational experience. VIS campus, immersed in natural light and surrounded by lush greenery, offers a strong connection with nature. The campus provides a serene and calm atmosphere for the young minds to flourish. The classrooms at VIS enrich experiential learning with innovative and immersive teaching techniques, where the curriculum is designed to create leaders of tomorrow. The library serves as a beacon of knowledge, a sanctuary for curious young minds, instilling a love for learning. Our labs are designed to ignite the innovative mindset in students, introducing them to a world of hands-on learning and a keen interest in science and technology. VIS residential blocks with a dedicated house parent ensure not just safety, but a nurturing environment where every need of the child is attended to at all times. VIS has a dynamic sports program to ensure students in a spirit of competition and team building, creating students ready to conquer challenges on and off the field. VIS is where safety meets nurturing care, ensuring your child takes the first step towards a life of accomplishments. Velour International School. Right place to rise.
VIT Chennai is a globally engaged, competitive, comprehensive, research-enriched university campus strategically positioned to respond to major industrial, social, economic, and environmental demands and challenges. The campus has a cosmopolitan atmosphere with students from all corners of the globe.
The curriculum at VIT is designed to help students discover their strengths and enhance their academic performance. VIT focuses on improving the uniqueness of each student.
Whether you're a coder, creator, or change maker, this is your launchpad. VIT's Incubation Center transformed my idea into a real product and helped launch my startup journey.
The fully flexible credit system at VIT gives me the opportunity to learn at my own pace. I can choose my own subjects, my own schedule, and choose to learn with the professors who work the best with my learning ability.
VIT Flagship Engineering Institute has been consistently ranked among the best engineering institute of the nation, making it one of the most preferred engineering destinations for students of the nation.
Being part of the research community means continuous learning, experimentation, and the freedom to explore new ideas.
VIT offers a wide array of schools and academic programs over various disciplines.
VIT School of Law is one of the leading law schools of the nation that is dedicated to honing and producing tomorrow's lawyers and law practitioners. The unique moot court concepts prepare today's aspiring lawyers for tomorrow's challenges. Simulated court cases are fought and debated as students develop gaining confidence, art of interrogation, communication skills, persuasion skills, and much more. VIT Fashion Institute of Technology is one of the specialized offshoots offering fashion education, where technology is being used to create uniqueness in blending the tradition and the modern designs. The school aims to impart quality fashion education to nourish the young minds with knowledge of fashion and teach them the nuances in this profession. VIT Business School has emerged as a premier business school in India. The programs are designed to infuse strong industry-relevant business principles with deep insights, influencing practice, and actively collaborating with foreign universities and industry.
Joining the college as a fresher who knew nothing about tech. Now, I'm leaving the college as a third-year student with a 1 crore package. From start to finish, VIT helped me throughout the recruitment process with interviews and online assessments.
Spacious hostel rooms, multi-cuisine cafeteria, sports arena, state-of-the-art gymnasium, all affording an opportunity for holistic development of the student.
Come, be a pioneer of change. Be a part of something larger than life. Come to VIT.
Velour Institute of Technology, a place to learn, a chance to grow.
Gentlemen, it's such a pleasure on behalf of the Hindu and the VIT School of Law, VIT Chennai. I extend a very warm welcome to all of you to Justice Unplugged 2026 here in New Delhi. Ladies and gentlemen, following the success of its inaugural edition in Chennai, Justice Unplugged now convenes in the nation's constitutional and legal epicenter. This edition marks the evolution of the conclave into a truly national platform with deeper engagement, wider representation, and broader participation from aspiring lawyers, legal professionals, and leaders from across the legal fraternity. Conceived as a student benefit initiative, Justice Unplugged offers aspiring lawyers a rare opportunity to engage directly with judges, senior advocates, policymakers, scholars, and industry experts. The 2026 edition expands the scope of dialogue to address defining questions confronting the legal profession today, including the impact of generative AI on legal practice and the evolution of fundamental rights in the digital age, and of course, the pathways to improving access to justice. Ladies and gentlemen, we are honored to have some very eminent people in our midst, and I would request them to kindly join us on stage for the lighting of the lamp. Our chief guest for the function, Dr. Abhishek Manu Singhvi, Senior Advocate, Supreme Court of India, and Member Parliament, Rajya Sabha. Sir, it's an honor to have you here with us today, and I would request you to join us on stage. May I request Dr. G. Vishwanathan, founder and chancellor, Vellore Institute of Technology, to also come up on stage, along with Dr. G.V. Selvam, vice president, Vellore Institute of Technology. May I also request Mr. N. Ram, director, The Hindu Group, to join us on stage, along with Mr. Suresh Nambat, editor, The Hindu Group, and also Mr. L.V. Navneet, CEO of The Hindu Group, for the lighting of the lamp. May we have the lighting of the lamp done first, gentlemen. It's such an honor to have some very esteemed dignitaries here with us this morning. May we have the candles brought out for the lighting of the lamp, please? I'd request the operations team to ensure that we get the candles up on stage quickly, please. Thank you. gentlemen and friends from the media still waiting for their perfect shot. Thank you very much. And I'd request our esteemed dignitaries to please take their seats on stage, please. I'd request you all to please be seated. Sir, I'd request you to please be seated on stage, sir. Sir, we request you to please take your seat on stage. I'm sure you'll be able to hear them, sir. Otherwise, we'll point the speakers your way. Please, I request you to be on stage. Right, ladies and gentlemen, to begin proceedings, I'm going to request Mr. Suresh Nambat, editor of The Hindu, to deliver the welcome address before anything else. Sir, we request your presence at the podium.
Right. Hello, everyone, and welcome to the Hindus Law Conclave in partnership with VIT School of Law, VIT Chennai. I welcome our chief guest, Shri Abhishek Singhvi, Mr. G. Vishwanathan, and Selvam. I just want to start by saying that all societies, from those of ancient civilization to those of modern nation states, are built on the rule of law. Rulers have always sought legitimacy from the ruled, whether through gods and priests as intermediates or through the will of the people manifested in established conventions and written constitutions. In India, the constitution and not the parliament is supreme. Both represent the will of the people, but unlike the parliament, the constitution represents the voice of the people across generations. While the parliament is reconstituted periodically, the will of successive generations of Indians is baked into the constitution. True, India's constitution is a living document. Laws evolve according to changing needs and aspirations of the people, but they must still adhere to principles of equality and justice. The basic structure of the constitution is not to be trampled with. The Hindu is proud to partner with VIT School of Law in this law conclave, Justice Unplugged. Wishing all of us a day of insightful discussions. Thank you.
Well, thank you very much, Mr. Nambat, sir. At this point of time, I'm going to request Dr. G. Vishwanathan and Dr. G. V. Selvam to please present a memento and felicitate Mr. Nambat, who's here with us on stage. May we have the mementos brought out, please? I'm going to request this to be presented at the moment. Thank you so much, sir, for doing the honors. Thank you for your presence, Dr. Singhvi. We'll be hearing from you in a short while from now. To our friends from the media, we'll have more photo opportunities, requesting you to please hold back for a moment. Ladies and gentlemen, we'll now proceed with the presiding address by Dr. G. Vishwanathan, Founder Chancellor of Vellore Institute of Technology, VIT. Dr. Vishwanathan, of course, a visionary educationist, former member of parliament, and a social reformer as well. There's so much to say about you, sir. I'm sure time and words will fall short. So without further ado, I'm going to leave the dais for you to tell us more. Thank you.
Good morning. Our chief guest of today, member of Rajya Sabha and also senior advocate, Mr. Abhishek Manu Singhji, Mr. Ram from Hindu, Dr. Selvam, Vice President of VIT, the editor, Suresh Nambat, Mr. Navaneet, the Pro Chancellor of VIT, other officers from Hindu, professors, and my dear students. This is the first time the School of Law from VIT is arranging a conference along with Hindu. I would like to thank all the officers of Hindu for arranging this wonderful conference. And I am happy that Manu Singh accepted our invitation to be here. He's a very busy person and is going to address you. This is a very important subject. I don't know how many of you know I am a lawyer by profession, though I had practice only for 3 years. I completed my law in 1963. And in those days, there was apprentice period. I completed 1 year apprentice and enrolled in 1964. And only 3 years practice at the end of 66. Our late leader Anna called me and said, get ready for election. In 1967, I came to Lok Sabha to Delhi and I lost my profession. Of course, still I continue to be a lawyer without practicing, a non-practicing lawyer. This is a very important subject. Law is a very important subject. Not only I consider it as a profession, but also it's a service to society and the country because they protect the individual rights for poor and the weaker sections, and also they protect the constitution where there is an encroachment on the powers of different people. But the problem is our country, we are delaying cases. The highest number, the largest number of pending cases in the whole world is in India. Based on the judicial performance indicators, particularly from European Commission for the efficiency of justice, reports and also World Bank studies, the countries are having efficient and judicial system. For the fastest case was in the northern part of Europe. And of course, one from Singapore, the other Denmark, Norway, Finland, Netherlands, Germany, etc. For Europeans, they take about 230 days for a disposal of a case at the lower level. Normally, we take 2 to 3 years. In January 2026, the total number of pending cases at all levels in India is 5.4 crores. In 2018, I remember it was 2.9 crores. Now we have grown and ours is 5.4 crores. This cannot go on happening in the independent country. We should do something and we go for judicial reforms and other things also. And the Rule of Law Index, I don't know how many of you are aware of this. Rule of Law Index 2025, published by the World Justice Project, ranked India at 114 out of 143 countries in the civil justice and 89 out of 143 in the criminal justice. Mainly because we have lack of judges, lack of courts, and the appointment also gets delayed, and always there is vacancy in the post of the judges post. The vacant judicial position in 1922, there were 14 judges per million. In 1922, there were 14 judges per million population in India, compared to 150 judges in US and 210 judges in Europe. That's how we are lagging behind in the number of courts and judges also. And it affects the public, particularly in the criminal cases. Civil cases is pending for years together. Like that, criminal case are also pending. And now we have about 5.5 lakh prisoners all over the country in jail. And out of them, under trial prisoners means that they have not gone under, they have not been punished. They are more than 4 lakhs. And I'm sorry to say that the policeman becomes the judge when he charges and send him to jail. He remains there without trial. And it may take years for him to come out or either be punished or released from him. And this also goes year after year. The number of people in the prison, it was about 3.56 lakhs in long back. Now it is going up. And among those who are under trial prisoners, there are about 10,000 of them who are more than 5 years in prison without being tried in any case. And so we require prison reforms as well as judicial reforms so that the poor will get justice as early as possible. And especially in a federal system, the courts are very, very important. Judiciary is very, very important because judiciary acts as an independent arbiter and guardian of the Constitution, maintaining the balance of power between the central government and the state governments. The judiciary acts as the final interpreter of the Constitution, ensuring that the legislative and executive branches do not encroach upon the power assigned to different levels of government. Within the state, when there is difference of opinion between the governor and the state government, always the people suffer. For example, in India, in a number of states, the appointments of vice chancellors has not been done. In our own state, out of 22 state government universities, 16 universities do not have vice chancellors. I want something to be done. It should be done either by the President of India or by the Supreme Court, so that the education should not suffer, students should not suffer. See, this country is a federal country, country of diversity, and this country is the only one which has more than 2,500 political parties. We cannot do anything about it, but it should not affect administration, particularly education. And I request our chief guest to do something so that the students will not suffer. For example, the oldest university, we have only 3 universities in India: Madras, Bombay, and Calcutta. University of Madras does not have a vice chancellor for the last 3 years. So it will go against the quality of education and against the students. And I want something to be done to improve these things. And when we establish the law school, in fact, you know, Vellore is known for engineering and technology. And I thought that we should have a law school, and we established in 2014. We envisioned a law school that balances excellence with ethics, knowledge with responsibility, and ambition with service. And as I look at our students, who are about 1,200 students and about 50 faculty members, I see that the vision is taking shape. I congratulate all the students and professors, and I thank other students who are attending this conference. Once again, I thank our chief guest for having accepted the invitation to be here this morning. Thank you very much.
Thank you, sir, for the presiding address. At this point of time, I'm going to request Mr. Suresh Nambar, the editor, The Hindu, to kindly please present a small token of our appreciation to Dr. G. Vishwanathan, please. A small memento from the side of The Hindu to be presented to Dr. G. Vishwanathan, please. Sir, requesting you to accept this small token from our side. Ahmad sir, kindly face the cameras. Thank you. Thank you, sir. Ladies and gentlemen, we now proceed to the inaugural address by our chief guest for the function today. And before I invite him on to the dais to speak, a quick announcement for everyone. A lot of aspiring lawyers, a lot of people interested who've come in here to hear this eminent jurist speak. Ladies and gentlemen, my humble request to you is after his speech, he's agreed and said, all right, he will be fielding a question and answer. He'll be fielding a question and answer session. So he'll be fielding your questions. My request to you beforehand, why I'm letting you know this before he speaks, is that you get some time to think about what you want to ask about. Remember, this is a public forum, so a quick disclaimer. Make sure that your questions are appropriate given the public forum that we are in, number one. Number two, keep it as non-aligned as possible is my humble request to all, some inspired minds who are present here. Ladies and gentlemen, the man here with us, of course, Senior Advocate, Supreme Court of India, Member Parliament, Rajya Sabha into his fourth term, eminent jurist, and of course, served as a former Additional Solicitor General of India and former Chair of the Parliamentary Standing Committees on Commerce, Law and Home. In case I've forgotten a few, kindly do excuse me. He's widely regarded as one of India's leading senior counsels, having been the youngest designated senior advocate in India at the age of just 34 and the youngest Additional Solicitor General at 37. Educated at St. Columba's School, St. Stephen's College, and Trinity College, Cambridge, where he completed his law degree and PhD with the summer program at Harvard University. Ladies and gentlemen, also an author and a respected public commentator on constitutional and public affairs. I needn't have said so much. The name itself is more than enough. Dr. Abhishek Manu Singhvi, sir. It's an honor to have you here with us and an honor to hear you speak.
The Chancellor, Mr. Vishwanathan, my good friend Mr. Ram, the editor, the CEO, the other distinguished persons on the dais, members of this august distinguished audience, above all, students, faculty members, ladies and gentlemen. Thank you for a very generous and possibly partially undeserved introduction. I find that the topic today is a general one. It is supposed to be inspiring, a little rhetorical, a little uplifting, but doesn't deal with the nitty-gritties of law, which the Chancellor has raised in his speech. So I think a good via media is found by a proposed Q&A at the end of the thematic lecture, where some of these more nitty-gritty problems can be discussed. Friends, my first dilemma is that those who have formulated the theme for this inaugural, which is, as you can see, law, leadership, and nation building, the responsibility of young lawyers. Those who formulated this theme necessarily want me to be sermonizing to young lawyers. Personally, I hate the didactic approach, but willy-nilly will have to do some of it today. I have actually for long believed that youngsters are getting smarter and smarter and not in need of any didactic sermonizing. And indeed, when I sit on some interview boards, I've sat on many earlier, I increasingly get the feeling that the interviewee is far ahead of the interviewer. Of course, we then tend to take refuge in the deeming fiction that our experience trumps everything else. Friends, especially young friends, law is not a profession that merely fills files. It is a profession that fills history. It is not simply a system for resolving disputes. It is the grammar through which power is disciplined and justice is articulated. Every nation is ultimately governed not only by those who hold office, but by those who interpret, defend, and refine its laws. If politics is the visible architecture of the country, then law is its invisible foundation. And foundations, as we all know, though unseen, determine whether the structure will endure storms or collapse under pressure. When we examine the arc of history, we find that transformative moments are often midwifed by lawyers. In the United States, the landmark case of Brown v. Board, Brown versus Board of Education, it did more than merely strike down segregated schooling. It actually altered the moral compass of a whole society. In Brown v. Board, equality, the concept of equality, moved from parchment to playground. That litigation, crafted with patience and intellectual precision, told a divided nation that constitutional equality cannot coexist with systematic humiliation. In India, our very own Keshavananda Bharati did something equally extraordinary. It declared that even a sovereign parliament cannot destroy the basic structure. Even, in other words, even a constitutional amendment can be declared unconstitutional. That one-line doctrine, born of argument, scholarship, courage, ensured that democracy in India can virtually never be hostage to transient majorities. Those cases remind us that the law, when guided by principle, becomes an instrument of social transformation and not merely one of dispute resolution. India's own freedom struggle offers several compelling testimonies to the nation-building power of lawyers, which is part of the main theme today. Mahatma Gandhi was trained in law. His method of satyagrah was at its core a moral argument framed in legal consciousness. Gandhi turned courtroom ethic into a mass moral movement. Nehru brought to politics the analytical discipline of the bar. Ambedkar, one of our most formidable legal minds and founding fathers, converted centuries of social exclusion into constitutional guarantees of equality and liberty. He converted suffering into structure and injustice into institutional reform. The Sardar Vallabhbhai Patel, before he unfurled and united the princely states, was a barrister whose courtroom discipline shaped his administrative decisiveness. These were not men or persons who abandoned the law for leadership. They expanded law into leadership. And even in independent India, young lawyers have risen not merely to prominence, but to transformative influence. Law does not whisper, friends, from dusty volumes. It thunders through the ages. Law remembers, leadership imagines, and nation building requires both. There are a lot of examples of lawyers who have successfully leveraged their courtroom acumen into legislative and ministerial leadership, shaping significant national policy. That must always remind us that the courtroom is indeed the rehearsal space for national leadership. Consider then Maneka Gandhi's case, where constitutional advocacy expanded Article 21, the right to life article, into a charter of at least procedural due process. That judgment did not merely protect the passport holder involved, it infused Indian constitutionalism with the idea that the procedure must, externally judged, be just, fair, and reasonable. A single case widened the moral horizon of liberty. Maneka taught us that procedure without fairness is power without legitimacy. Similarly, the global dismantling of apartheid was shaped not only by political agitation, but by the legal training of persons like Mandela, who understood that the courtroom and the constitution could become theaters of resistance. Mandela proved that even a prisoner trained in law, as he was, could cross examine an empire. Incidentally, let me digress for some of the law students. This is a bit of a digression on substantive law. But this Maneka issue and this, it tells you how law is a vibrant, pulsating, non-static concept. It's forever changing. And if you look at our most important article in our constitution, possibly not 21 but 14, but at least both of them are the two most important, you will find how vibrant, dynamic, and ever evolving law and jurisprudence can be. 14, prior to a judgment which had some Tamil Nadu connections called Royappa. Prior to that date in the 60s, in the 70s, I'm sorry, Royappa Article 14 was largely on equality, on the doctrine of classification, that you will not be able to treat equals unequally or unequals equally unless you provide a valid classification and unless that classification is tested to find that it has a reasonable nexus to a larger object sought to be achieved. So it was the equality clause from independence till the late 60s and 70s. Royappa changed that by including a new facet in 14, in the same dead letter of 14, the anti-arbitrariness aspect, which Justice Bhagwati immeasurably expanded through cases and judgments like Ajay Hasya, Ramanna Shetty, and a host of other cases. So by the time we reached Maneka and beyond, we were already having anti-arbitrariness as a full-blooded facet of Article 14, which had only been dealing with equality doctrine prior to Royappa. Post Maneka, we got a third facet added into the same dead letter of the same language of the same article. That was procedural due process, which I've just spoken about. How the procedure to deny or grant the passport to Maneka Gandhi had to be not merely a procedure prescribed, which it was, but the procedure should be liable to be judged independently, to be fair, just, and reasonable, which is nothing but due process. But it was couched, still disguised for a reason, as procedural due process. Actually, it was full-blown due process. Finally, that fig leaf of a camouflage was shed when the fourth facet of Article 14, the same Article 14, unamended, same language, included full-blown substantive due process in the various cases authored by Justice Nariman, Shaira Bano, Triple Talaq, adultery, Joseph Shine, Swiss ribbons, and so on and so forth. Of course, the reason we kept hesitating, law develops incrementally. It develops slowly, but surely. The reason we rightly did it incrementally was because we didn't want both Justice Frankfurter and Mr. B.N. Rao to start turning over in their graves or in their celestial silences too early. Because you know that when B.N. Rao went to America, he was told by a much harassed Justice Frankfurter that whatever else you do in the Indian Constitution, don't include that bloody phrase called due process. Otherwise, due process would have been a phrase in our Constitution as it was born in 1950. So B.N. Rao took his advice. He said gives too much of uncanalized, wide, arbitrary power to judges and deleted that original proposal. And we plucked up the current language of Article 21 from a clause in the Japanese constitution, except in accordance with procedure with law. So, due process was struggling to be born. It was born in Maneka in the late 70s, but still couched as procedural due process, and it has now become full substantive due process, whether both Frankfurter and Mr. B. N. Rao like it from their respective places of silence or not. Friends, young lawyers must therefore see themselves not as technicians, but as trustees. The Constitution does not defend itself. It relies on disciplined minds and courageous voices. When we reflect upon dark chapters, such as, for example, ADM Jabalpur, we are reminded that institutions, including courts, can falter, but courage must outlive error. The eventual judicial acknowledgement of that error demonstrates something equally powerful, that constitutional systems possess the capacity for self-correction when conscience reawakens. The lesson is not to romanticize fallibility, but to recognize that vigilance is generational. Each cohort of lawyers inherits both the triumphs and the mistakes of its predecessors. Friends, leadership in law is not measured by decibel levels or media presence. It is measured by depth, by discipline, and by durability. The finest advocates prepare in silence. They read comparative jurisprudence, they study history, they anticipate counter arguments, they refine their reasoning unless it becomes near unassailable. Scholarship is not ornamental, it is strategic. In Roe versus Wade, the abortion case, and the later constitutional debates in the US, we saw how deeply researched arguments can shape and sometimes reshape social consensus. Whether one agrees with particular outcomes, the enduring lesson is that the law evolves through sustained intellectual engagement, not impulsive rhetoric. Let us go a step further. The measure of a legal system is not how it treats the powerful when they are secure, but how it treats the vulnerable when they are exposed. Law at its noblest is a shield for those without a voice. Around the world, transformative change has often begun with young lawyers young lawyers like yourselves, who refuse to accept inherited injustice as a permanent reality. In India, public interest litigation expanded access to justice. It brought bonded laborers, under trial prisoners, environmental degradation, gender discrimination, and so on under judicial scrutiny. That movement was not driven by corporate incentives. It was driven by moral imagination and reimagination. Leadership in law also requires the courage to dissent. The finest constitutional systems mature through principled disagreement. Judges, advocates, and scholars engage in a continuous dialogue about liberty, about equality, governance. In that dialogue, your role as young lawyers is to elevate the quality of argument. Because democracies decline when debate declines. Democracies strengthen when disagreement remains reasoned, respectful, and rooted in constitutional fidelity. Remember that character precedes charisma, though charisma frequently overpowers everything else. Discipline precedes distinction. The habits you cultivate now, meticulous reading, punctual preparation, ethical clarity, will determine whether you merely practice law or personify it. In every generation, a handful of young lawyers rise beyond briefs to become builders of institutions. There is no secret formula. There is only sustained effort, intellectual honesty, and moral steadiness. And also remember the principle that there are many substitutes or maybe substitutes for Harvard, but there is no substitute for hard work. Scholarship is slow fire. It does not dazzle, it endures. The law is a demanding master, but a generous teacher, apart from being a very jealous and a zealous mistress. If you serve it with integrity, it will grant you not only success, but significance. And in the long march or the arc of a nation's history, significance always outlasts success. Ambition is natural in youth, and there is nothing ignoble about striving for success. But ambition without anchor becomes opportunism. The great lawyers remembered by history are not those who merely accumulated victories or notches. They are those who embodied values. Nani Palkivava is remembered not simply for his forensic brilliance in constitutional courts, but for his unwavering commitment to constitutional limits and to constitutional fidelities. Thurgood Marshall in US is remembered not only as a judge, but as the advocate who patiently and meticulously dismantled segregation brick by brick by brick before ascending to the bench. Marshall argued not for applause, but for access. Their reputations endure because they aligned professional excellence with moral clarity. Ambition does build careers, but integrity builds civilizations. The responsibility of young lawyers today extends beyond litigation. There's a whole wide, big world there which was not there when your chancellor did his law in 63, or indeed when I did my law in the early 80s. Regulatory reform, legislative drafting, arbitration, technology governance, environmental protection, human rights advocacy, apart from fancy things like sports law, space law, entertainment law, and so on, are all domains where legal expertise shapes the destiny of millions. The digital age represents new frontiers. Data privacy, artificial intelligence, cyber sovereignty. In all these and more, the legal mind must balance innovation with liberty. Nation building in the 21st century will not occur merely in supposedly dramatic constitutional showdowns. It will occur in the careful crafting of frameworks that reconcile growth with justice. Let me also add, democracies rarely collapse in a single dramatic moment. It's not like a collapse of an earthquake, the house comes crashing down. They erode gradually. Democracies erode gradually through normalized excess, when excess becomes the new normal, through institutional fatigue, through the slow corrosion of standards. It is the lawyer's duty to recognize those early fissures. Constitutional morality, as Ambedkar told us, is not a natural sentiment. That's in the debates. He said it must be cultivated. You cultivate it through discipline in argument, civility in disagreement, and courage in adversity. The courtroom is not a battlefield of egos. It is a sanctuary of reason. To enter it either unprepared, of course, is disrespectful, but to enter it without integrity is downright dangerous. Let me also speak to you about something that is rarely discussed in law schools, but in a way is central to leadership, which is another part of the facet of this theme today, and that is loneliness. Leadership in law is often lonely, frequently lonely. There will be moments when the easier argument is more popular, when the louder side commands applause, when compromise seems convenient. Yet history respects those who stood firm when standing firm was uncomfortable. When Keshwananda was argued, there was no certainty that the doctrine of basic structure would emerge victorious. It required sustained courage from both the bench and the bar. Transformative outcomes are rarely guaranteed. They are those which are pursued despite uncertainty. And a lawyer's silence in the face of excess is, according to me, complicity dressed as caution. The relationship between law and leadership is also a relationship between memory and imagination. Law remembers, it records precedents, it preserves institutional wisdom, it ensures continuity. Leadership, on the other hand, imagines, it anticipates change, it responds to new realities, it adapts structures to contemporary needs, and a great or a good lawyer must do both. When technological revolutions disrupt privacy, when artificial intelligence challenges accountability, when environmental crises strain regulatory frameworks, the lawyer must combine constitutional memory with creative foresight. The Constitution is not a museum artifact. It is a living, pulsating compass. Consider how constitutional courts across the world have navigated tensions between liberty and security. After moments of national trauma, governments often expand executive authority. It is during such times that the bar's role becomes most critical. In the United Kingdom, debates following terror attacks tested the balance between surveillance and civil rights. In the United States, cases arising post 9/11 detention forced courts to confront executive overreach. In India, constitutional jurisprudence has repeatedly grappled with preventive detention, free speech inroads, and national security issues. These are not abstract contests. They shape the moral climate of a republic. Young lawyers must understand that defending liberty in difficult times is not fashionable but foundational. Today, Liversidge and Anderson, right bang in the middle of the Second World War, a judgment of the House of Lords, is remembered only for the dissent of Lord Acton, where he had that famous phrase, amidst the clash of arms, the law is not silent. Nobody remembers the majority. Just like H.R. Khanna adorns our courtroom, but nobody remembers the majority in ADM Jabalpur. Power seeks expansion. Law insists on explanation. Where politics builds walls, law is supposed to carve out windows. A transient majority can amend a clause. It cannot amputate a conscience. That's what lawyers have to remember, practice, and vivify. Let me add, and this is particularly apposite, maybe in contemporary times. Let me add that the fear of consequences are often ghosts of the mind. And the moment truly independent judges and fearless lawyers call the bluff of that mental misgiving, they will usually find that it dissolves into nothingness. There is not much which the powers that be can do to such constitutionally protected judges and independent lawyers. For sure, they can ensure that your several ambitions are not fructified, but they cannot take away either your soul or your conscience. Ultimately, when history judges such lawyers and judges, it normally gets its verdict right. The loaves and fishes of high office and of high posts are discounted by history. And it elevates only those to a pedestal who have followed the call of their soul and the voice of their conscience. The Constitution is not self-executing. It breathes through brave lawyers. Where fear expands, let reason respond. Where rights shrink, let arguments rise. No discussion of nation building can be complete without economic nation building. Law is the bloodstream of markets also. Contracts, arbitrations, frameworks, insolvency codes, corporate governance norms. These are not dry commercial mechanisms. They are the basic infrastructure of trust. When India undertook economic reforms in 91, it was not only an economic shift, but a very major legal recalibration. Regulatory institutions were strengthened, new frameworks were drafted, and global integration required sophisticated legal architecture. The young lawyer who masters commercial law is not merely drafting agreements. He or she is contributing to national competitiveness and investor confidence. Economic justice and economic growth are both mediated through law. A nation's true wealth is not in its treasury, but also in its jurisprudence. Leadership in the legal profession also demands intergenerational responsibility. You are beneficiaries of institutional capital built by those before you, judges who preceded you, who defended independence, advocates who protected fairness, scholars who enriched jurisprudence. Thank you. I'll take it. This is fine. This is fine. Your conduct, friends, will determine whether future generations inherit stronger institutions or weaker ones. Professional civility is not cosmetic, it is constitutional. When lawyers reduce discourse to personal attacks, they erode the dignity of courts. When they elevate arguments to scholarship, they enhance the credibility of justice. There is another dimension, ethical restraint. The power of advocacy is immense. A skilled lawyer can influence outcomes. He can shape narratives, can tilt perception. With that power must come the power of natural restraint. The temptation to weaponize procedure, to delay strategically without justification, which is always there for one side or the other in a case, to prioritize spectacle over substance. These are your professional crossroads of your conscience. Each decision either strengthens institutional faith or chips away at it. The true test of leadership is what you do when no one is watching, when integrity is invisible, but very, very indispensable. Let me also draw your attention to constitutional backsliding phenomena. Around the world, we have seen democracies strained by polarization, by misinformation, and by erosion of institutional norms. Rarely do these crises begin with tanks on the streets. They begin with subtle distortions. By normalizing exceptional powers, by questioning judicial legitimacy, by weakening checks and balances. In all of this, the lawyer's vigilance is society's early warning system. A vigilant bar is the first line of constitutional defense. Young Indian lawyers have also demonstrated how professional excellence can merge with public service. Some have moved from courtrooms to commissions, from advocacy to academia, from litigation to legislative drafting. They have shaped environmental jurisprudence, gender rights discourse, technology regulation, and human rights protection. They're not lawyers in the strict sense. They're doing these things, which are close cousins, but closely interconnected with law. Their journeys illustrate that leadership is not confined to one arena. It is a continuum. What unites them is not uniform ideology, but unwavering engagement with institutional development. You must also, young friends, cultivate intellectual humility. The law is vast, and no one masters it entirely. The greatest advocates continue to learn. They continue to have the curiosity of a child. They revisit precedent, they re-examine assumptions, and they refine arguments. In an age of instant opinion, instant coffee everywhere on media and elsewhere, depth becomes either a casualty or revolutionary. Reading widely constitutional history, comparative law, political philosophy, economics, all of this shapes leadership, which demands context. Context transforms argument from mechanical citation to persuasive narrative. And let me emphasize, dissent is never disloyalty. Within the bounds of constitutionalism, dissent enriches democracy. The lawyer who challenges legislation through constitutional scrutiny is not undermining parliament. He or she is actually participating in a constitutional dialogue envisioned by the framers as the bedrock of our system. The tension between institutions, the word tension can be very positive. The tension between institutions, when conducted respectfully, is not a weakness, it's a strength. It ensures equilibrium between all the different organs of state. A cozy, comfort, non-tension situation doesn't ensure that. Finally, remember that the law is ultimately about people. Behind every constitutional principle stands a human story. A prisoner seeking bail, a worker seeking wages, a woman seeking equality, a citizen seeking dignity. Leadership in law is not abstract. It is profoundly human. It's not an ivory tower profession. When you argue a matter, you carry not just legal propositions, but lived realities. If you can combine technical mastery with empathy, you will not only persuade courts, but you will also elevate justice. The republic we inhabit, friends, is dynamic, diverse, and demanding. It requires lawyers who are intellectually fearless, ethically grounded, and institutionally loyal. If you commit yourself to discipline, to scholarship, to the courage of your convictions, you will discover that law offers not merely a career, but a calling. And when the story of this generation is written, may it be said that its young lawyers did not succeed merely. They strengthened the nation they served. In the end, your legacy will not be measured by the number of reported judgments bearing your name. It will be measured by whether institutions were stronger because of your actions and your service to them and to causes. Did you elevate the discourse? Did you protect the vulnerable? Did you resist expediency when principle demanded patience? Did you see law merely as a ladder for personal ascent or as a bridge for collective progress? Friends, despite being the world's largest democracy and a proud one at that, India does remain an unfinished republic. It's a constitutional experiment, constantly and always in motion. Each generation writes new footnotes to that founding document made by our founding fathers. You, the young lawyers of today, will write many of those footnotes. The river of law flows continuously. It reflects the sky of its times, but it also shapes the land through which it is flowing. You are not mere observers of that river. You are its future navigators, its custodians, and when necessary, its reformers. Friends, if you combine scholarship with service, ambition with integrity, and courage with humility, you will discover that law is not merely a profession you practice. It is a nation which you help build. And when your generation is judged, it should be said they did not merely practice law, they practiced courage. Thank you very much.
Ladies and gentlemen, that applause could carry on for a little longer. And we made a promise before Dr. Singhvi started speaking that we will open the house to one and all for questions. So we do that now. Kindly do raise your hand and we'll have a microphone sent out to you. And we'll have a hand microphone brought out for Sir. That's sweet.
Good afternoon.
We've got quite a few hands that went up. There's one right there.
Good
Yes,
afternoon,
please.
sir. them introduce themselves.
Could you please introduce yourself before you ask your question? Thank
Good
you.
afternoon, sir. My name is Ashish Raj, and having 8 months of experience of practice.
Can you be a little louder, please?
Having 8 months of experience of practicing before Delhi High Court, I have noticed that when the clock hits 5 p.m., the court leaves without completing the cause list. Now, as sir, you have mentioned Article 21, and sir, I mentioned 5.5 crore cases being pending. My question is, isn't current 10 to 5 schedule a direct violation of fundamental right to a speedy trial for a common man?
You must. Yeah, you must speak close to the mic because I missed some part of your question. But
My
what I
apologies.
understand is, why do judges leave at 5 o'clock without finishing their cause list?
Yes, sir.
Now, that's truly a very nitty-gritty question after all the heights we have been flowing for the last 1 hour. But my favorite topic for the last 25 years is the topic on which your chancellor spoke.
Yes, sir.
Reforms in the administration of justice, the battle of the bulge, the scourge of arrears. But that is a separate topic. Maybe there'll be some question on it. Having said that we have huge areas, you must also remember that judges in India work harder than possibly any of their counterparts anywhere on planet Earth. As a generic, I mean, individual judge may not work hard here, individual judge may work hard in the USA, but as a collectivity, no breed of judges in any part of planet Earth works harder than India. So you should not grudge them. By the way, the court time in most places is 4:15 or 4:30. And some places it's 4:30 actually. In our country, in Delhi, it's 4:30. So 5 o'clock is already in excess. There is no point in continuing till you finish every matter because they're not finishable. Every member of the bar understands immediately when a judge is doing his best, when he's working hard, versus where and when a judge is a shirker. So the bar is the best judge of such judges. So I don't think you should you should grudge them that part of it at all. And by the way, with all our areas, what we decide in, well, if you include both the miscellaneous cases and the final, what we decide in 1 week in the Supreme Court, a US Supreme Court decides half of that in a year. Yes.
Hello, sir. This is Nikita. Loud whatever you said, and that has actually inspired me to ask this question. That recently CJI had showed concern about the Class 8 book, where it has been given that how corruption exists even in judiciary, and has appealed to remove that part, saying it lowers authority of court and it weakens the trust of the people. But my question is, in 2025, we have seen one of the judge from Delhi High Court, and my simple question is that how do you see it? I mean,
Yes. Well, first of all, the disclaimer I always make is when I've appeared in a case, please take anything and everything I say with a bucket full of salt. So I am one of the counsel in this case, both the days I appear in this case, this NCRT case you're talking about. Secondly, I think it is being misunderstood as to what the reaction or anger was about. There can be no two views about the fact that there are black sheep in the judiciary as there are in every other sector, and that the C word is a very major issue. After arrears, it is probably the second major issue in the judiciary. That was not the issue at all. There were two issues, and one of them I articulated very openly. Many of the newspapers, including the Hindu, in fact, did a whole side part on that aspect. And that is the selectivity of this 2-page chapter. It suddenly, out of the blue, for Class 8 students, plucks out for the first time 2 pages on judiciary, doesn't seek to deal institutionally with corruption, doesn't seek to deal institutionally with corruption, which is rampant in the bureaucracy, in the political class, in politicians, in so many other sectors of our system, and plucks out and places it out of context as if it is targeting one. That is a matter of concern. Second was the fact that and this is still under investigation, so I won't want to go into the details, that possibly this was introduced in the minutes of meetings, suddenly out of the blue without careful scrutiny from the top, in which case it could possibly be the agenda. This is still out for the jury to decide. It could possibly be the agenda of some people to weaken, threaten, intimidate, control, or overawe the judiciary. The second one is still undergoing some file checking. They're going to produce the files next time. But certainly the selectivity is inexcusable. And if you tell class 8 students across the country repeatedly that this one sector on this table on the left side is got a corruption problem, but none of these sectors here you talk about, by the time they reach 8, 9, and 10, they're going to get this is not you and me, it's class 8. They're going to get a somewhat distorted and warped view of how ultimately the organ, and by the way, there's a third facet, ultimately the organ which has defended liberty, private rights, stood as a bulwark against government excesses, that part is not mentioned anywhere. So it's an incomplete, inchoate, and possibly targeted insertion.
Also, sir, I have second question if I can ask.
There are multiple people who would like to ask questions, ma'am. So I think we just in the order of being fair to the others, we'd like to pass that microphone on to some of the others. We've got one right here. Thank you so much.
Good afternoon, sir. Thank you for the opportunity. I am Asram Shimunu from VIT School of Law, 4th year. So, sir, my question is, what is your opinion on the usage of AI in legal education, and how does the modern approach to legal education has differed from the traditional approach in which you were trained, sir?
Oh, it's a sea of difference. You know, probably 33% of what you can or are being taught in schools were not available to us. We had not heard of cyber law, AI law, sports law, entertainment law, a whole range of technology law. In fact, because of my exertions, now you teach as a taught subject reforms in the administration of justice, which was not taught in those days. So you can take it that there's a sea change in the menu card available for people like you compared to people like me or your chancellor. Many of these options were just not there. They were the traditional hardcore subjects of contract, constitutional law, etc., etc. Secondly, AI has come to stay. I mean, I don't think there is any if question left about AI. It is a very simple answer as far as AI is concerned. It's a very valuable, indeed a remarkable tool. Just like nuclear power, it has to be used constructively, positively, but always as a slave, never as a master. As long as you are the boss and that remains a slave, it's of great utility. I don't think you can undermine the utility merely because if you let it go haywire, it becomes the master. Well, that's your fault. It's you who have to be always in the saddle. The best horses are unruly, but they need competent, talented riders.
Thank you, sir.
Right, we've got more questions coming through, I believe. Just one sec. Yes, we've got one from that side.
Hello. Hello, Mr. Singhvi. Namaste.
Can you hold that mic up a little, please? Thank you.
Hello, Mr. Singhvi. Namaste. Namaskaram. I am Manmohan Singh. I am from Mathura. Actually, my question is very relevant to the tackling of judicial corruption or teaching and increasing cases in High Court and due process of law. Actually, I am from a family of rape victim of a minor girl, and I am just going through this case. So I want to ask you very live experience of mine. Actually, we are following the process. We are normal people. I never entered the court before that in my life. But I see that मतलब जैसे मतलब हम गए, हमने अपनी पूरा प्रोसेस किया, लेकिन उसमें ये जो केस है 72 BNS 351 356 पोस्को 5G, दे आर 5 एक्यूज्ड इन दिस केस. लेकिन जैसे ही हमने पूरा प्रोसेस किया, सारी चीजें की, तो उसमें क्या है कि हमारा जो ड्यू प्रोसेस है, जैसे हमारा डिफेंस है, उसको वहां पर मतलब सुना ही नहीं जा रहा है. उस
देखिए इस कमरे में सभी लोग जो बैठे हैं वो आपसे सहानुभूति करेंगे। आप
नहीं
एक
नहीं सहानुभूति
आप एक पीड़ित व्यक्ति हैं,
जी सर,
लेकिन इस प्रकार
अपनी
के
बात शायद मैं
प्रश्न
कह
का
नहीं पा रहा हूँ, लेकिन आप
इस प्रकार के प्रश्न का ऐसी गैदरिंग में उत्तर नहीं दिया जा सकता। इस देश में बहुत बड़ी प्रॉब्लम है नंबर्स की, विलंब की।
नहीं नहीं ऐसा मेरा क्वेश्चन सर ये है, अब मैं आपको थोड़ा टोकना चाहूंगा, आई एम सॉरी, कि ऐसा है कि हाईकोर्ट में जैसे केस बढ़ रहे हैं, हमने पूरा डिफेंस किया लेकिन प्रोसेस को फॉलो नहीं किया जा रहा, हमें नोटिस सर्व नहीं किया गया है, और ये पूरा मतलब नेक्सस की तरह काम हो रहा है।
इंडिविजुअल
तो
केस
इस
को
चीज को
डिस्कस
आप
नहीं
कह रहे हैं
करते
कि
हैं।
डिबेट मतलब इस चीज को डिस्कस न करें।
माय डियर फ्रेंड,
नहीं नहीं दिस इज
दो सवाल यहाँ पे मैं आपके सामने रखना चाहूंगा, वो ये है, सहानुभूति हम सबकी आपके साथ है, लेकिन सवाल ये है कि एक पब्लिक फोरम में ना आपके जो केस की डिटेल्स हैं जी, I think we will have probably have this, we can have a discussion on this offline. We have another question, please.
Good afternoon to everybody. Sir, today is a National Science Day. It's a very important day. I am Ramesh Kumar. I am a science communicator working with the science communication and for the common man. My question is there any specific role of science and technology in today's legal framework? My second important question, even to Dr. Vishwanathan as well, because he is leading a great institution, VIT. Is there any framework for the GM issue, genetically modified issues, which a law can play an important role? This is my question.
So, very briefly and pointedly, of course, science and technology are now permeating every part of our legal profession, of legal academia. Science and technology, in fact, may be too generic and too broad a theme which you have formulated. Subparts, subspecializations within that larger rubric are now being taught very specifically, and that's a very good thing. The interface between how ultimately all science and technology major issues have to be controlled by regulatory legal frameworks. So wherever you see all these law being taught, cyber, this is all Data Protection Act. These are all methods of controlling or regulating or providing the effects and consequences of science and technology in a manner that they are not deleterious to society. So this, your first part is, it's just everywhere. And much less of it was there in my time or his time. Your second part is surprising you're asking that, because genetically modified crops or genetically modified varieties have been part of jurisprudence for over 20 years. I have done most of the leading cases in them. I've been appearing for that company's name, I forget, the first fellow who came here. In many cases, from Supreme Court to Nagpur to, so some they have already introduced some crops, some are under introduction. There is a whole committee for it. So, and that goes through 5 or 6 processes and then comes to courts. And there are a number of PILs. So there again, GM is both a scientific, technical concept, but is heavily regulated in law, both by the statute, but after you cleared all the hurdles by PILs. So it goes through an additional judicial scrutiny through PILs. And I've done many of the cases myself.
Interesting insight. Another
Yeah.
Over the word, he's right.
A very good afternoon to you, sir. I'm Professor Dr. Shuchi Mehra, the head of the Department of Management Studies at Chandigarh Group of Colleges, CGC University now. Just out of curiosity, I'd like to know, like when the matter is listed in the court and it goes to the judge, I think with all their experience and every day they go through all these cases, they get to know what will be the decision and the result of that particular matter. Then why all these matters, like they have been, the decision has always been delayed, and both the parties have been given the long dates and it has been prolonged.
You see, your question is narrow. I'm not really responding to your very narrow question, but it really touches upon the larger issue of delay, which the Chancellor talked about. So let me spend a couple of minutes. It's a very, it is a theme long enough for a seminar or a whole day lecture. One can speak about it, so we don't have time to discuss it like that. But let me give you very quickly a few facets. Our country has the most avant-garde, progressive, greatest inventions of law. Nobody has PIL, nobody has basic structure. We are considered the inventors of such major doctrines, and other countries have followed us. We also have the best and the brightest in law, both on this side and on the bench. And yet we have to hang our head in shame only because the scourge of arrears, which is now after uh, almost 25 years of reports, committees, recommendations, commissions, actually doubled. And we used to give the excuse of COVID. Now the COVID excuse is wearing thin because in the COVID period it went only up to 3.25 crores. It is now beyond 5.5 crores. So this is something which is terrible. All the best and brightest in our professions, the great doctrines of law, the great sermons, the great judgments are nullified. And there is a complete denial of human rights. There is no doubt about it. In fact, I always say that what required is to take up 5 or 10 solutions and uninterruptedly implement them over 10 years. You'll start finding results. Instead, we keep on discussing. I mean, my favorite joke is a committee is a group of the unfit appointed by the unwilling to do the unnecessary. So you will have yet another committee giving the same recommendations. So you just postpone it. Secondly, what happens in our country is that we have zigzags. So he has a very good proposal. His proposal has 5 points, but when I succeed him, I want to put my own stamp. So I put another 3 points and I dilute his 2 points. And then when he comes, he does the same to my proposal. So therefore, the synergy of continuity is lost. The answers are simple. 1, judges. Under Supreme Court directions repeatedly, we have climbed from 11, 12 to 20 per million of population. He's talking of 150. Minimum should be 50 per million of population. So you just have to have more judges. You cannot have excellent hospitals, fantastic equipment, but no doctors. Number 2, at any point of time since independence, at any point of time, remember for a country which is now the largest, but in those days was second populous after China, we have this low judge per million population. But of that low judge to million population, that's very important to understand. So this 20 is the total pot of appointments potentially which you can make are 20 per million. But of those, since independence at any point of time, 1/3 of all High Court posts has been vacant. High Court is only 1100 in a country of this size. At any point of time, 300 to 350 are vacant. At any point of time, out of the 22 or 24,000 of our lowest judiciary, 1/4 are vacant. 1/3 for the High Court, 1/4 for the lowest judiciary. Now, it doesn't require rocket science to start appointing people in time. I know the date of his retirement on the date he's appointed. 2 weeks before he retires, I should appoint his successor. The reason again is very simple. We first know the people we have to appoint in this room. And having identified those 5, we then start finding ways of disappointing them, not appointing them. That is pure politics. And let me tell you, the politics of the judiciary will make the politics of parliament blush. I mean that. I've said it many times. So, if you have a system like that, where you know the best 5 lawyers in this sofa, the best 5 lawyers in that sofa, the best 5 lawyers, then you start finding the worst 5 because of politics. Then what do? Then, of course, there are various other things. You need to increase, to jack it up to double the number. You need to have ad hoc people appointed. Supreme Court has done me great honor by citing my article in a footnote. There's a provision in the Constitution which allows retired judges of that same court to be appointed. It's never been used in the High Court till now for 75 years. It's been used in the Supreme Court 5-6 times. Now they're trying to appoint somebody. Because what happens is when he retires, you start this appointment, disappointment exercise, takes a long time. But you already have a retired chap there who's a tried and tested chap who can sit as an ad hoc judge. Then you have to have a simplification of procedure and you appoint well. By the way, quantity is a very major fallacy. You appoint 100 judges and 80 of them are poor, inefficient, not good. Then they only add to arrears. You need to have hands-on judges. There are so many other things. You started with night courts. You had in some states, then they fizzled out, fast-track courts. So it's not difficult. It's a house of cards. Do you know, if you have a proper computerized system in this country of all these 5.5 crore cases, and you start giving notice on that computerized format, I believe personally that at least 1/3, maybe even close to half, will be infructuous. A man has died, his family has moved on, he has retired, there is nothing left in the case. There are only numbers on the file, but there's no tracking. What gives us a bad name? Each high court has 5, 7, 10, 20 cases which are 20 years old, 10 years old. Why can't the high court put those cases first and finish off the 10-year-olds? Every high court should have at least 2 tracks. Track 1, which maintains keeping abreast of current filings. And track 2, system of judges should be only dealing with arrears. And start with the 20-year-old ones, then the 10-year-old ones, the 5-year, you'll be actually down to 3 to 4 year pendency if you do it in a methodical manner. But it's quite amazing, with all the commissions, committees, we don't have the will to continuously implement it. As I said, it can be a much larger answer, but I've already taken time.
The candid comments coming through from Dr. Singhvi. We've got time for just that one last question now. And I'm sure the young man there is going to make it count.
Thank you. Good afternoon, Dr. Singhvi. I'm here. I had a quick question. Doctrine of stare decisis, or the law of precedence, has been crystallized in judicial history over time. And you spoke about Article 21 and how it is the most important articles in our constitution. Long incarceration in jail is a gross violation of Article 21. It is a settled law upheld by laid down by the Supreme Court in Hussain Ara Khatun and many more judgments. And this has also been followed by the Supreme Court in many stringent cases like the UAPA or the PMLA. My question to you is, the recent inconsistent finding of the Supreme Court in the case of Umar Khalid has been the
case of
Umar Khalid has been facing a lot of criticism due to the inconsistent stand taken by the Supreme Court, although it is a settled law. So my short question to you is, what was the minuscule line that made the top court deviate from the settled law? And how can we, as an institution, move forward to crystallize doctrine of precedent?
Yeah. Well,
thank you.
Doctrine of precedent, of course, does not mean that it's a one-size-fits-all. Unfortunately or fortunately, cases will differ according to the factual context of the case. So a principle of law which is stare decisis or doctrine of precedent will never be giving you a solution for an individual case which will turn on its facts. So merely deciding on facts is not violating stare decisis. However, what is happening in our country, especially as you go higher, is a feeling of subjectivity and infallibility, which is making more and more judgments like the chancellor's foot. So some chancellors in England had big feet, some had very small feet. So they would decide cases upon the size of their feet, which led to this phrase, chancellor's foot. Which means that we have to rein in subjectivity. Now, unfortunate but true, and I've been saying it, that we do not have one Supreme Court, just in case you are mixed up about that. We have at least 12 to 14 Supreme Courts in those 16 courtrooms. Now, that kind of subjectivity leads to inconsistency, because then you show me the color of your hair and I'll show you the kind of judgment. Thirdly, the lower courts have been traditionally a little hesitant to give liberty-based bails because of another trend in our country, a very easy way of taking a swipe at the judges that they have been compromised. So judges tend to think that, look, if this kind of allegation we have to face, then better err on the side of denial. As you go higher, that disappears, but then inconsistency comes in completely. And the biggest creator of that inconsistency, unfortunately, is frequently the Supreme Court. because all the courts below have to look at the Supreme Court. Now you find conflicting 3 or 4 orders, you take your pick. So in a nutshell, the answer to your question is, in liberty, bail matters, the narrow concept which you are asking about, bail the rule, jail the exception must be followed consistently. Variations of that must be corrected immediately. Bail the rule, jail the exception has been followed in special statutes. Normally it is a rule anyway, but special statutes means with special anti-bail provisions. Once you satisfy them, you should be able to. And now there is a new dimension which has been repeated in many of the cases I've had the privilege of assisting the court. Unduly long incarceration by itself becomes a ground, irrespective of a special anti-bail provision in a statute like PMLA, Narcotics Act, UAPA, etc., which are special anti-bail acts. There, repeatedly courts have said you must release because of sheer length of incarceration. Now, unfortunately, there are aberrations which are then plucked up and they multiply. There is nothing I can say to that. I think this has to be controlled. Judges have to be sensitized, and judges have to be told that they cannot have their subjective view.
Thank you so much, sir, for your insights. Ladies and gentlemen, that's all that time will permit us to do in terms of the Q&A session. At this point of time, I'm going to request Mr. N. Ram, Director of the Hindu Group, to please present a small memento to our chief guest for the function, Dr. Abhishek Manu Singhvi. Sir, thank you so much for being here today, for enlightening a lot of young minds with ideas and thoughts. Can we have that memento brought out? And I'd request Mr. N. Ram, Director of the Hindu Group, to please acknowledge the presence of Dr. Abhishek Manu Singhvi, please. We always say the pen is mightier than the sword. That's the reason why the pen there as well. Thank you, sir. At this point of time, I'm going to request Dr. G.V. Selvam to please also present a small token of appreciation to Mr. N. Ram as well, please. Could you please do the honors? Dr. G.V. Selvam, presenting a small token of appreciation shawl to Mr. N. Ram. Thank you, sir. I am also going to request the presence of Professor K. Satyanarayanan, Director, VIT Chennai, to kindly come up and also present a small token of appreciation for Mr. Suresh Nambath as well, please. So could you please present that needful? Thank you, Professor K. Satyanarayanan. Thank you so much, sir, for doing the needful. And may I also request the presence of Professor T. Tyagarajan, Pro Vice Chancellor, VIT Chennai. Sir, requesting your presence on stage. I would request you to please present a small memento and felicitate Mr. L.V. Navneet, please. Mr. L.V. Navneet, CEO of the Hindu Group. Thank you very much, Professor T. Tyagarajan, Pro VC of VIT Chennai. Thank you so much for doing the honors. Dr. Singhvi, thank you so much for your presence today. It's been an honor to hear from you, and I'm sure you'll inspire a lot of young leaders of tomorrow. Thank you very much, sir. I'd request our dignitaries to kindly step off stage. We'll take a short break, ladies and gentlemen, and we will regroup very soon for a fireside chat that follows. So lots coming up, ladies and gentlemen, to stay right there in that seat. We'll be commencing proceedings from here on in a short while. Ladies, gentlemen, thank you for waiting so patiently. We'll be beginning the next set of the fireside chat very shortly. So I'd request everyone who just took a little breather, maybe stepped out of the hall, to kindly come back in, take your seats, please, and we will start proceedings in a short while, please. And also a quick reminder to everyone, please put your mobile phones on silent during the course of the panel discussions and fireside chats, please. Thank you. Ladies and gentlemen, they say well begun is half done. And we couldn't have asked for a better start this morning. What a fantastic session it was with our chief guest, Dr. Abhishek Manu Singhvi. And now, ladies and gentlemen, we head into the fireside chat. Some of you at the back of the hall who are still looking to take their seats, I'd request you to please settle in so that we can begin proceedings and have our set of speakers come up on stage, please. Right, ladies and gentlemen, the first fireside chat of the day is on legal education in India. And this session aims to examine the current legal education landscape and necessary shifts required to prepare the next generation of legal practitioners. The speaker for this session is going to be Dr. G.V. Selvam, Vice President, Vellore Institute of Technology, and he's a distinguished education leader who assumed office as Vice Chairman of Vellore Engineering College back in 1999 at the age of just 26, with a vision to drive systemic change in education and expand opportunities through excellence at scale. Under his leadership, the institution was elevated to VIT University in 2001, and he went on to become the world's youngest pro-chancellor of a university, as recognized by the Limca Book of Records. As the first vice president of VIT Chennai, he played a pivotal role in developing its lush green campus and ultra-modern infrastructure as well, also extending VIT's ethos of quality education to Vellore International School, Chennai. Deeply committed to holistic development, Dr. Selvam believes education should inspire students to think independently and also build strong personalities and grow beyond mere acquisition of information. A visionary indeed. May I invite Dr. G.V. Selvam, Vice President, Vellore Institute of Technology, on stage. And to moderate this session, may I invite Mr. L.V. Navneet, the CEO of the Hindu Group, to do the needful. The stage is yours, sir.
Thank you and a warm welcome,
welcome.
Mr. Selvam. So let's begin. Let's dive deep in. In the morning session, Chancellor spoke about the law school and when it came into being. Now we all know that VIT is a globally recognized name in engineering, and it's an old institute with close to 100,000 students on its multiple campuses. So what was the defining moment when you realized VIT needed a law school?
Yeah, as I said, VIT is known for technology. So as a multidisciplinary university, we should offer all courses. So we are globally ranked in engineering. We started architecture, business school, agriculture, hotel management. So law is the need of the hour. So we started law as a multidisciplinary university.
And of course, VIT is widely recognized for its deep roots in engineering and technology. Now, how does that unique DNA shape the vision and the philosophy at the VIT School of Law, particularly in preparing students for the future?
That's a great advantage for VIT. This technology DNA is rooted in law also. So we are not teaching only the rules and regulations. We connect with cybersecurity, AI, biotechnology. Then we ask students to focus on conference, paper presentation. We have strong global connections, which will be useful for the students. So we project them not only as lawyers. We give the technologies added advantage for VIT.
We spoke about AI in the morning, and there's a session dedicated to AI later. But we are seeing AI tools evolve rapidly and it being adopted quite quickly. So, in your view, is AI a disruptive threat to the traditional role of a lawyer, or is it a powerful enabling tool a lawyer has access to? And how should both aspiring and young lawyers work with AI?
So AI is not a threat; it's a tool. It's an additional tool. It depends upon the user how they use. AI is like a time saver. It summarizes, it compares, it makes statements. In fact, if you want to say in one line, AI you should use like a co-pilot, not autopilot. You should think ourselves. It's a tool where it will help you and save time also.
And how do you personally use AI? Do you use AI yourself? And how do students, for instance, in the law school versus the engineering college, is there a difference in approach of how they use AI, or is it similar across students?
Personally, if you ask me, I'm not using AI. I use my own brain. Otherwise, we'll give you a holiday for our brains. For engineering and law, so technology is most wanted thing for engineering. We have a system called fully flexible system where students can interact and study one subject from other technology also.
I mean, I'm sure Mr. Ram will have some questions because he's a huge advocate of experimenting with new technology, and it's amazing what he does. So we'll speak about students. There are a lot of students in the room, and you spend a lot of time with students. And I think you're in a unique position to understand their inspirations, their motivations, and their aspirations. Is there something you would like to share with the legal luminaries about the younger generation they are going to hire now?
So this generation is very fast. They are adaptive. They are understandable. Only thing is, as elders, there should be like a God figure for them. They're very much interesting. They want to go to a quick, fast step. They're very interesting to learn more in a short time.
And and on campus, how do you temper these expectations of quick success, and that life outside us is a hard walk to success and not necessarily easy? So how do you ensure that students get this perspective on campus before they get into the real world of work?
As you said, we produce real advocates, lawyers, because nowadays time is very precious. They don't want to waste time. In fact, we conduct so many practical workshops for them. So they conduct legal clinics in the villages where they have hands-on experience. We invite more seniors to interact with them, sitting judges. They visit the high courts and district courts to get hands-on experience.
There are, of course, lots of aspiring lawyers in the audience, but there are a lot of people watching online who would be curious about the legal profession but may not know much about it. So I have a couple of questions in terms of the composition of students who come to study law. So for somebody who at your school comes to do a law course after 12th, what is the kind of backgrounds they come from?
So usually in Indian mindset, they think there's only two options. One is engineering or medicine. Nowadays, totally changed. Now this younger generation, mostly they want to go for law, architecture. They go for design also. So law means mostly any course they study in 11th they can join. Particularly parents, the lawyers' parents insist on their sons and daughters. But even other parents also, they want a new stream which has future.
Which was my other question. So typically, if you have a lawyer among your friends and relatives, you are aware of it. Roughly, what percentage of students would be people studying law for the first time in their among their family members?
Maybe around 40 to 45%.
That's awesome. And see, we all know when it comes to medicine and engineering, at least it used to be that as soon as you're born, your parents will decide you will study medicine or engineering, and students those days didn't have a choice. Today's students exercise their choice. Roughly at what age do students start to figure out and get a sense that they want to pursue education in law?
It's not like medicine or engineering. Mostly after grade 10, they decide. Mostly they want to become a IAS or IPS. Usually I used to meet the parents. They say my son or daughter want to become IAS, IPS and apply for public service exams.
So lots of young and aspiring lawyers in the audience. What is the single most important advice or takeaway you can give them, not just to survive but to thrive in their chosen profession in the years to come?
So as I advised, this generation very fast. Only thing is they should think clearly, write regularly, and speak integratedly. That's very important. So they want to have everything fast. So first thing is integrity is very important. Honesty is important because reputation travels faster than a resume. The word of mouth travels fast. It gives good clients. So always, my motto is always say H and H, hard work and honesty. Definitely they should do hard work. As our chief guest states, hard work can be replaced, but hard work cannot be replaced.
You spoke about writing as something they should do. Could you build on that? And
because nowadays only hearing is there, so writing habit has gone, reading habit has gone. So students should read regularly. Sky is the limit for learning. They should learn till the last day.
Part of good writing comes from ability to read well and read good stuff. So I would urge younger people to certainly breed news media sources with credibility. We are one of them, so please read us or please read somebody else you think is credible. But reading credible newspapers is important to expand both depth and width of one's lived experiences, which comes handy in the pursuit of legal profession later.
So always have a chance to say coffee with Hindu. So morning you should read newspapers. That's it improves your language, new words we can learn. So reading is very important.
Yeah, we touched upon multidisciplinary education. So is multidisciplinary education luxury or a survival necessity in 2026? And how are you as an educational institution approaching this?
Is essential, is necessity, because we talk about 360-degree development, overall development. As a multidisciplinary, a lawyer means it's not sit only with law courses. For example, climate change. It connects with economics, geometrics. So many things are connected. You talk about startups. It connects with finance, branding. So many things are connected. So there'll be a fusion. If you know so many things, it will be easy to interact with your clients, and negotiation skills will improve. So multidisciplinary is essential and necessity.
We speak about multiple careers post a course in post education in law, and I think one of the things for us to produce great lawyers is to have more institutions and great faculty, great people managing law institutes. So among the young students here who want to build a career in academics in law, what should they do? How should they start? How should they approach it?
Patience is very important. Handling students is not easy nowadays. Listening capacity, what you call concentration time, has gone down, not only among students, in all field. So how to attract students in the classroom is a big tough challenge for us. Maybe in future, if an institution is doing well, first you should remove attendance. Without attendance, students should sit in the class and listen. So your lecture should be new, which is not available in the Google or any book. For that, a lecturer should prepare himself, update himself to get the concentration of the students.
So basically, be original. Yeah. So what makes a first year? I mean, you see the transition of somebody who's 18, 19, comes into college or at a younger age probably and blossoms into a young adult ready to face the world. So what makes a first year law student fit for industry and ready for success by the time he or she graduates?
Main thing is integrity is very important because after graduation he has more options. So mostly they go for abroad for higher education. Mostly in VIT we give this exposure to the students. It will be very useful for the students if they go abroad, since we say this fully flexible system where he can take a subject from business school or environmental science. It's like a basket. They pick up and take the subject. So exposure is important for their future.
I mean, let's talk about social media, and I know you and I have spoken a lot about it offline. What's your view on social media? Is it the ultimate distraction, or is it a student's best networking tool?
It's a double-sided sword. Social media is a double-sided sword. It depends upon the user. It's like internet, right? It's double-sided sword. If you say in positive way, we have so many social medias, Facebook is there, Insta is there, particularly LinkedIn. It connects the world with you. It develops contacts. The contacts can be converted into clients. For as a lawyer, can be connected with clients. So you can follow the senior lawyers like Mr. Singhvi, Mr. Kapil Singh. You can follow them and improve your knowledge. So it depends upon the user. It definitely going to improve his future.
So let me rephrase that question. One is the context of students, but let's say as a member of a family, what would you advise younger people in your own circles about how to use social media?
It depends upon the age also. I have seen some countries below 16, they are going to ban. I think in other, Australia, in some states, they are thinking. Everything depends upon the time. There's a limit. If they use in a particular limit time, there's no issue. Because nowadays, even a newborn baby is given a mobile phone, have a food. So limited access is good for the social media.
I mean, you run the VIT School of Law. It's neither a new nor an old institution. It's around 12, 13 years old now. Would I be right? 2014. And you have sent out many graduates out into the real world. What is the one line you want VIT law graduates to be remembered for? What will make you happy if people outside say one line and describe a graduate from the VIT School of Law?
Suppose if I visit a high court or Supreme Court, if someone says it's very honesty, then you should be a VIT.
That's nice. I have one last question to you for you, and then we can take some questions in the audience. And this is a tricky one. I know Chancellor was a lawyer. Now he calls himself a lawyer who doesn't practice, a non-practicing lawyer. If you were to hit the reset button and redo your own degree today, would you choose law? And if yes, or if no, what are your reasons?
So I have two lawyers in my family, my father and my wife. Yes, definitely. If I could ever be a lawyer, I'd be a whistleblower, not a arbitration going abroad or mediation. We should serve the society. We should go to the court, help the people. You should act like an NGO. That was my wish.
Fantastic. And your questions have been crisp, short, sharp. We are done ahead of time, but we can take a few questions from the audience. We can take a few questions if you're okay with it.
So we do have we've put out some chits out there, and I believe you can moderate the same.
Yeah.
Good afternoon, sir.
Yeah,
my name is Samar. I am a student currently. Sir, no one in my family practices law. So, as a first generation lawyer, I have seen around in my environment also, first generation lawyers, they struggle a lot. So, what is your take on that? How can I, actually make a career for myself as a first generation lawyer?
You can compare with a doctor. If his father is a good doctor, he has a big hospital, he will survey immediately. The same thing happens in your fraternity also. But as I said, join a good office, good listener, good follower. Maybe in 5-10 years, you'll become a senior. All the best.
Thank you very much, sir.
So if I can add to that, it is a blessing in my view. So for instance, nobody in my family has worked in a news media organization. It helps because you get different perspectives at home, and you don't need necessarily to measure up to somebody else in the family. So it's quite liberating if you're the first in your from your family tree to be doing it.
So no one is born as a lawyer.
Namaskar, sir. My name is Shivam Kumar, and most of us in this hall are students, and we are related to the academia. So my question is to you that how to manage many subjects at a single time, because it is always dilemma with a student that which subject he should prefer at which time, and because at a single time he choose one, then another there is a lapse such type that. Thank you very much.
Again, I compare with a MBBS doctor because MBBS is a broad vision. After MBBS, they'll go for MD or MS. So as a basic lawyer, you should focus on all subjects, not only crime or criminal or civil, because nowadays more specialization is there. They go for international arbitration, mediation and all. But you should have a basic knowledge of all subjects.
Hello, sir. My name is Lavleen. I'm from Delhi University Law Center. I have one question that if you are a fresh graduate and cyber law is one of the newly emerging law field, how we can make a career in cyber law? Because we are well aware about arbitration, litigation, but the cyber law is something that we really need more information about.
Yes.
Thank you.
Future is going to be cyber law. For cyber law, first we should know about cyber security basic subject. So as a multidisciplinary university, we offer cyber security also. So you should have a knowledge of cyber security, then you should study about cyber law.
Hello, my name is Rahul. My question is future related technology. Should artificial intelligence be used in court decisions? Why? Why or why not?
AI cannot replacement human thinking. It can fast you because we have so many things. Court strategy is there, empathy is there, so many things you have to consider and give a judgment. Because if AI decides everything, no need of personal hearing. They can submit and get a court judgment. So human brains cannot be replaced by AI.
Good afternoon, sir. I am Asmi Kumar. I am a student of economics at DU. I am aspiring to pursue a career in legal education further. So I am interested in knowing how economics would open up avenues in law.
Yes, as I said, we are talking about this climate change. For climate change, economics is one of the main subject. It's going to be future. We are talking about global warming every time, but it's not happening. No action is being taken. So climate change will be the future. Definitely, economics will be useful for climate change.
We can take one final question.
Good afternoon, sir. This is Shraddha. I'm from fourth year of VIT School of Law. So I want to post a question basically stating what will be the future of the legal education in India? Whether if it is so, what are the changes will bring by you to change the legal education in India in future?
In today's scenario, to enter politics, legal education become a minimum eligibility. I see so many advocates and lawyers become MPs and MLAs. This is apart. So we have good future. As I said, so many specialists are coming. So not only High Court and Supreme Court, mostly this all MNC companies, they need a person like you as an advisor. You have a good future in law.
Thank you, Mr. Selvam. It's absolute pleasure. Thank you so much.
Thank you, Mr. Navin.
So thank you so much, Dr. Selvam, for sharing your thoughts. I'm going to request Mr. L.V. Navneet to please present a memento from our side to Dr. G.V. Selvam, sir. Request you to please accept that little token of our appreciation. Thank you very much, sir, for an enlightening session. Conversations will flow, and I'm sure lots will be shared. And of course, we'll be fielding your questions post the sessions as the day continues. We'll take a short breather here, ladies and gentlemen. It's already 1:15. Napoleon said even armies cannot march on an empty stomach. So what we shall do is that we will take a little breather. We'll break for lunch. We'll reconvene at 2 p.m. and carry on the conversations and, of course, the sessions. Thank you so much.
Next up, an in-depth review of India's foreign affairs. And speaking of foreign affairs, Jollywood star Malesh was spotted with a 22-year-old Brazilian supermodel, Lana Kova. Now that's a real foreign affair. Looks like trade isn't the only thing crossing borders. So tell us, do you think this foreign affair will actually strengthen India-Brazil relations? Guess Malesh.
And this is Worldview at the Hindu. Now, D-Day arrived this week for US sanctions on India after 25% reciprocal tariffs that came into play in early August. Another
newspaper. Shakkar Kama.
గప్పు తాంగల అయ్యో గప్పు తాంగల హీరోయిన్ ఫోన్ తో లంగా హెడ్ లైన్ న్యూస్ అయ్యో తాంగల గప్పు తాంగల వంద బ్రేకింగ్ ప్రింట్.
Velour International School, a holistic education hub designed to nurture a child's all-around development with a value-rich learning beyond academics. VIT's 3+ decades of magnificent contribution to education gives birth to Velour International School. VIS is empowered by the vision to nurture and promote unhindered knowledge seeking and make it a premier institution of the nation. VIS stands out with its holistic learning, Wisdom, the student profile building program, and personalized house parenting for an extraordinary educational experience. VIS campus, immersed in natural light and surrounded by lush greenery, offers a strong connection with nature. The campus provides a serene and calm atmosphere for the young minds to flourish. The classrooms at VIS enrich experiential learning with innovative and immersive teaching techniques, where the curriculum is designed to create leaders of tomorrow. The library serves as a beacon of knowledge, a sanctuary for curious young minds, instilling a love for learning. Our labs are designed to ignite the innovative mindset in students, introducing them to a world of hands-on learning and a keen interest in science and technology. VIS residential blocks with a dedicated house parent ensure not just safety, but a nurturing environment where every need of the child is attended to at all times. VIS has a dynamic sports program to ensure students in a spirit of competition and team building, creating students ready to conquer challenges on and off the field. VIS is where safety meets nurturing care, ensuring your child takes the first step towards a life of accomplishments.
Chip one, chip.
Vellore International School. Right place to rise.
VIT Chennai is a globally engaged, competitive, comprehensive, research-enriched university campus strategically positioned to respond to major industrial, social, economic, and environmental demands and challenges. The campus has a cosmopolitan atmosphere with students from all corners of the globe.
The curriculum at VIT is designed to help students discover their strengths and enhance their academic performance. VIT focuses on improving the uniqueness of each student. Whether you're a coder, creator, or changemaker, this is your launchpad. VIT's Incubation Center transformed my idea into a real product and helped launch my startup journey.
The fully flexible credit system at VIT gives me the opportunity to learn at my own pace. I can choose my own subjects, my own schedule, and choose to learn with the professors who work the best with my learning ability.
VIT Flagship Engineering Institute has been consistently ranked among the best engineering institute of the nation, making it one of the most preferred engineering destinations for students of the nation.
Being part of the research community means continuous learning, experimentation, and the freedom to explore new ideas. VIT offers a wide array of schools and academic programs over various disciplines.
VIT School of Law is one of the leading law schools of the nation that is dedicated to honing and producing tomorrow's lawyers and law practitioners. The unique moot court concepts prepare today's aspiring lawyers for tomorrow's challenges. Simulated court cases are fought and debated as students develop gaining confidence, art of interrogation, communication skills, persuasion skills, and much more. VIT Fashion Institute of Technology is one of the specialized offshoots offering fashion education, where technology is being used to create uniqueness in blending the tradition and the modern designs. The school aims to impart quality fashion education to nourish the young minds with knowledge of fashion and teach them the nuances in this profession. VIT Business School has emerged as a premier business school in India. The programs are designed to infuse strong industry-relevant business principles with deep insights, influencing practice, and actively collaborating with foreign universities and industry.
Joining the college as a fresher who knew nothing about tech. Now, I'm leaving the college as a third-year student with a 1 crore package. From start to finish, VIT helped me throughout the recruitment process with interviews and online assessments.
Spacious hostel rooms, multi-cuisine cafeteria, sports arena, state-of-the-art gymnasium, all affording an opportunity for holistic development of the student.
Come, be a pioneer of change. Be a part of something larger than life. Come to VIT.
Vellore Institute of Technology, a place to learn, a chance to grow.
Unlike newspaper, Shakkar Kama,
గప్పు తాంగల అయ్యో గప్పు తాంగల హీరోయిన్ ఫోన్ తో లంజ హెడ్లైన్ న్యూస్ అయ్యో తాంగల గప్పు తాంగల వంద రేటింగ్ ప్రింట్
Or International School, a holistic education hub designed to nurture a child's all-around development with a value-rich learning beyond academics. VIT's 3+ decades of magnificent contribution to education gives birth to Valor International School. VIS is empowered by the vision to nurture and promote unhindered knowledge seeking and make it a premier institution of the nation. VIS stands out with its holistic learning, wisdom, the student profile building program, and personalized house parenting for an extraordinary educational experience. VIS campus, immersed in natural light and surrounded by lush greenery, offers a strong connection with nature. The campus provides a serene and calm atmosphere for the young minds to flourish. The classrooms at VIS enrich experiential learning with innovative and immersive teaching techniques, where the curriculum is designed to create leaders of tomorrow. The library serves as a beacon of knowledge, a sanctuary for curious young minds, instilling a love for learning. Our labs are designed to ignite the innovative mindset in students, introducing them to a world of hands-on learning and a keen interest in science and technology. VIS residential blocks with a dedicated house parent ensure not just safety, but a nurturing environment where every need of the child is attended to at all times. VIS has a dynamic sports program to ensure students in a spirit of competition and team building, creating students ready to conquer challenges on and off the field. VIS is where safety meets nurturing care, ensuring your child takes the first step towards a life of accomplishments. Valor International School. Right place to rise.
VIT Chennai is a globally engaged, competitive, comprehensive, research-enriched university campus strategically positioned to respond to major industrial, social, economic, and environmental demands and challenges. The campus has a cosmopolitan atmosphere with students from all corners of the globe.
The curriculum at VIT is designed to help students discover their strengths and enhance their academic performance. VIT focuses on improving the uniqueness of each student.
Whether you're a coder, creator, or changemaker, this is your launchpad. VIT's Incubation Center transformed my idea into a real product and helped launch my startup journey.
The fully flexible credit system at VIT gives me the opportunity to learn at my own pace. I can choose my own subjects, my own schedules, and choose to learn with the professors who work the best with my learning ability.
VIT Flagship Engineering Institute has been consistently ranked among the best engineering institute of the nation. making it one of the most preferred engineering destinations for students of the nation.
Being part of the research community means continuous learning, experimentation, and the freedom to explore new ideas. VIT offers a wide array of schools and academic programs over various disciplines.
VIT School of Law is one of the leading law schools of the nation that is dedicated to honing and producing tomorrow's lawyers and law practitioners. The unique moot court concepts prepare today's aspiring lawyers for tomorrow's challenges. Simulated court cases are fought and debated as students develop gaining confidence, art of interrogation, communication skills, persuasion skills, and much more. VIT Fashion Institute of Technology is one of the specialized offshoots offering fashion education, where technology is being used to create uniqueness in blending the tradition and the modern designs. The school aims to impart quality fashion education to nourish the young minds with knowledge of fashion and teach them the nuances in this profession. VIT Business School has emerged as a premier business school in India. The programs are designed to infuse strong industry-relevant business principles with deep insights, influencing practice, and actively collaborating with foreign universities and industry.
Joining the college as a fresher who knew nothing about tech. Now, I'm leaving the college as a third-year student with a 1 crore package. From start to finish, VIT helped me throughout the recruitment process with interviews and online assessments.
Spacious hostel rooms, multi-cuisine cafeteria, sports arena, state-of-the-art gymnasium, all affording an opportunity for holistic development of the student.
Come, be a pioneer of change. Be a part of something larger than life. Come to VIT.
Willow Institute of Technology, a place to learn, a chance to grow.
Unlike newspaper, Shakkar Kama.
Gappu tangala, ayyo gappu tangala, heroine phone tolanja, headline news, ayyo tangala, gappu tangala. Print.
Or International School, a holistic education hub designed to nurture a child's all-around development with a value-rich learning beyond academics. VIT's 3+ decades of magnificent contribution to education gives birth to Velour International School. VIS is empowered by the vision to nurture and promote unhindered knowledge seeking and make it a premier institution of the nation. VIS stands out with its holistic learning, Wisdom, the student profile building program and personalized house parenting for an extraordinary educational experience. VIS Campus, immersed in natural light and surrounded by lush greenery, offers a strong connection with nature. The campus provides a serene and calm atmosphere for the young minds to flourish. The classrooms at VIS enrich experiential learning with innovative and immersive teaching techniques, where the curriculum is designed to create leaders of tomorrow. The library serves as a beacon of knowledge, a sanctuary for curious young minds, instilling a love for learning. Our labs are designed to ignite the innovative mindset in students, introducing them to a world of hands-on learning and a keen interest in science and technology. VIS residential blocks with a dedicated house parent ensure not just safety, but a nurturing environment where every need of the child is attended to at all times. VIS has a dynamic sports program to ensure students in a spirit of competition and team building, creating students ready to conquer challenges on and off the field. VIS is where safety meets nurturing care, ensuring your child takes the first step towards a life of accomplishments. Velour International School. Right place to rise.
VIT Chennai is a globally engaged, competitive, comprehensive, research-enriched university campus strategically positioned to respond to major industrial, social, economic, and environmental demands and challenges. The campus has a cosmopolitan atmosphere with students from all corners of the globe.
The curriculum at VIT is designed to help students discover their strengths and enhance their academic performance. VIT focuses on improving the uniqueness of each student.
Whether you're a coder, creator, or changemaker, this is your launchpad. VIT's Incubation Center transformed my idea into a real product and helped launch my startup journey.
The fully flexible credit system at VIT gives me the opportunity to learn at my own pace. I can choose my own subjects, my own schedule, and choose to learn with the professors who work the best with my learning ability.
VIT Flagship Engineering Institute has been consistently ranked among the best engineering institute of the nation, making it one of the most preferred engineering destinations for students of the nation.
Being part of the research community means continuous learning, experimentation, and the freedom to explore new ideas. VIT offers a wide array of schools and academic programs over various disciplines.
VIT School of Law is one of the leading law schools of the nation that is dedicated to honing and producing tomorrow's lawyers and law practitioners. The unique moot court concepts prepare today's aspiring lawyers for tomorrow's challenges. Simulated court cases are fought and debated as students develop gaining confidence, art of interrogation, communication skills, persuasion skills, and much more. VIT Fashion Institute of Technology is one of the specialized offshoots offering fashion education, where technology is being used to create uniqueness in blending the tradition and the modern designs. The school aims to impart quality fashion education to nourish the young minds with knowledge of fashion and teach them the nuances in this profession. VIT Business School has emerged as a premier business school in India. The programs are designed to infuse strong industry-relevant business principles with deep insights, influencing practice, and actively collaborating with foreign universities and industry.
Joining the college as a fresher who knew nothing about tech. Now I'm leaving the college as a third year student with a 1 crore package. From start to finish, VIT helped me throughout the recruitment process with interviews and online assessments.
Spacious hostel rooms, multi-cuisine cafeteria, sports arena, state-of-the-art gymnasium, all affording an opportunity for holistic development of the student.
Come, be a pioneer of change. Be a part of something larger than life. Come to VIT.
Window Institute of Technology, a place to learn, a chance to grow.
Unlike newspaper, Shakkar Kama.
Gappu Pangala, Ayo Gappu Pangala, heroine phone tolanja, headline news, Ambaja, Ayo Kangala, Gappu Pangala. Print.
Valor International School, a holistic education hub designed to nurture a child's all-around development with a value-rich learning beyond academics. VIT's 3+ decades of magnificent contribution to education gives birth to Valor International School. VIS is empowered by the vision to nurture and promote unhindered knowledge seeking and make it a premier institution of the nation. VIS stands out with its holistic learning, Wisdom, the student profile building program, and personalized house parenting for an extraordinary educational experience. VIS campus, immersed in natural light and surrounded by lush greenery, offers a strong connection with nature. The campus provides a serene and calm atmosphere for the young minds to flourish. The classrooms at VIS enrich experiential learning with innovative and immersive teaching techniques, where the curriculum is designed to create leaders of tomorrow. The library serves as a beacon of knowledge, a sanctuary for curious young minds, instilling a love for learning. Our labs are designed to ignite the innovative mindset in students, introducing them to a world of hands-on learning and a keen interest in science and technology. VIS residential blocks with a dedicated house parent ensure not just safety, but a nurturing environment where every need of the child is attended to at all times. VIS has a dynamic sports program to ensure students in a spirit of competition and team building, creating students ready to conquer challenges on and off the field. VIS is where safety meets nurturing care, ensuring your child takes the first step towards a life of accomplishments. Delore International School. Right place to rise.
VIT Chennai is a globally engaged, competitive, comprehensive, research-enriched university campus strategically positioned to respond to major industrial, social, economic, and environmental demands and challenges. The campus has a cosmopolitan atmosphere with students from all corners of the globe.
The curriculum at VIT is designed to help students discover their strengths and enhance their academic performance. VIT focuses on improving the uniqueness of each student.
Whether you're a coder, creator, or change maker, this is your launchpad. VIT's Incubation Center transformed my idea into a real product and helped launch my startup journey.
The fully flexible credit system at VIT gives me the opportunity to learn at my own pace. I can choose my own subjects, my own schedule, and choose to learn with the professors who work the best with my learning ability.
VIT Flagship Engineering Institute has been consistently ranked among the best engineering institute of the nation, making it one of the most preferred engineering destinations for students of the nation.
Being part of the research community means continuous learning, experimentation, and the freedom to explore new ideas. VIT offers a wide array of schools and academic programs over various disciplines.
VIT School of Law is one of the leading law schools of the nation that is dedicated to honing and producing tomorrow's lawyers and law practitioners. The unique moot court concepts prepare today's aspiring lawyers for tomorrow's challenges. Simulated court cases are fought and debated as students develop gaining confidence, art of interrogation, communication skills, persuasion skills, and much more. VIT Fashion Institute of Technology is one of the specialized offshoots offering fashion education, where technology is being used to create uniqueness in blending the tradition and the modern designs. The school aims to impart quality fashion education to nourish the young minds with knowledge of fashion and teach them the nuances in this profession. VIT Business School has emerged as a premier business school in India. The programs are designed to infuse strong industry-relevant business principles with deep insights, influencing practice, and actively collaborating with foreign universities and industry.
Joining the college as a fresher who knew nothing about tech. Now, I'm leaving the college as a third-year student with a 1 crore package. From start to finish, VIT helped me throughout the recruitment process with interviews and online assessments.
Spacious hostel rooms, multi-cuisine cafeteria, sports arena, state-of-the-art gymnasium, all affording an opportunity for holistic development of the student.
Come, be a pioneer of change. Be a part of something larger than life. Come to VIT.
Willow Institute of Technology, a place to learn. a chance to grow.
The next newspaper, Shakkar Kama.
Gappo tangala, ayyo gappo tangala, heroine phone tolanja, headline news. Ayyo tangala, gappo tangala.
Or International School, a holistic education hub designed to nurture a child's all-around development with a value-rich learning beyond academics. VIT's 3+ decades of magnificent contribution to education gives birth to Valor International School. VIS is empowered by the vision to nurture and promote unhindered knowledge seeking and make it a premier institution of the nation. VIS stands out with its holistic learning, wisdom, the student profile building program, and personalized house parenting for an extraordinary educational experience. VIS campus, immersed in natural light and surrounded by lush greenery, offers a strong connection with nature. The campus provides a serene and calm atmosphere for the young minds to flourish. The classrooms at VIS enrich experiential learning with innovative and immersive teaching techniques, where the curriculum is designed to create leaders of tomorrow. The library serves as a beacon of knowledge, a sanctuary for curious young minds, instilling a love for learning. Our labs are designed to ignite the innovative mindset in students, introducing them to a world of hands-on learning and a keen interest in science and technology. VIS residential blocks with a dedicated house parent ensure not just safety, but a nurturing environment where every need of the child is attended to at all times. VIS has a dynamic sports program to ensure students in a spirit of competition and team building, creating students ready to conquer challenges on and off the field. VIS is where safety meets nurturing care, ensuring your child takes the first step towards a life of accomplishments. Valor International School. Right place to rise.
VIT Chennai is a globally engaged, competitive, comprehensive, research-enriched university campus strategically positioned to respond to major industrial, social, economic, and environmental demands and challenges. The campus has a cosmopolitan atmosphere with students from all corners of the globe.
The curriculum at VIT is designed to help students discover their strengths and enhance their academic performance. VIT focuses on improving the uniqueness of each student.
Whether you're a coder, creator, or change maker, this is your launchpad. VIT's Incubation Center transformed my idea into a real product and helped launch my startup journey.
The fully flexible credit system at VIT gives me the opportunity to learn at my own pace. I can choose my own subjects, my own schedule, and choose to learn with the professors who work the best with my learning ability.
VIT Flagship Engineering Institute has been consistently ranked among the best engineering institute of the nation, making it one of the most preferred engineering destinations for students of the nation.
Being part of the research community means continuous learning, experimentation, and the freedom to explore new ideas. VIT offers a wide array of schools and academic programs over various disciplines.
VIT School of Law is one of the leading law schools of the nation that is dedicated to honing and producing tomorrow's lawyers and law practitioners. The unique moot court concepts prepare today's aspiring lawyers for tomorrow's challenges. Simulated court cases are fought and debated as students develop gaining confidence, art of interrogation, communication skills, persuasion skills, and much more. VIT Fashion Institute of Technology is one of the specialized offshoots offering fashion education, where technology is being used to create uniqueness in blending the tradition and the modern designs. The school aims to impart quality fashion education to nourish the young minds with knowledge of fashion and teach them the nuances in this profession. VIT Business School has emerged as a premier business school in India. The programs are designed to infuse strong industry-relevant business principles with deep insights, influencing practice, and actively collaborating with foreign universities and industry.
Joining the college as a fresher who knew nothing about tech. Now, I'm leaving the college as a third-year student with a 1 crore package. From start to finish, VIT helped me throughout the recruitment process with interviews and online assessments.
Spacious hostel rooms, multi-cuisine cafeteria, sports arena, state-of-the-art gymnasium, all affording an opportunity for holistic development of the student.
Come, be a pioneer of change. Be a part of something larger than life. Come to VIT.
Vellore Institute of Technology, a place to learn, a chance to grow.
Unlike newspaper, Shakkar Kama.
గప్పు తాంగల అయ్యో గప్పు తాంగల హీరోయిన్ ఫోన్ తో లంగా రెడ్ లైన్ న్యూస్ కాంగల గప్పు వంద లిస్టింగ్ ప్రింట్.
Vellore International School, a holistic education hub designed to nurture a child's all-around development with a value-rich learning beyond academics. VIT's 3+ decades of magnificent contribution to education gives birth to Vellore International School. VIS is empowered by the vision to nurture and promote unhindered knowledge seeking and make it a premier institution of the nation. VIS stands out with its holistic learning, wisdom, the student profile building program, and personalized house parenting for an extraordinary educational experience. VIS campus, immersed in natural light and surrounded by lush greenery, offers a strong connection with nature. The campus provides a serene and calm atmosphere for the young minds to flourish. The classrooms at VIS enrich experiential learning with innovative and immersive teaching techniques, where the curriculum is designed to create leaders of tomorrow. The library serves as a beacon of knowledge, a sanctuary for curious young minds, instilling a love for learning. Our labs are designed to ignite the innovative mindset in students, introducing them to a world of hands-on learning and a keen interest in science and technology. VIS residential blocks with a dedicated house parent ensure not just safety, but a nurturing environment where every need of the child is attended to at all times. VIS has a dynamic sports program to ensure students in a spirit of competition and team building, creating students ready to conquer challenges on and off the field. VIS is where safety meets nurturing care, ensuring your child takes the first step towards a life of accomplishments. Velour International School. Right place to rise.
VIT Chennai is a globally engaged, competitive, comprehensive, research-enriched university campus strategically positioned to respond to major industrial, social, economic, and environmental demands and challenges. The campus has a cosmopolitan atmosphere with students from all corners of the globe.
The curriculum at VIT is designed to help students discover their strengths and enhance their academic performance. VIT focuses on improving the uniqueness of each student.
Whether you're a coder, creator, or change maker, this is your launchpad. VIT's Incubation Center transformed my idea into a real product and helped launch my startup journey.
The fully flexible credit system at VIT gives me the opportunity to learn at my own pace. I can choose my own subjects, my own schedule, and choose to learn with the professors who work the best with my learning.
Good afternoon, ladies and gentlemen. I'm sure that with a bit of food in the belly, the mind is now focused on some of the other issues that we will have on hand in this session. I'd request everybody to please settle in, take your seats, please. We're heading into our next session. We've managed to get a plethora and a wide array of speakers for our panel discussions, and we'd love to hear them in earnest. Right, we get in straight away to our panel discussion that's lined up in this post-lunch session. And this is an important one, an interesting one. It's called, can we have the music off, please, now? Thanks so much. Pretty much set the tone for what's to happen. And to everyone else who's outside the hall, I'd request you to please come in. There is food outside, but there's definitely food for thought in this hall, which I think is going to be serving the soul a lot better. So I request you all to come in here. Right. GenAI-induced technological transformation. That's going to be the topic that we're going to be talking about. Professional competence in legal practice. Of course, this addresses the profound impact of generative AI on legal practice, and we'll explore how these emerging technologies are redefining professional competence and ethical imperatives for lawyers navigating this digital transformation. To take matters further, I'm going to invite our moderator and then, of course, our panelists on stage. The moderator for this session, Mr. Sandeep Pukan, Associate Editor of The Hindu. Pleasure to have you here with us, sir. He is the man who will be holding fort as we go ahead in this. And of course, our esteemed panelists, I'd like to invite them on stage. Mr. Vishal Sinha, Advocate, Supreme Court of India. Sir, pleasure to have you here. And thank you so much for taking time out and joining us today. May I invite on stage Ms. Neha Rathi, Advocate on Record, Supreme Court of India. Pleasure to have you here with us, ma'am. And also present is Dr. Jishnu J.R., Head of the Department, BBA LLB Honors, VIT School of Law, VIT Chennai. Thank you so much, sir, for your presence, and it's over to you.
Thank you, Raman. Thank you. Am I audible? Yeah, so this is actually a tough session to do. I mean, I know for all the good words that Raman said, after a sumptuous meal, it's difficult to keep people awake. So I'm actually relying on my brilliant panelists to give you that food for thought after the sumptuous lunch. Let me introduce the panel quickly. I have with me Advocate Vishal. Vishal Sinha is an advocate in Supreme Court who focuses on constitutional law. We have Advocate Neha Rathi. She's an advocate on record in the Supreme Court and focuses on issues of transparency and constitutional law. And of course, I have Dr. Jishnu, head of Department of BA LLB course in the VIT School of Law. He's a PhD in law who specializes on intellectual property and digital media marketing, among others. Thank you very much. And I hope the way a few housekeeping announcements before I proceed. I would request all of you to settle in and keep your phones on silent mode. Towards the end of the session, this is a 45-minute long session. We hope to keep about 10 minutes or so for question and answer session once the discussion is over. Keep your questions brief and identify yourself while asking the questions. The way I have structured is I'll open this floor with a common question to all of you, which is that it's interesting that we are, beginning the post-lunch session with a session on artificial intelligence. It's only perhaps appropriate that we are doing this right now because very recently we hosted an AI Impact Summit in Delhi. And it is the right thing to ask the impact of artificial intelligence in legal practice. My first question to all of you, each one of you can answer, will artificial intelligence actually enhance productivity, lead to better research, better drafting, or will it be a burden in terms of requiring more due diligence? Why don't you start, Neha, being the only lady on the panel? Yes, I think so.
Yeah. So I think artificial intelligence is already acting as a great efficient tool. If I talk in the context of advocates, especially, it is already being used a lot. Apps like there are already softwares like Claude, Notebook LM, ChatGPT, of course, for general usage that lawyers, junior advocates are already using. At the same time, there's a large fear of wrong judgments, as you all would be aware, of course. There are so many judgments which have been which are cited regularly, being cited and being pointed out by courts, and it's to the horror of advocates, of course, that they come to know that okay, some junior has actually just copy pasted what the output given by an AI. So, of course, due diligence is very, very, very important. Meticulous due diligence is important. We cannot rely on it with our eyes closed and just go in front of a courtroom and argue something. You have to check, double check all the facts. So this is where we are right now. But in for example, if I would give regular practice, AI is being used in a very practical way. So, for instance, it's a very, very, very efficient intern, one would say, or a very efficient junior, one would say, which could in concise summarize things, give you points in concise, give you some points against or for a particular brief. We are using it actually for translation also, for any last minute brief that you have got. So quick summary, sometimes it helps to put those points across. So those kind of things are being used regularly. But of course, there is no denying that time is also spent checking everything. So
Right.
if I get a list of dates made on Claude, I can't just copy paste on that onto Word. I'll have to again and again check every fact.
Right.
So to some extent it is used, and
Right.
with a pinch of salt.
I'll ask that question as a follow-up. Vishal, what's your thought on this? Whether it increases productivity, workflow efficiency in legal practice, or is it
No,
do you
so
need more due diligence?
right. No, so adding on to what Neha is saying, I am also of the firm opinion that it is a great tool. It is going to impact efficiency. It is already doing. Saying that, I think is the similar to say the advent of internet back in the early 2000s, or when we were small, but it's the similar way that we are now realizing that there is this huge repository of information, of tools which we can enhance, which are being modulated now slowly into different fields of life. So of course one of them being law. So since the last 2 years we've already seen that all these tools have developed and are still in the process of developing, of ensuring that their outcomes are trustworthy, are can be relied upon. Saying that, I feel that the advent in this, especially in the last year or the last 2 years, has been huge, has been really impactful. It has made things easier for a lot of us, especially as Neha said, that you get something at 9 a.m. or at 10 p.m. and you have a hearing the next morning. You can't go anywhere else. Like, for example, if you have an original document which is, say, in vernacular language, and you want to verify what it says, at 10 p.m., you can't call a friend and say, hey, can you read this document for me? So, in that sense, it's a great substitute. And I feel what it can do will keep enhancing, and it will get more and more part of the legal profession as lawyers, as judges, and also of institutions. So I think it's still learning on the go. But yeah, but saying that, as Nia said, there are, of course, a few fallbacks which we have to be sure about, we have to think about. So, but I'm sure we'll touch upon that in the rest of the session.
Right. Dr. Jishnu, what's your take on this?
Yes.
Does it increase efficiency, or do you think that you need to be now more careful?
Yeah. So to understand the efficiency factor, one have to be very clear with how. Since I'm an
Will you bring
academic,
the mic a little closer? I think.
since I'm an academician, I'll be speaking with respect to the aspect of research. Okay, and research basically includes a review of literature, then experimentation, and towards the end you will be making analysis. And a basic human being, they will search, they will screen, they will extract, they will analyze, and then they will move on to the next step, that is experimentation, wherein they will apply, they will think, that they will apply their mind and think whether I should come up with an output only based on the data, or whether I should come up with an output by applying data alongside my belief. And my belief, what I am saying is my logic. Okay, and that is how you end up with a particular output. This is exactly what AI is also doing. It is also searching for you, it is also screening for you, it is also analyzing data, extracting data. But the difference here is they do it very quickly. Okay, so that is what the moderator is trying to tell us, that regarding the efficiency. But my understanding is, it's not that we want the result very quickly. What we expect is the result should have like it should be in short time period, but it should be accurate also. So the point here is, see, if the while data mining, when generative AI is trying to look for data, if the base data is historically inaccurate, if the measurements given is wrong, or if it is being restricted by any other intellectual property rights and they don't have access to it, at that time, how will that intelligence think, is the question that we have to look up into. Can it think like a human being? In the past, no. Currently, we are like looking into that. So it improves efficiency with respect to quantity, but with respect to quality, we will have to look into.
So the human mind will always play a role. In fact, on that note, I just want to take this across to Neha, since you mentioned that you spend a lot of time actually also fact checking whether what you've got is correct. Now, given AI's, I wouldn't use the word tendency, but given AI's, um, possibility of throwing up these fictitious cases or case laws, uh, what are the safeguards that you actually undertake before you rely on the text of the AI generated or AI generated text? I mean, what kind of safeguards you have to undertake to ensure that when you actually file a petition in court, there are no fictitious case laws? Because I do recall very recently there was one where I think Justice Nagaratna pointed out that no such case exists. It was just made up by the AI tool.
Yes, so Justice Nagaratna had actually pointed out to this case, fictitious case, Mercy versus Mankind, and I often joke that it's actually the most famous non-judgment judgment that there is now. So yeah, so the main thing is that when you do particular research, so for example, you have put on the AI application or software that I need judgments on this particular issue. It will throw up a lot of judgments, but those judgments could be fictitious. And if those judgments are actually, you find that on the internet you have found the judgment, that the judgment is correct, at times the paragraphs cited are actually nowhere to be found in the real judgment. So every word, because when we quote a judgment in any draft, every word has to be the same as the judge wrote in that very judgment. So that meticulous matching has to be done. There is no running away from that.
So isn't that duplication of work then? I mean, you might as well go through the original judgment and reproduce it.
Yes, but what it does is, it can shortlist things. So as a good starting point, so for example, there's an issue and I want particular case law on that. So as a starting point, it will throw up judgments, and actually it improves with time. So in the beginning, it might have made mistakes, but now my AI knows that this is Neha Rathi. She does these kind of cases. She does a lot of public interest matters. She does constitutional law also. And so these kind of cases, and then when I put in that prompt. So one very important thing, of course, is what kind of a prompt do you put in? Which is something I think we are also learning as we go. As the AI is improving, we are also learning how to put that correct prompt so you'll get the correct output. And that checking, as you say, that one is able to do, because one is able to do a control F and find out, okay, these paragraphs are correctly there. So
Right.
that verification, double verification has to be there. With regard to translation, it's the same thing. So as you said, the one other thing is that AI works to please. At times it will not give you an objective output. So that is something one has to be very careful about. And as you said, the topic was, I mean, of this question you're asking is about hallucination. So yeah, so that's one has to live with. But I believe that as AI is also improving, new and new softwares are coming. We'll have specific. We already have actually specific softwares related to law only and legal research, which could be connected to, for example, a publication like SCC Online. And so these gaps could be bridged in the
with
very,
the
very near
with
future.
with the adequate tools and the requisite tools and the knowledge. I actually want to take off from where Neha left, that you need to have the right prompts. So I'm actually asking this question to Professor Jisnu. Uh, you're teaching law in a university. We heard in the earlier session, in the inaugural session, we heard Abhishek Singhvi saying that there's a world of difference between the time when they studied law and 30%. I think I recall he said 30% of the syllabus wasn't there. He didn't study cyber law and internet and all of that. And now, of course, students study all of this, cyber crime, cyber law. Do you think it's about time for law school like yours to integrate AI curriculum to give the students the right knowledge as to what is to be asked? What are the safeguards that you have to take in using AI? How can you use AI to enhance your efficiency and your productivity? To borrow his words, how to make AI your slave and not the master.
Yes. So I just want to make clear. So we just want to know whether AI can be a tool in curriculum building.
Yeah, no. Should it be a part of curriculum?
Definitely,
Because
definitely.
a lot of us, I mean, first disclosure is that I am completely almost tech challenged, so I don't know how to use AI. Perhaps the wrong person to be doing this session in the first place. But having said that, I think it's very important how you pose these questions and what kind of responses you get from the AI tool. So, do you think it would be better if your future lawyers, who are your current students, they are actually given a proper course on how to use, basically integrating AI into your curriculum?
Yes, actually, this is a very relevant and important question. And VIT School of Law have actually introduced artificial intelligence and law syllabus to, I think, 3 semesters before. Okay. And if you go through that, you will understand it is basically focusing on the law aspect. Definitely, the technical side is a little bit weaker on the syllabus, but it is a law subject. We have to follow multiple process to come up with a particular law syllabus. But sir's question was like whether technically you will be advanced by learning that particular subject. My answer is no. But what we are trying to do is, in order to bridge that technical lacking, we will call industry personnels, experts, cybersecurity experts, who will be telling them the technical aspect of it. And once they get to know a very good clarity on the technical aspect, rest we will take care. We will tell them how the entire world is, looking up to AI, how they are responding to different aspect. We have a lot of plans by the government coming up with, wherein they are planning to incorporate explainable AI in the governance system, that too in the critical governance system. So once you know the technique, we are teaching them how these situations can be tackled, how European Union is tackling it through their, how US is doing it. Does Japan have a act for it? So they will have a very clear idea about how law is responding to it. And the technical side, we are bridging it. Since we are a law school, we are
Right.
bridging it through industry experts.
Yeah, so law is going to be your primary concern. Vishal, as a practicing lawyer, I wanted to ask you that one aspect perhaps that everybody in this room would be concerned about or with is pendency of cases. Do you think, as a lawyer, earlier uh, Mr. Singhvi actually touched upon it, that our judges work far more than what their counterparts in other countries do. Yet we have such a huge, backlog of cases. Do you think there are areas where AI can help in reducing the pendency, in speeding up the process of decision making?
Right. No, so I think to answer that question, I would like to break it down into two parts. So one is with respect to the pending cases, and secondly, with respect to new cases coming in. Now, with respect to the pending cases, I feel that AI is actually already being used because so since COVID, the Supreme Court came up with an e-courts
Yes.
mode, and through which there have been different phases to it, through which they developed video conferencing. And like, for example, if you go to, I don't know if you've gone recently, if you go to court number 1 in the Supreme Court, there's a huge screen, and whenever constitution bench hearings are going on, it is being transcribed live on the spot through AI, and this was adopted 2 years back. So there are things which have already been incorporated by the Supreme Court, and of course on a broader level by all courts, where these tools are being used for aspects which can be delegated, so which is transcribing, which is document translations, which takes a huge time. Because so for example, in criminal cases, we keep saying they stay pending for 10 years, 12 years, 15 years, because the documents, like if you see them in hard copy, are like this. They will be like 30 volumes.
As they famously say, that the process itself is punishment.
Definitely,
You end up waiting for your
absolutely,
trial to
because
begin for
and
years.
correct. So and you when you have such voluminous records, it is going to take time. So but what AI really helps, and just to add to what the other panelists also said, that unless if you are relying on AI for summarizing data which is already with you, it is far more reliable than to ask questions with respect to the unknown. So for example, if you have case records which are voluminous or documents which are already part of record, AI can summarize them for judges, for the lawyers, give you just brief points that this is really what is in dispute. Because in a lot of cases, these in amongst the sea of documents, even judges and lawyers, we have to struggle, we have to spend a lot of time in coming to what is the point and how do we resolve it.
Right.
So there are tools like, so for example, transcribing translations, as I said, as well as document summary, which are already being used. So in that way, it will really help in pendency, I feel. And of course, case management, because so now recently Supreme Court also, because earlier the case list would come out. So now what they've done in the Supreme Court registry level is categorized all the cases into different categories, that for senior citizens, they'll be heard first, criminal cases will be heard first. So if you have, because there are like hundreds and thousands and lakhs
Right.
of cases which are pending.
I think a similar kind of system can be
Correct.
evolved where they track of these decade-old
Absolutely.
cases or a
Yes.
couple of decades, and then you fast track them and
Correct.
bringing.
And in that documents, if you can use the
Right.
AI to summarize it for the judges, it will be much faster.
Right. Thanks
Yeah.
so much, Vishal. Before I actually open floor to the house and take a few questions, I wanted to ask once again a common question to all you panelists. See, in journalism, we keep hearing that artificial intelligence is going to be the big disruptor. But as a practicing journalist and as a reporter, I believe that AI cannot really substitute the human element. The reporter always has to go to the field. He has to see for his check the facts for himself or herself, and report back as diligently as possible. In law, when you actually look at judicial decisions, there is an element of moral reasoning and conscience. Do you think that AI can develop a moral conscience and moral reasoning and conscience in terms of arriving at a judicial decision? To all you panelists.
Can I answer that?
Yes. Yeah.
Okay. So, if you look at it, when you want to reach to a particular conclusion, there are basically two techniques.
Put the mic a little closer
Okay.
to you.
There are basically two techniques. One is called frequentist, and the second one is called Bayesian technique. So, frequentist means you will just use the data and come to a conclusion. Bayesian technique means you will use the data plus logic plus moral conscience and you reach a particular conclusion. To be very precise, if you ask me, frequentist is used in cases like evidence, like if it is relating to evidence. Okay, so the data speaks and the data will answer the question. Whereas if it is an aspect relating to family law, if it is a criminal law, granting of bail, in those aspects, there should be an element of moral conscience also in that. So my point here is, if at any point technology can, the two techniques that I've told you, if they are able to convert that into a technological parameter that can be introduced into the AI, definitely AI will be able to think, but not in the past, not right now, but maybe in the future. That is my answer.
Yes. Neha?
I think I mean, right now, presently, I don't think so, because as you said, that human element is actually the main important part of any judgment. When a judge listens to a case, there are litigants at times in front of you or through their counsels. So that aspect is very, very important. Also, we need to be aware that any judgment is not just written in a mechanical way. There are a lot of aspects to it. There is the social context, there is the politics of the day. So there is a certain sensitivity involved, there is a certain morality involved, which right now perhaps AI has not gone to that level. Perhaps maybe the next stage of AI, which is the artificial super intelligence, which they say is going to be autonomous, it might improve to that level. But right now, I don't think that we have reached a point where judges or judiciary in that manner can be replaced by artificial intelligence. That's my take.
As a practicing lawyer, you would rather listen or take a judgment from a human being than rely on artificial intelligence.
I think so. I think so. It would because I mean I would not like a judge or any judge actually to hear a case or handle a case in a sort of a mechanical algorithmic way. It's better to hearing after hearing the way things progress. At times there are certain kind of circumstances in which a person is being charged of something. So these kind of things, and also you have to take into account a judge's own experience, his own upbringing, his own background. So all that, I think, cumulatively helps make a judge and helps them take decisions.
Right.
So Right now, I believe
We haven't yet arrived at that stage. Vishal, I just quickly want to add a point, basically following from what Neha says. While you expect a judge to have his own, his background, social background, his political background, everything come into play in judgment, though he will strictly go by the provisions of the law. But the counter argument is that when you have a decision making is done through AI, then neutrality is going to be of the highest order.
Absolutely.
Your take.
Because like even judges are more subjective, right? Like even if you have these cases which are going to different judges, like from one courtroom to another, there is that element of subjectivities which is always there. So if we look at AI as just another judge, then it's pretty much the same as how it's already working right now. Because if you see, I think
What about the aspect of moral reasoning and conscience?
I think what would be a little different, that's why I differ a little bit. I think there are aspects to law which can be delegated, which can be handled by AI, because you have a lot of civil cases, you have consumer cases, you have, like for example, traffic violations, which are all, which is also in backlog surprisingly. Those should not be taking so long because it's just a matter of fact whether this happened or not. So wherever it's something which can be easily determined through documents, through evidence which is already there, which doesn't require a human intervention or a human relook, those aspects I believe can be delegated, because then there's object, the neutrality is always there, and in fact then that may help in reducing pendency, because then judges can focus on things which require them to actually apply their mind, because have a lot of cases that we come across don't really need human intervention. It should be handled just by looking at the bare documents, and perhaps in that sense. But even on these aspects I feel it's that subjectivity is always there. But of course, you one aspect to is, and what is very fundamental to law, is that you get a chance for your lawyer to go and present your argument.
Right.
Because
So
you're briefing
basically,
the lawyer.
the point you're making is that there has to be a distinction between offenses that really doesn't require moral reasoning and offenses that where you actually apply your mind to arrive at a decision. Thank you very much. So we want to open the floor now to question and answer. Please identify yourself and yeah, ask your question, and please be brief. Yeah. The light is against me, so whoever wants to answer a question, please stand up. Tanisha, can we get him the mic, please? The gentleman right here. Okay, the lady. Yes, please identify yourself, and also
Myself,
identify who do you want the question addressed by? Who are you
myself,
directing your
Vedish,
question to? Yeah.
myself, Vedishri from third year VIT School of Law. This question is to all the panelists who are here. The cost of AI systems for the legal drafting like SCC or Manupatra or India Current Prism AI is less cheaper and less accessible due to high premium payments. What is your take on the accessibility of the same?
Okay. Should AI be more freely, easily available so that everyone can utilize it? Okay, because right now these are all subscription-based models which are very costly. Yeah, whoever wants to
Right
take.
now, for little things that we are using it as an AOR, for example, my office uses it. That's not; these are not subscribed. So, for example, we may use Claude or Note LM. These are not the subscribed versions that we are currently using. Of course, SCC, yes, very expensive, and similar Manupatra and everything. Those subscriptions one has to take. So students can actually just make use of if they're, their universities or their colleges are actually providing, and many of which are, so they are providing those subscriptions to students, and later as they get into the field in their offices, generally provide that. So I think even with the what is not charged, like major these softwares that I talked about, these can be used to a large extent, I believe.
Right. So the free versions are still accessible to students. They can start with that. Yeah.
Yeah.
Please identify yourself.
Yeah, I'm Advocate Nitin Khanna, practicing in the Delhi High Court. Advocate Nitin Khanna, practicing in the Delhi High Court. First of all, I'd like to congratulate you for the wonderful moderation and the wonderful knowledge you have just given. My small apprehension regarding the use of AI is that now, of late, there were some articles saying machines are talking to each other. And if the quantum computing and AI come together, they become very fast, much faster than the human imagination, and they can control us. So it's very good. Grass is on the greener on the other side. We see the positives of AI. But what I would like to ask all of you is, what are the precautions we have to take while using AI in the legal fraternity?
Yeah. I think
So the darker side of technology,
right.
what
And
he's
that's a
pointing to.
broader question about how much ethics and AI, I think, have to marry each other. But I feel, especially in the field of law, I think, like what we already discussed, there needs to be an awareness of what AI can do. So whenever we use AI, we have to be very smart about it. We should not be using it for purposes like research, like drafting, also as to a large extent. But if it is used in a manner where we are aware of its capabilities, then I feel it can never be in a position that we are over, like, it's overshadowing our thinking, because as you said, like, the element of human thinking will always be retained. But yeah.
So I would like to add few points on this. So here we are
So
actually
will you just take the
yeah.
mic?
So actually we are discussing about due diligence. And with respect to using technology, due diligence is divided into two. One is the due diligence that have to be taken care by the person who is using it, and due diligence that have to be taken care by the AI vendor who is offering you with the technology. So there are certain parameters. So if I am the user, I should be aware, okay, this is the accurate AI that I'll have to use. Whether I can use it. Am I compliant with the regulations or legislations that is currently existing? That is and when I'm using it also, I should be within the line of reasonableness so that there won't be any legal repercussions. With respect to the AI vendors' responsibility or due diligence, they have to make sure that whatever data we are, asking it to process. So basically, security, privacy, those due diligence aspect have to be looked into them. Then only that balance. And your question whether machines will be taking over. See, that is a hypothetical situation which can happen. And we all know that Isaac Asimov's three rules that have already always existed. Okay, so that will be always there to safeguard also, hypothetically responding.
Thank you very much. I think one person, one question. Any other person?
So, good evening. My name is Shahab, and I've come from Uttarakhand to attend this workshop.
Thank you very much. Yes.
Especially because it was hosted by the Hindu and VIT, which is what I'm affiliated. This is the kind of affiliation I'm coming from.
Right.
The first 15 years of my professional work were into IT, and I was selling Intel processors and all of that. The last 12 years, I've been working in very remote areas of Uttarakhand,
right,
among people with disabilities and all that. So I come from two different extremes. My question is, I feel that in with the sense of AI, a lot of issues which are related to public relief are too far from being resolved from the artificial intelligence, is the kind of people that I work with, which is the majority of this country.
Right.
I also feel on the technology front, after 5 prompts on the any of the chat box, you see that I feel that the artificial intelligence is equally stupid as a human being is. So after, so you have to come with your own ideas. My question is legal. With the background that I've given, I've drafted this to make it simpler because there's a challenge that I face in everyday life, which is I'm using the word everyday life because I work with the people with everyday struggles. And my question is that my work hinges with the RPWD Act 2016. And I feel that it talks about the reasonable accommodation, which is widely misunderstood. Uh, I feel that there's in the administrative processes. Now, this is a challenge that I see, and I've tried to make it as simple as I can. I feel that there is it has devolved into a de facto trial where the burden of proof lies entirely on the citizen rather than the state's duty to serve. I could,
Who would you want this question addressed by? Who are you direct?
Anybody.
Any of the lawyers? Okay. So what can you just make it very sharp and
if I put it in the ordinary, the common man's language,
yeah,
all the statutory information, all the public schemes, everything
yeah.
which can be accessed by the common man are being mechanized by the intermediaries. So how do we resolve this? This is a situation of a common person, which is accessible. What I'm trying to say is that things which are accessible are also not approachable.
Yeah.
Okay. So, sir, I think with respect to the Rights of Person with Disabilities Act, and you rightly said there are several of these laws which are meant to enhance the life of general citizens, but because of awareness, because of implementation, or several bottlenecks at the administrative level, the due information is not going out, and the mechanisms are not in place, which are required to implement them. So I completely understand, because sir working in the field would know better the challenges which come on a day-to-day basis. But yes, because the Supreme Court on a fundamental level or with respect to the law has been preaching that these laws which are meant to protect uh, uh, citizens and enhance their rights are implemented in due course. So it's of course still a developing field. I feel even AI can assist in that, because even government machineries have started using AI or enhancing their websites with to spread more information, to make access more it's like to make justice more accessible and share information. So I think still a developing field. I think there's still more work which has go into this.
Yeah, so we've almost come to the end of this session. Very quick question, because I
Yes.
just barely have 60 seconds.
Yes. Good afternoon, everybody, and thank you very much, sir, for this opportunity. My name is Yash Harshvardhan. I happen to be an advocate, and academically, I'm an engineer also.
Right.
So, therefore, my question is that how detrimental is artificial intelligence in the intellectual growth of advocates, particularly young advocates who have just entered the profession? I mean, like when we entered the profession, we were more accustomed to reading files and case laws that ran into thousands of
I get the drift of your question. Will AI make lazy advocates?
Thank you.
That's a very interesting, very important question. I'm glad you raised it. I agree. I agree with this because, for example, there is a particular the way we also started out. There you would be so many files, and you would go through everything, and you had the brains. You had to cultivate those qualities and that craft to actually take out what is relevant. So that is very very important, and no amount of AI can actually teach you to do that unless you do it by yourself. At the same time, the fact that, as I said, you need to do due diligence, you need to check everything, every kind of output. One would be able to do that only one is able to do without AI also. So you can only check the output once you know that, okay, what kind of thing would be able to do, even if AI were not there, only then you can actually check. So that is definitely there. It would make lazy advocates for sure, but that is where one has to be very very careful. So many times, for example, AI can be used to just simple grammatical errors. All of those could be checked. So that
Right.
doesn't mean that the advocate doesn't need to, improve their own.
Our time's up, but I think I've just been told by Raman that there can be one more question. Very quick, short question. Sorry.
Yeah. Okay. My name is Sarah Sani. I'm working with, I take cases in the Supreme Court. My question related to AI, like you mentioned, the Supreme Court, courtroom number 1 has live captions, but let me tell you, captioning is not 100% precise. I am a deaf lawyer. I go inside court and I use live transcription a lot, but there are a lot of words which it misses out. So AI actually does also have challenges. Also, as a deaf person, they are not fully, they haven't got an education in English. So there is an English bias in AI. What would you like to think about
Thank
that?
you so much. Thank you for this wonderful question. Yeah, which one of you would like to take this?
I would like to answer to that question. See, even technology is also technologically backward when it comes to a situation like this. Okay, so this is a major issue that have to be looked into. Okay, thank you for bringing up that particular point also. But this forum, I don't think any of us are capable to answer the technical question, but I'm very sure that there will be a point wherein all these parameters which will also be looked into and added on to the technology. Because if you look back few years back, we just had like very few information that we could gather, but now it have changed. Errors will be there. Error correction is the main idea, and once that is done, we will be actually using AI for our own betterment.
Yeah, thank you very much. As I said, time's already up. Well, I was thinking of summing it up, but this is a wonderful way to end, as Shreya pointed out, as both practicing lawyers, Neha and Vishal, can perhaps take it up with the Supreme Court that challenges that even technology has. And to sum it up, as in the inaugural session, we heard the chief guest saying that technology can be a good thing as long as you make it work for you instead of the technology working for you and you become a slave. Rather than that, make technology your slave, and you should be always in control and command of the situation. With that note, thank you very much. I hope I kept you guys awake in this post-lunch session up to the next session. Thank you very much from all of us.
Well, as Sandeep said, you got to be in the saddle. Well, for this moderation, he was definitely in the saddle. Thank you so much for a great session. Before our panelists leave, Sandeep, I'm going to request you to please present a small token of appreciation to each one of our panel members. To Mr. Vishal Sinha, Advocate, Supreme Court of India, also to Ms. Sneha Rathi, Advocate on Record, Supreme Court of India. And to Dr. Jishnu J.R., Head of Department, BBA LLB Honors, VIT School of Law, VIT Chennai. Thank you for conducting this session with aplomb, Mr. Sandeep Pukan. So nice of you. Thank you very much. Big thank you to all our panelists and the moderator as well. You're most welcome. Steps ahead. Right, ladies and gentlemen, done with one panel discussion, but there's more to come. And ladies and gentlemen, without further ado, let's get into our next session. This one is titled Fundamental Rights in the Digital Age, the Constitution's Response to Emerging Trends. This, of course, is going to examine the intersection of constitutional law and digital age. Ladies and gentlemen, the panelists will deliberate on how the Constitution of India provides a robust framework for safeguarding fundamental rights amidst rapid technological advancements. To take this session forward, please join me in welcoming Ms. Aratrika Bhaumik, Senior Sub-Editor Digital, The Hindu, who will be the moderator for this session. Here she comes. Pleasure to have you here with us on stage, ma'am. May I now invite our panelists and our speakers, Mr. Shadan Farasat, Senior Advocate, Supreme Court of India. Pleasure to have you here with us, sir. And thank you so much for taking time out today to join us. May I also invite on stage Mr. Gopal Sankaranarayanan, Senior Advocate, Supreme Court of India. Thank you so much, sir, for being here with us today. And I love it when people have a spring in their step. And also, may I invite on stage Dr. M.S. Sharmila, the Head of Department, Center for Postgraduate Legal Studies, VIT School of Law, VIT Chennai. Stage is yours now, ma'am.
Hello and good afternoon to all. I hope I'm audible. So we have a very interesting topic for this panel discussion. We are at the cusp of a new reality. The very existence and the exercise of fundamental rights, whether it's privacy, right to information, free speech, is now highly contingent on emerging digital power structures. So the intent of the session will be to explore how courts are responding to this shift, and also what happens when judges are made to determine cases where there are conflicting and competing fundamental rights in question. We, of course, have a brilliant panel with us today. We have Mr. Shadan Farasat, Senior Advocate at the Supreme Court of India. We have Mr. Gopal Sankaranarayanan, Senior Advocate at the Supreme Court of India, and Dr. Sharmila, who is a Professor of Law at VIT Chennai. Now, I would like to start off this discussion with some recent observations that we have seen made by several benches of the Supreme Court regarding the need to come up with regulations to regulate obscene as well as abusive digital content. A lot of concern has been expressed by the Supreme Court. So, Mr. Sankaran, if I may begin with you, A, do you think that regulations are required? Is there a regulatory void in the first place? And B, what guardrails can there be so that there is no disproportionate restriction on such speech?
First, let me thank the Hindu group and with Saul and everybody for having us. And thank you for an excellent question, Aratrika. I would like to take one step back from where your question starts and figure out why the Supreme Court is getting into this. Obscenity and content which people put out, language that people put out in any format, leave alone digital, has been the plague of civilization for centuries. I think we spend way too much time worrying about content which is obscene or annoying or irritating or anything which gets in the way, which is the reason why the court had to strike down a provision of the IT Act specifically in Shreya Singhal. I don't think it's the Supreme Court's business to get into trying to regulate society. And so their advice is best kept to themselves. I don't think we need new regulations to deal with obscenity or any of these other ways that individuals and groups engage with each other. Having said that, I personally don't see a void. I think the law has, in fact, over a period of time, reached a certain level of balance with reference to these kind of issues of where free speech may go towards the precipice, go towards the borders. We have very clear principles in our constitution, in Article 19.2, saying that the state can regulate only speech to a certain degree. It has to be reasonable. And it has to be to ensure that you are not in any way impinging on friendly relations between states. You're not inciting violence. It's not slanderous or libelous in any fashion. Those are broadly, and public order is not being affected. Now, the law is fairly crystallized on that. Now, every new piece of content that is uploaded on YouTube or Instagram or anywhere cannot be the reason that the court step in and start saying, look, we need to regulate. The only thing that's changed is that from a fourth estate, which was a media which used to put out content, now every single one of us have become part of the fourth estate. So all of us put out digital content, right? That's the only shift, but that's only a shift of platform. I don't really see the need for regulation.
Thank you. Dr. Farasat, what is your opinion? Now, a bit of more context to this. The union government has heeded to the Supreme Court and it has said that it will come up with regulations under the IT Act, especially to define what obscene digital content is. Now, a lot of experts as well as stakeholders have remarked that it's an over broad definition, it can be misused. Do you share these concerns? And of course, responding to what Mr. Sankararayan said, do you think the Supreme Court should venture into this in the first place?
Yeah, thanks, Aritrika. Another very nice question. Now, I'll also just thank the Hindu group for holding this amazing get together. I can see a lot of young faces in the crowd, and it's always amazing to brainstorm with the youth. I'll answer your second question first. So, I do broadly agree with Gopal that it's really not the Supreme Court's business to get into it. I see it for a slightly different reason because there's an inherent risk when the Supreme Court itself is directing a regulation to come in. If the regulation is problematic, who's going to test it? The court itself again. So if the initiation happens from the court, then there is a problem in the way that regulation will be tested, right? So even if there could be situations, I mean, I don't think we can always say that in every situation the Supreme Court, there's a clear gap, there's a problematic gap. There is no action on behalf of the executive or the legislature. I think they can very broadly suggest do something about it, not go into the details of it. And then, of course, they'll have to test it if it's overbroad because governments, as they go, I mean, that's the experience from history. They'll always use these opportunities to sort of get more control over the speech which is happening in the democracy, right? And so they should come in only in the rarest of cases and only in the broadest terms, if at all. Otherwise, they should stay out of it. On that, I agree with Gopal. In terms of Should government define obscenity? Is there a problem there? I do think yes. I mean, obscenity, anyways, you don't want the government to be defining much about free speech at all to begin with. It should be very, very limited role for the government. Obscenity is anyways very subjective. It's not open to a very objective, clear-cut definition, which will, which can be applied in all contexts. So a general definition of universal application by definition is not possible in a case like obscenity. So I think I do agree with whatever the critique that it's quite problematic.
Thank you, Dr. Farasat.
Just one correction. I don't have a PhD. I'm only Mr. Farasat.
Oh, sorry, Mr. Farasat. Dr. Sharmila, what is your opinion on this? Do you agree with the other panelists here?
Thank you. My observation here is that if Supreme Court does not give the guidelines, then where will we get the remedy? When you check the world, other countries, what are the remedies that they have given against this freedom of speech or expression, that too in digital age? If you look into the EU regulations, they put the blame on the private actors, making them accountable instead of giving all the work to the Supreme Court. Already we do have backlog of cases, so it is the private actors' accountability. And not only that, we should take a preventive measure, not that should be a proactive one. As a freedom of speech and expression, that too in the digital age, where an algorithmic society today where we live in, it's very, very important. And if it is not regulated, if that regulatory vacuum is not filled up, then that will be leading to serious issues. That is what my idea is about.
Thank you, Dr. Sharmila. Now, moving on to the right to information. That is a very important constitutional guarantee, a fundamental right. Beginning with you, Mr. Farasat, do you think over the last couple of years we have seen an erosion of the Right to Information Act? And especially if you could comment on what your opinion is when it comes to the amendments made to the Act through the Digital Personal Data Protection Act.
Yes. So on the RTI, I think I would say over the last decade, really speaking, the act has become ineffectual because the kind of experience you get right from any authority, you don't get any answers. They maneuver it around from one department to the other. If you go to appellate authority, you will get a negative. The exemptions are applied in a way overbroad fashion to deny you information. And the authority themselves and the appellate authority do not act at all. So it's been effectively, as far as I see, it's been heavily de-operationalized, the act, in the last 10 years or so. We saw a very assertive phase of the RTI in the first 10 years, and I think we have seen a very dead phase, if I can use that term, in the last 10 years. So even with it being on the statute book, it's for all practical purposes, you're not getting any information which can be even remotely problematic for the agencies, the government, the entities, etc. Right? So all of that is shut out using the exemptions. Now, insofar as the Act is concerned, the DPDP Act amendment, and especially like 81J. Now, 81J, the classic form of Section 81J was just for the uninitiated. It really balanced the right to privacy against the right to information, and it gave the power to the authority that even if there was something which was private in nature or personal information, you could, in larger public interest, release it. A classic case would be a degree of a MLA or a member of parliament or something like that. Now, the DPDP Act seeks to take away that exemption and that power that in larger public interest, you can't do it. So obviously, even that limited balancing, which was already available in the Act, that is being taken away. And I think right to privacy is being used in a fashion it was never meant to be. That is to protect the so-called privacy of those who are in public spaces. See, when you're in a public space, your amount of privacy you will enjoy will be much lesser. It will be limited to your family zone or your immediate, personal life, and not to a lot of other aspects which a purely private person would. So I think it's hugely problematic. It actually is being misused, if I can say that.
Right. Mr. Sankanarayan, so we saw the Supreme Court refuse to give an interim stay on the amendments to the RTI Act earlier this month. And very interestingly, what the Chief Justice said is that there are competing fundamental interests, a bit of which, of course, Mr. Farasat explained that you have the right to information vis-a-vis the right to privacy. What is your opinion on this? And of course, if you could comment on the amendments itself.
I have a similar view to Shraddhan. I think any right minded student of the Constitution could not but endorse the same view that the inroads that have been made into the RTI Act as they first stood with reference to how often you would dilute the protections which the Act afforded by giving excuses and using small clauses to escape. Any good bureaucrat is always well equipped to find loopholes. So they would say it's third party, or they would respond within a month saying you have not submitted in the proper format. And then you would go through the appeal process, which would meander its way. And then, if you've not lost your energy by the end of it, they will possibly remand it back, by which time they'll say, we don't have the information in the format in which you want it. So you can imagine how tenuous it was. Occasionally, information would filter through, but it usually was not information of a public nature. So, for example, if there is a small revenue record which has some correction and you need to get the revenue records, they may get it. But if the revenue record is dealing with farmlands which is held by a member of parliament outside of Bangalore and he doesn't want you to get it, they'll find a way for that not to be obtained. Now, this amendment is particularly problematic because there was an existing proviso which gave the power to the public information officer to share the information or to withhold if he thought that it was against a particular public interest. Now, by dropping the proviso, that discretion which is available with the officer is gone. And the DPDP Act now brings in penalties of up to 250 crores. Now, you can imagine no officer who's sitting there in right to information is going to sit there and run the risk of this being brought down like a cosh on him. So I feel that it was ideal for staying by the courts. Far be it for me to comment about them. But I have felt over the last, say, 10 years or so, I feel that courts by and large have stopped exercising the true judicial power of stepping in and taking tough stances. They prefer to just say, not right now, we'll see it after a while, let a reply come 6 months later, and then many issues die their own natural deaths. I'm seeing this personally in the SIR case. I've seen this many, many times, too far for it to just be a coincidence now.
Right, well said. In fact, if you could also talk about what do you think the judiciary's response has been when it comes to the vacancies that we see, widespread vacancies in information commissions. So, do you think, I mean, of course, we've had orders where they have set timelines, but then either the cases are not listed or there is no real enforcement or even accountability when it comes to the center fulfilling these vacancies?
No, but look, a large part of that is administrative. So I can understand if these were judicial officers, then you would place the blame at the judiciary's door. But with understaffing elsewhere, including in CPIOs, etc., it's actually an administrative concern which the administration should take up, on a war footing. It is in their interest not to take it up. So they don't man the authorities, and I don't really see what the courts can do unless you line up all the chief secretaries as usual every 3 months. Shadan has been defending chief secretaries inevitably in many of these cases. It's a tough ask because eventually the chief secretaries, you line them up and you tell them to come to court, and they miss out on something else that they have to do. And what are they supposed to do? Where are you supposed to find these people from? And when you find them and they man the resources, the law has taken out the teeth. So then what are they supposed to implement?
Right, right. Dr. Sharmila, what is your response to this, especially when you look at the amendments where, there's a blanket prohibition on any personal information, even when there is an overriding public interest. So do you think that's a cause of concern?
Yes, I take the similar view of my panel members. The Section 44, Class 3 of this DP Act has amended 8 Class JI of, as my fellow panelist said,
That full form
Digital Personal
Digital Personal Data Protection Act.
has completely denied this right to information. So it is no more right to information, it is right to deny information. And no more you can get any details, personal details of any public official. That will not be given. So this right to information act and the power being lessened.
Thank you. Now I'll move on to something which is very interesting. In fact, it is going to be a lot of interest for law students that we have here, and of course, legal reporters as well. Now we've come a long way from the Swapnil Tripathi judgment, which cleared the deck when it comes to live streaming of proceedings of public interest. My question, and I'm going to start with Mr. Farasat here. Where do we draw a balance? Of course, it has democratized courtrooms, but we are also increasingly seeing oral remarks of judges being taken out of context. So, as an institution, does the judiciary really draw the line when it comes to such access?
See, I think drawing the line is not too difficult, like in terms of theoretically. The idea is that you cannot splice the different portions and sort of play them, right? The challenge is technologically. How do you prevent it? Because if you are only putting it in YouTube, the entire proceedings, there's no risk. Like everybody will get the context from the beginning to the end, and they're pretty educational as well, right? Like even for law students, when we were lawyers, we didn't know what was being argued in constitution benches when we were law students. Nowadays, of course, law students can see all the arguments online in CBs. So there are a lot of positives. You can restrict it. You can say there can be a diktat. You can say that you cannot splice portions and play it. But how do you implement it? That's the challenge. Technologically, how do you restrict it? I think that's where the challenge is. That once it's out, how do you restrict? Because till the time you can splice it, you will put it in a in a 5-minute video with 10 seconds of something, and then have your commentary on it and all of that. That's where the misrepresentation happens. So I think really it's a technological question more than a legal one, and I don't have an answer, to be honest.
Mr. Sankaran, what is your opinion?
I actually feel that there is something that the institutions can do, because after all, the content is being put out by the institutions, by the courts. And I think much like C-SPAN in the US, the courts must take the responsibility of ensuring that the data cannot be either replicated, redistributed, etc. And it's only through official channels that it goes out. So if you have a Supreme Court's YouTube channel, that's it. And I'm sure the guidelines or even regulations can be laid down, because Supreme Court has an administrative authority as well, where they'll take action against people who add their own content and mislead and misrepresent. Because very often, um, this is actually reflective of a larger problem, which is that quite often I've seen lawyers themselves, because we are not a undistinguished tribe. We try our best to up the ante when it comes to the cameras, right? And when you're conscious that you're being watched, you find entirely different arguments and drama being inserted. I mean, many of us don't. I mean, it's not something that's lost on us. We know that that's why it's happening. The judges know why it's happening, and it would be best that it doesn't happen like that. So it's not only to regulate how exchanges happen and what the courts actually said, the context in which it's said, but also helps regulate the profession to a degree, I feel. So I think it's necessary that we have only full content, and you don't splice it. I take what Shadan says about it being a data or technological issue, but I feel it is possible to be regulated. There's no way, in my view, that lawyers should be putting out content, because very often you see lawyers advertising for themselves by saying, so proud, look, I appeared, I managed to get this file thrown back in my face, that kind of stuff, and they put the video up for 20 seconds. I don't think that it does any favors to the institution or how the very solemn task of justice is dispensed by the courts.
In fact, if I can talk about the coverage of the stray dog proceedings, right? We saw oral remarks of judges being going completely viral, lot of remarks being made, lot of outrage on social media. So when it comes to these sensitive proceedings, how do you think, I mean, what responsibility lies both on the bench and the bar in terms of possibly being restrained, more careful? Do you think such a responsibility lies at all? Or do you think that would hamper genuine courtroom engagement?
No, 100%. I think there's responsibility on the bar less, very honestly less, and much more on the bench, because it's not the bar's remarks that's being reported as headlines the next day. It's the bench. And the judges on the bench know this. The judges who belong to the traditional school, who don't want to shoot their mouth off and make responses for every argument made, they continue to be restrained. But those judges, and we know it, while the arguments are going on, Shadan and I know, we've sometimes turned to each other and exchanged a glance, because we know the judge is saying that because he wants it in the headlines in the paper the next day. Let's be honest, that's why he's saying this, right? Instead of making these comments, put it in your order, right? Don't tell me that Article 21 protects liberties and freedoms and then deny bail to Sharjeel Imam, who's been inside for 5 years. Don't tell me that. Either don't make these comments, or go ahead and give them bail, write it in your judgment. that makes a difference to me. But otherwise, I don't see these oral remarks taking anybody anywhere. But unfortunately, people like you in the media are also forced to report it. Everybody is reporting it, right? As if it's a comment from the court and this is what the court has said. And you find very often young lawyers, students, etc., saying, "I remember a year ago, the Supreme Court said this. Let's find the judgment." There won't be one. There's no judgment or order which will say it.
Oral remark.
It'll be oral remarks.
Dr. Sharmila, yes. What do you think? This is concerning. Is there a solution that you can think of?
Yes, the model rules on online streaming, that gives you these solutions as of any sensitive issues or discussed in the court. The judge can pass for 10 minutes. So that regulation is there. And not only that, the any family court issues or sexual harassment issues where they need not discuss in the open court, where the public trial and the open trial is part of a fair trial that been given, the right being given under CPC as well as part of 1011 of the UDHR, that is Universal Declaration of Human Rights. And during COVID-19, you know very well, we all entered into the virtual court hearing thing. So as of technology is evolving and we are going to compete with the robotic lawyering chatbots, the future is there where this technology has to take place actually, and the virtual hearing has to be moderated. Thank you.
Right. Thank you. So now that we see that, like I mentioned at the beginning of this session, that the exercise of fundamental rights is increasingly being dependent on digital infrastructure. Mr. Farasat, beginning with you, do you think we are seeing progressive rulings, especially if we were to talk about Justice Pardiwala's bench in Amar Jain versus Union of India, where the bench interpreted right to digital access for an asset attack survivor to be a fundamental right under Article 21. So, do you see the court also interpreting fundamental rights more progressively?
Yes, I mean, the judgment you mentioned, yes. There is, of course, there are areas in which digital rights for, say, people impacted with disability, that's been interpreted quite positively, and that's necessary. But overall, is it progressive? The jurisprudence of the Supreme Court, it's probably pretty patchy, is what I would say. Again, it's very bench specific. Like everything in Supreme Court today is bench specific, right? Because there's no one Supreme Court. You have one matter go to one bench, and that's what we as counsels, appearing in matters next day think, okay, how do you approach this particular judge on this question? They're like two different, not two, 17 different Supreme Courts, as the saying goes, right? So is there one jurisprudence? Answer is no. There have been good judgments. And on some issues like disability, definitely, I think by and large has been uniform. I think since the time of Chief Justice Chandrachud, he brought it in a big way. I think on that, his record was quite exemplary in the sense that he brought in a lot of other people, other judges, sensitized them to it. Also, the bar got involved in it. And I think that work has continued, even him demitting office as the Chief Justice. But on a lot of other aspects of digital rights, when governmental interest comes in a big way, courts can seem to be balancing a lot more than they should be. That also is a problem. Either like by what Gopal said, just kicking the can down the road, like not deciding it because you don't want to decide, it's a problematic decision, or just balancing when you don't need to balance. These days you have so many overbalanced judgments that it's just refreshing to see sometimes judgments which are clear, convincing, taking a side. So I would say it's a patchy record. That's
Right. Mr. Sankaran, do you see this as a doctrinal shift? And also something very interesting that Mr. Farasan mentioned, right? The polyvocality of the Supreme Court. Do you see, at least in the recent past, a trend emerging of inconsistent precedents, especially by coordinate benches? Do you think that's a concern?
It's a very serious concern. I've seen it a lot in the last 5 years, and the regrettable change, if I can call it that, has been that after judgments, final judgments are passed, and the judge who has penned it has demitted office or retired, you suddenly find the next bunch of judges reopening those cases and taking with the march of the law in a completely different and opposite direction, diluting very often what has happened. I mean, just in the last few months, we have seen that happen with whether you like it or not. I'm just telling you how it's happened. Justice Pardiwala's judgment on stray dogs, diluted, altered, modified, changed, went to a larger bench. It was the final judgment. Justice Pardiwala's final judgment on the governor's sanction. Suddenly, a presidential reference comes in. There's an attempt to try and dilute that. Uh, this ex post facto clearances, environmental clearances, Justice Oak's final judgment. It went after he had delivered it. The review is taken up by three judges headed by Chief Justice Gavai. The original judge dissent saying, how can you even reopen this? But the other two go ahead and steamroll it. So these are just three large public interest cases that I'm referring to. There are dozens more. And I don't think in the 75-year-old history of this court, we have found a trend like this at any previous time in its history. For me, that's deeply disturbing. It's not about government, not government. It's about institutions. And if institutions can't promise citizenry consistency, then we are gone.
And it sends a wrong message to the lower courts as well. But I mean, do you have any institutional reform in mind which can possibly address this?
I think institutional discipline needs to come from within. So I feel in judicial selections, which has been a bugbear of the court for a long time, I think too often the selections of judges are being made for the wrong reasons and for completely extraneous reasons. And that's been something that the institution has been grappling with. I don't think we necessarily choose the right fit. Um, Shadan, between Shadan and me, we have a few years difference, but that's the age group of people who are ripe for appointment to the High Courts right now. We know many colleagues of ours, very promising, excellent advocates, really vocal, smart, got integrity, got intelligence, right? Their names get proposed by the various high courts and it just goes in a cold freeze. Now, if the Chief Justice of India and his collegium wanted to push those names through, no force on earth can stop it. But they don't want. And that's a question they have to answer. So many of these really excellent candidates have withdrawn candidature, saying, how long are we going to wait? Because after a while, you wait 18 months, 20 months, you start appointing all sorts of people you know are absolutely mediocre. And then you wonder, why the hell am I doing this? Because eventually, when you're called upon, it's a call for institutional virtue. And you find that the collegiums are not of the same mind as you are.
Right, Mr. Farasad, you want to add
Just
something?
quickly, on the fragmentation question, I think the line has to be very clear. It's not a personal viewpoint of each and every judge. Once the court holds something, it has to stick. It's important to have some things decided finally rather than having it decided right or wrong. Only if it's an exceptional kind of a error which has been made will you correct it. Certainly you don't start correcting judgments every year, right? Like you have one decision which is given, like Gopal said, the judge superannuates, and then another set of judges within the next year revisiting it. It's just totally destructive for the system. I argue before high courts as well. What do you argue to a high court? How does a high court judge see what is the law? There are 6 different versions of the law before him. Which one does he pick? Right? And so it's very, very difficult for everybody in the system. So it has to, the threshold has to be very high. And only if it's completely erroneous view do you revert. Some views, of course, with passage of time, they become erroneous. Like, views taken in 1960s on, say, some kind of freedoms will today be totally, could be obsolete, right? So that is with passage of time. But this business of changing every time, bench change, is destroying the system completely.
Dr. Sharmila, I'd love to hear your views as a professor of law. How do you really see this inconsistent jurisprudence being said? And even when it comes to interpretation of fundamental rights, it's getting purely discretionary.
As of a digital era, even all the institutions are stumbling with the AI technologies and the blockchain technologies that are evolving. As a law professor, initially I started with the ordinary contract, and after that I moved on to the standard form of contract, and now it is smart contracts. No more the old contract regulations applies to smart contracts. So accordingly, we should move ahead. And this digital access right is a new evolution of rights where if you look into the EU GDPR, it has accepted this digital access rights. And not only that, the other new rights like right to be forgotten and right to eraser. So these are the new rights which been accepted, which also applies, has to be applied as of our country is concerned.
Right. The last question for the panel, which is that how do we as a country increase digital literacy? Now, of course, we are consumers. We consume AI, all forms of technology, but we are not seeing critical engagement of the public with digital infrastructure, questioning digital power structures. How do you think such a culture can be cultivated in the country? Mr. Farasat, if you could begin.
Yeah, I think before we can, because the landscape is changing so fast, especially with AI coming in, right? So I think the first thing we have to understand is what is the information that you are giving to, I think there has to be education on what is the information each of us is giving to these various apps, to AI chat forums, etc., right? Because until we understand what we are giving and how it's being used, how do we even seek to regulate it? Even I'm a senior counsel in the Supreme Court. I also don't know what exactly Chat GPT does with all the questions I ask it, right? Is it going to monetize it? Is it going to use it in a certain way? I also don't know. So there's complete lack of information. So I think the first thing towards regulating this is to have a publicly informed, a base about what this means, and then we can think about how to regulate it. I think that first step itself is lacking as of now.
Right, well said, Mr. Sankara. And also, if you could also respond to what he mentioned, which is very important, that even when you see laws being passed, DPTP Act, for instance, a lot of stakeholders and experts were upset that there was no real public consultation. So, how do you see this? Do you think it's a cause of concern?
Yeah, so two completely different questions. So I'll answer this one first. Well, I think correct me if I'm wrong. I understood that there were notifications put up in December 2025
Right.
or 24. I think inviting objections, etc. Correct me. I was under the impression that there were uh, I think invitations for consultation, but like it's linking this to the other question on digital literacy. If you're not literate enough on this issue, then there's very little that you can really engage with reference to regulating it and going forward. There are many problems with the rules and the act as they've come, and I think a large part of it has to do with the immediate taking away of your right to privacy right now, while giving your remedies only in 2027, which is how the rules operate. So that's as far the rules are concerned. But on digital literacy, I don't see digital illiteracy as a problem.
Okay.
I actually like the fact that we should have greater digital disengagement as a parent of three children, particularly, but also from the point of view, I think, of the public and the dangers of AI. I feel that the one thing that can save the world from the greatest travails of AI, because it's overtaking us at such a frenetic pace that we have no clue, right? It's really insane. I was just looking at those Chinese robots climbing mountains with machine guns, and I was just thinking it's crazy. We are nowhere on the same planet that those guys with development. Now, you've seen Hollywood cinema on this for the last 30 years about how the fact that you consider yourself disengaged from the digital world actually helps you. If at all there is one country which can stand against this, the overtake in the world, is India, its illiteracy and its digital distance. However much we frown at it and say it needs to be bridged, I'd be quite happy if all of us actually disengaged from it and went back to paper and pen and took it the old way. I don't see too much of that as a drawback, right? I see this digital addiction, this need to actually go to Google every time you disagree with somebody on a piece of trivia. I see all that as problematic. So I'm quite happy with us being digitally illiterate as much as possible.
Dr. Sharmila, your concluding thoughts, please.
Yes. Digital literacy is a foundational skill as of today in today's context. As of digital literacy is concerned, my fellow panelist was telling that being a Supreme Court lawyer, the Gen AI, how it works. So that is why for our students, we are training the prompts, legal prompts, how to operate the chat GPT in order to get the best answers. So we are in the need of the hour to train our young generation. As I said, being the father of three children, disengagement. Yes, we have started the vehicle and we must know where to hold the brake. So that part of training is required as of today's context.
Thank you, Dr. Sharmila. We'll open the floor to questions now, please. If you could please state your name and also who the question is directed to.
Yes, my name is Avantika and I'm from VIT Chennai. My question is basically directed to Gopal sir. So, obscenity is based on morality, and morality is subjective, right? It's an evolving concept right now. So, now that technology is in the picture, it's blurred the lines of what is morally right and what is morally wrong. My question is regarding the approach that the young minds are supposed to take with this concept.
Um, I I have a fundamental disagreement with the way you pose that in linking morality with obscenity, because that takes it into a completely subjective plane for the purpose of regulation, because we're talking about how it's going to be regulated, and particularly for young people. It's the access to what is deemed to be obscene that is the question that has to be answered by those who are in the power to regulate it. At home, parents; in schools and institutions, it will be principals and teachers, etc. Elsewhere, it will be governments and similar authorities. So I feel that very often we are spending too much time, I believe, on trying to label things as obscene or otherwise, because all of us grew up with content where we went to temples and saw sculptures, which today people may call obscene. You may see poetry, you may see articles. Half the Mahabharata is full of things which today people would call, oh my God, it's obscene. How could that relationship have happened? How could this have taken place? But all of this is extremely subjective. I don't know if this gets into the realm of law at all, except where it pushes the envelope at an extreme level. That's the way the law has changed and reached a stage where we are extremely tolerant. And the Constitution allows us to be extremely tolerant of different views of what we may call obscene until it starts infringing on things which may cause public disorder or other things which are mentioned. So, while I take your point, I feel that the link between morality and obscenity may be a little ambiguous. Thank you.
Good afternoon, everyone.
Wait.
Uh, I'm a fourth year learner at Symbiosis Law School, Noida. So my question is
So sorry,
directed
your
to,
name, please.
my name is Sakshat. My question is directed to Shadan sir and Gopal sir. Sir, as both of you mentioned that there is discrepancies in the Supreme Court itself upon its various benches and how they deal with the judgments. For example, Justice Pardiwala ruled XYZ in the street dog judgment, and which was overruled by uh, a different bench in a different manner. How does this ensure that the public can trust judiciary in such a manner that the judiciary is dealing rightly with the fundamental rights if there is so much discrepancies in the judiciary itself dealing with all these matters?
No, so it is, of course, a huge challenge today. Forget like the public at large. I mean, high courts are struggling today to figure out what is the law laid down by the Supreme Court because there's so many versions of that law. So that's, and as councils, we struggle also. So that's one. So I think the way for a court is, see, the with the Supreme Court, nobody above that particular bench, it's very attractive to do what you feel is right in that case, right? Irrespective of what the law strictly says. I think it's important that judges sort of, in the interest of consistency, hold back their instinct if needed. Unless, of course, the matter is really crying for it in sense of justice in extremity. So I think that's one way of doing it. Second thing which has happened, which is a recent phenomenon, is it's like almost like there's an intra-court appeal which has developed, right? So you have a judgment in say court 13, 14, some one of those courts which comes, and then suddenly you have a three-judge bench constituted, and then it's undone, or the presidential reference being used as a appeal, right? That's what in effect happened in that specific case. And that's even more debilitating to the institutional integrity. The court is one court. If every bench is speaking for the court, therefore at least there has to be some level of consistency. I think it's for the judges to internally sit and then figure out ways to how do they become more consistent. I think it's really at that stage now whether when institutional credibility will be lost because of this fragmentation.
I just want to supplement that. I feel that I've seen this shadow over the last few years. I think judges have started applying principles which have no application at all. Number one among them is their need to uphold public interest. That's not their job. Upholding public interest is not the court's job. A has a dispute with B, you decide on the law. Don't get into extraneous factors, how it will impact that person, this person. That's not your concern. Very often we have seen also this slightly jingoistic comments coming from the bench. We will not let India's reputation be affected in the international. Arey, who are you? Yeah, you're a judge. You decide. It's not for you to decide India's reputation in the international arena. You have a list, you decide the list, that's it. These kind of things, when it starts playing in your mind and you start thinking as a judge, for some reason you've become Prime Minister of India, you have to step back and realize you have an oath in the constitution which you have to uphold the constitution and the laws. That's your job. Stop it. I've heard judges very often tell us that my conscience will not permit. Your conscience is not being called upon here. You're asked, this is the law. If something illegal is done and a building has been constructed, trees have been chopped without environment permission at all, that building will be demolished. It doesn't matter who it belongs to, right? So it can't be that, oh, so much money has gone. Money doesn't matter. If it was a small villager who had spent 5,000 rupees, you would demolish, right? So then the law has to keep its scales even. For me, all these extraneous principles, the more you bring them in, it gives elbow room to judges to do things which are not legally permissible.
Very well said. We have time. Yes, yes.
Yeah. News organizations are often flooded with requests for deletion of content merely because someone who's been accused of, arrested for a heinous crime has since been acquitted. The recourse we provide for is usually that we lead with the acquittal in an online item because that can have a separate life of its own. Unlike, and so we provide context to the arrest, but most often these people want the entire content to be deleted. So how do you deal with a situation like that? Does right to be forgotten, can that be invoked in this context, or doesn't it might concern a point of law that might have larger implications? So how do you deal with a situation like that?
I think either of you can.
Karna.
Mr. Kaushik.
I'll just quickly, before Gopal comes in, I'll just say on the right to forgotten, my personal sense is I don't think there is a right to have a sanitized history. If you were charged at some stage and subsequently you have been discharged from that crime, both are in the public domain. Like yesterday, we had a important discharge of Mr. Kejriwal in the excise policy case, right? We were charged. There was a narrative created for 2.5, 3 years, and then both are in the public domain. Let both of that be in the public domain. I don't think we need sanitized histories completely. So if there has to be a right to forgotten, my sense is it has to be more limited. It can't be, and you put it quite well, that it can't be that everything should go out. So there is a certain history. You were at some point charged, and that in fact speaks to your credit that both the versions are there. And the fact plays out as it has played out rather than just erasing something. That's my personal sense.
I agree with this. I don't really have anything to add.
We have time for one last question.
Yes. Hi, I'm Advocate Ananya Tyagi, and my question is where a person's meta created digital identity is violated without consent, can such a virtual harm be recognized as an infringement of dignity and autonomy under Article 21? And how should the constitutional law respond to this?
Did you say virtual identity?
Yes, yes, sir. So through Meta, now people can create their own digital identity.
Yeah.
Yes, in that
I think it's a very interesting question. If you were to put it to a court today, which is, open to consider this, it may well be that they will decline to say that the digital identity avatar will have an Article 21 right today. But knowing the Overton window, maybe in 20 years' time, they may come to saying that it does. Right now, I don't think it would, because it's a digital avatar. It's very, very essential that we understand that Article 21 is very different from all the other rights that we have in Part 3. It says no person shall be deprived of his life and liberty. Now, deprivation means that it's inherent in you. So your digital avatar having such a right was never inherent as considered by the Constitution. But for you to have that right, it is considered inherent. All other rights in part 3 are actually bestowed on you by the constitution, given to you, including equal treatment, freedom, etc. But this one is inherent. So it's very critical how we look at it. And it's best that we read it narrow enough that people have that basic fundamental right. And we don't start having, if you had multiple digital avatars, which one would have the fundamental right?
True.
So I think there would be many questions that would arise around.
Yes, sir.
Yeah. Too often, people who are have some bad publicity in the press, they approach courts, and then just because one publication has written something about them, they get a injunction against all publications, saying that anything on this subject cannot be written about by any of these publications. And we just get notice, but we are not even heard. And the newspapers get notice from the court saying that we have decided ex parte that you cannot write anything on this person on this subject. So what do yeah, and especially in Karnataka.
Delhi High Court has been passing a series of orders like this,
Yeah.
Ashok Kumar orders, as they call it. It's the equivalent of the John Doe orders. So the petition is filed with Ashok Kumar as respondent. I think the gentleman sitting next to you might have authored some of those orders as well. So the Justice Muralidhar is here, and he's been a star and a beacon for us in the profession with reference to how he has deported himself as a judge. But we've seen many of these kind of cases coming up in the last few months in particular Delhi High Court. So you have all these celebrities sitting in Madras and Bangalore and Chennai, etc., and Bombay coming to Delhi and filing their petitions here for protecting. And you're right, but it's up to the media houses to file an application and say, look, we are affected. You are curtailing our freedom of speech. Hear us as well. So I think that's the solution.
And just to add to that, I think it was 3 or 4 days back, there was a case in Delhi High Court where in a personality rights case, Meta took the position that the person is trying to actually shut down all criticism using personality rights as the basis, right? Although the court went narrowly, didn't decide that question, but I think that's also happening a lot. You're using personality right to actually shut down legitimate criticism of public personalities. So exactly. So I think that will have to be dealt with by courts, and I think most of these cases are coming to Delhi High Court, so they'll have to engage with it at sometime sooner than later.
We have time for one more question, one last question, please.
Yeah. Hello. Greetings to one and all present here. My question is regarding privacy. As we know, first of all, myself, Aditi. My question is relating to privacy. As we all know that after the case, Puttaswamy judgment in 2018, privacy is a fundamental right, and the enactment of DPDP Act crystallizes it. And with these rules, now the AI comes into picture where the large models are being developed, trained, taking personal data from the public at large. So, my question is regarding how do we protect the privacy of people whose like the data is taken in a large amount and there is no filter, then how the regulation is being done to protect the privacy of those people while training AI models?
Dr. Sharmila, if you could please respond.
Yes, under the DPDP Act, for training the data, if it is procured, we need to get the consent. And as of the principal is consent, he has also have to give the consent, and based on that, you obtain the data. And we do have provisions under DPDP Act which ensures. But as of the large model is concerned, last week the Anthropic CEO he mentioned even the creator doesn't have a control. So that is what the situation as of the AI models are concerned. That is where the future is going, where we have to ensure the regulations are very strict.
Is there any filtration as to what to go in the training and what not to exclude the personal information?
So, as of the private entities are made accountable, and in the design, it has to be ensured. The content moderation and the content moderation that has to be employed in the design itself.
Okay. Thank you.
That brings us to the end of this session. Thank you, Mr. Farasa. Thank you, Mr. Sankanarayan. Thank you, Dr. Sharmila, for such a fantastic session. It was very insightful for all of us. Thank you.
And the candidness as well. I think the replies was what I think won over everybody here in the audience. Superb stuff. Before the panel leaves, I'm going to request Mr. Atrika to please present a small memento as a token of appreciation to our panelists who are present here. Mr. Shadan Farasat, Senior Advocate, Supreme Court of India. Thank you so much, sir, for your presence. Mr. Gopal Sankaranarayanan, Senior Advocate, Supreme Court of India. Thank you so much, sir. And of course, to Dr. M.S. Sharmila, Head of Department, Center for Postgraduate Legal Studies, VIT School of Law, VIT Chennai. And of course, a big thank you to Ms. Aratrika Bhaumik, Senior Sub-Editor, Digital, The Hindu, for moderating this session. Thank you. Thank you very much. Well, that was a wonderful session that we've just witnessed. And they say when you're already on the right track, then there's no point in stopping. Let's just make sure we gather a little more momentum down that same passageway. We move on to our next fireside chat, which we've got. This is, of course, ladies and gentlemen, the art of constitutional thinking. So we'll just give our ops team maybe just another 60 seconds to put things in place for this. Now, never underestimate the importance of having a good team. And that's what I'm saying. This is like clockwork. The moment they come in together, put things in place, and we're set and we're ready. And never underestimate the importance of having a great team, somebody who's putting it all together for you. Now, ladies and gentlemen, on to our next session. The art of constitutional thinking, how great lawyers are made. I'm sure this is going to interest a lot of you. This session explores the intellectual rigor required for constitutional thinking. We'll discuss skills and philosophical underpinnings that shape exceptional legal minds. And to talk more about this, I'm honored to introduce our speaker for this session. Of course, that's Mr. S. Muralidhar, Senior Advocate and former Chief Justice, High Court of Odisha. Pleasure to have you here with us, sir. It's an honor. And of course, to moderate this, may I invite Mr. Krishnadas Rajgopal, legal correspondent, The Hindu, who's moderating this session. It's over to you, sir. We're all looking forward to this.
So, so I was supposed to say the star and beacon line, but then Gopal said that, and I'm saying got all the claps for Justice Muralidhar. But then let me have the privilege of introducing him once more. Yeah. Justice S. Muralidhar, jurist, author, former Chief Justice of the Orissa High Court, and now a much sought after senior advocate of the Supreme Court of India. I read your website profile and said you started in 1984, which means 42 years. And next year, I think 1987 is when you came and started your practice in the Supreme Court. He's seen it all, both sides of the coin, the bar and the bench, and also the serrated edges of the coin too, sir. Yeah. So as a young lawyer, he's done a lot of pro bono work for the Bhopal gas tragedy victims. And he also passed what was widely reported as the the Midnight Order, which saved probably many, many lives in the national capital during the February 2020 riots. It's an honor and a privilege to have you here, sir, with us. So I would invite you to make a few opening remarks on our topic of conversation here, which is the art of constitutional thinking, how great lawyers are made.
Thank you, Krishnadas. Thank you, both Hindu and VIT, for inviting me here. It's very encouraging to see this kind of an audience. Law is very much in everyone's mind, imagination. The amount of coverage of courts and lawyers in the last 2 decades has been phenomenal. And after the social media, everyone gets to see some forward or some video clip of some lawyer in action or judge in action. And I think there's a greater realization that courts are playing, whether we want it or not, a very active role in people's lives. Almost every aspect of life in India is governed by some court order or some statute or some legal policy. So everybody's interested in knowing what's happening in the courts and with lawyers. I keep saying this, one marked change that I've seen, because I was a lawyer in the first phase between, as you pointed out, 1984 and 2006. And then after 17 and a half years in the bench, I've come back to the bar. So one marked change I'm finding, and this owes to the change in legal education, is the advent of the national law schools and products of the national law schools coming into the bar. Right. I think one of your issues that you raise is about the dichotomy between the national law school law graduates and the non-national law school graduates and how the priorities have changed. But just the previous session, we had 2 eminent senior lawyers who are all product of the national law school system. And it's very encouraging to see many of them come back. They've done their time in the corporate law firms or corporates. Something is drawing them back into practice, litigation. They're taking huge cuts on pay to come back to litigate because something in the bar is attracting them. That's right. Of course, some have been fired by idealism and are very clear that they want to practice from day one. But there is this trend. There is also a trend of the national law school products coming back into academia. So they're coming back to teach in the national law schools. Of course, the divide does exist. But overall, I would think it's improving the quality in a indirect way also among the bench, because many of these young law students are interning with judges. Many of them are law researchers for judges. So I know judges who are driven to perform better with many young minds around them. And judges are introduced to new ways of thinking. So all this doesn't happen in isolation. Let's take the example of, Section 377 IPC. That whole building up of the public opinion and driving lawyers and judges to get it decriminalized, homosexuality decriminalized. I think there is a whole backstory to it. Yeah. And even the latest Sukanya Shanta judgment, which invalidated many provisions of prison manuals, which permitted segregation of prisoners on caste lines or allocation of duties to prisoners on caste lines. There's a whole backstory to it. So there are many young legal minds interacting with judges. Many of them I know within chambers questioning judges. Sir, you said this just last month in this judgment. How come you're taking a different view now? So there is definitely a greater awareness in the bar, and the standards are getting pushed. So this is the good story of it. The not so good story, of course, we're going to discuss when you start putting forth your questions. So overall, I'm not a pessimist. Right. As you must have all realized by now, I'm this eternal optimist. And I think the better days are yet to come. And I think we've laid a kind of foundation for it. When these young people really come back to the profession, raise the standards of the bar, I think there'll be better days for the bar, but it's going to be a huge struggle because the divide does exist between the urban lawyer and the non-urban lawyer, the male lawyer and the non-male lawyer. So these divides have to be overcome. A lawyer who's very tech savvy and the lawyer who can't afford digital devices. So that divide needs to be bridged. It's going to take some time, but we'll have to keep working at it. So overall, I think there's a lot of work to do. For any law student here, you must be assured this is perhaps the most exciting time to be in the law. In the discipline of law, there are many, many options. And judiciary, of course, is one of those options. And there is never a dull moment for a person interested in the law, for the person wanting to engage with the law. The tougher it gets in terms of protection of liberties or upholding the rule of law, the greater is the work of the lawyer. The better is the challenge for the lawyer. So the way of looking at it is, this is perhaps the best time to hone your skills, because this is perhaps the most challenging time for our collective liberties and for our challenge in upholding constitutional values. So this is the time to be at it.
I'd like to ask you that, what I've spotted in the Supreme Court, we have the AI governance, we have digital age coming into the courts. But on the other hand, there are a lot of cases and lawyers on religious issues, on communal tensions, and these litigations also, even in the lower courts, these civil suits are filed with communal color to it. So there is also a flurry of these petitions coming in. So do you believe that that the ideals that are enshrined in the Constitution, equality, fraternity, dignity, right to life, these have to be inculcated at a very young age? It has to be a natural way of thinking, these ideals. Do you think that this would probably balance with the onslaught, or maybe a negative word, but the flood of AI governance, the new branches of law opening up, that you have to get the basics, the foundational basics of the Constitution right?
Correct. So actually listening to you already echoed the words of Dr. Ambedkar in the Constituent Assembly when he spoke of constitutional morality, imbibing constitutional values, because he realized very early on that Indian society was not fully ready to become completely democratic. So you're seeing the transformative potential of the Constitution. And he was not so confident that we'll achieve social democracy through only the instrument of law. And he was perhaps right. We have many such law reform statutes which haven't changed societal behavior. I'm prefacing my remarks with this because lawyers are products of society, right? And judges are from among the lawyers.
Exactly.
So if you look at the entire spectrum of the legal system, unless you start very early in imbibing constitutional values, you're not going to be able to find that happen at the level of the bar and then at the level of the bench.
At a law school.
Even earlier than the law school, I would say at home to start with.
Exactly.
Right? The minute at home, when a person comes to work for you, to sweep your floor, to wash your clothes, to clean your utensils, is not allowed to drink from the same cup, her cup of tea, which all of you drink. And she's not allowed to stand or share the table with you to eat. She has to sit in the kitchen on the floor, unpack her food, and turn to the wall and eat it. And as a child, you watch it, and your parents are fine with it. There is some problem that we have there.
We don't even have a minimum wage.
Of course, I mean, that's all, we're still talking too far ahead. But I'm saying at a very basic level, when you see practices of discrimination practiced in a very personal sphere, and you're not allowed to react to it. I know many children ask, why is this happening? And you'll have the parents say, no, don't bother about all these things. These things have happened for a long time. We'll tell you later, or this is how it should be. That's where the problem starts.
So is it a kind of a social conditioning that happens
throughout? And vice versa. I don't know how many of you have heard the name Beswada Wilson, who's spoken about his childhood. He came from a family who were doing sanitation work for generations. So when Bezwada Wilson, somehow he was the only one in his family to complete school and then go into college. When he had to enroll in the employment exchange, he went with his elder brother. And the person at the employment exchange automatically said, what kind of job is Wilson going to apply for? And he put down sanitation work as well. And when Wilson protested, his brother said, come away, at least you're getting registered in the employment exchange. Trying to say is even from their perspective of people who've been sweepers, who've been cleaning our latrines for years on end, for doing all that so-called dirty work, people working in cremation grounds, people working in landfills, all those children who are rack pickers, or people working in mortuaries. I don't know how many of you in this audience knows that all that post-mortem that we talk about, the anatomy exercises that happen, they're all done by people of a certain community, a certain caste. The cutting open of dead bodies, the preserving of the viscera. The doctor in the rural countryside will simply sit in the chair and instruct how it should be done. So we don't have any movement of social resurgence, like Narayana Guru, for instance, in Kerala, or some of the other saints that we had during the Bhakti movement. Somebody who can actually, because today's gurus are not inculcating constitutional values. You go to a, Isha, or you go to a Sri Sri Ravi Shankar, or you go to any religious gathering. They're not going to say, please let us look at our fundamental rights. Please let us look at Article 17. I would accept you as a follower only if you vow not to practice discrimination in your social circle, not to oppose interfaith marriage, not to oppose, and to fiercely oppose untouchability. These are constitutional values, right? Non-discrimination, untouchability being an offense. How many of our religious heads say these things? How many of our people holding constitutional offices say these things, right? And how, do we really boycott people who practice these things? I know of an SGPC head who had her daughter killed as an honor killing because the daughter married somebody against her mother's wishes. So I'm saying we are in a country where we don't allow the provisions of the Constitution to influence our personal behavior. Till that change, and this is the change Ambedkar is talking about. He knows it's not enough for a court to declare something to be unconstitutional. I spoke to you about Sukanya Shanta judgment. We knew that our real issue started after the judgment was pronounced. The judgment had declared provisions of the prison manuals sanctifying segregation of prisoners according to their caste to be legal. So far, so good. Getting it actually implemented within the prisons is going to be the biggest challenge for us. Somebody looks at me and says, oh, this guy has to be a Brahmin. This guy has to be a Muslim. This guy has to be a lower caste. By looks, by names, we already segregate people. Something happens in Pahalgam, in a public school in Delhi, the child in the 3rd standard turns to his neighbor who is a Muslim and starts calling him Pakistani. Where does this come from? It comes from that social milieu where you grow up, in your houses, in your homes. So we turn a blind eye to the numerous practices of discrimination around us, and we don't relate to the Constitution at that level. So that change has to happen. Through education, I agree with you, but not just some civics lesson in the 10th standard. It's not enough, according to me, because you will not know how to relate to it in your personal life.
So it has to start from home.
Because otherwise, what will happen is you're looking at numerous reactions of judges. People ask me, how is this judge so conservative? The judge says you can't have live-in relationships. The judge says you can't have boyfriend, girlfriend. You shouldn't have premarital sex with a person until you marry. So where does this come from? Right? In National Judicial Academy, we were having a conversation. I'm from the Delhi High Court. I'm having a conversation with my counterpart from, let's say, High Court in the North. I tell him, off late, I'm talking about some 15 years ago, off late, we're flooded with habeas corpus petitions from runaway couples. Today, it's there in every High Court. Every High Court, if the audience doesn't know it, every High Court, the habeas corpus roster is being flooded on a daily basis of petitions by interfaith couples who've run away from their respective families, deciding to marry and seeking police protection from their own families. So I was sharing with this judge, saying as a rule of caution, we first grant the protection. We know some of them may not have attained the age of majority. Some of them may not have proper identity papers. They may not even have valid proof of marriage. But still, we know that they need protection. So, as a matter of caution, we offer them the protection. Of course, we give a shorter returnable date to verify the particulars. My counterpart in Allahabad said, that is not how I look at it. When there's a young girl standing before me, the question I will ask is, what is this is my daughter? And he also followed up. He says, no parent can think ill for their child. No mother, no father will ever want their child to be unhappy. So we come from a very opposite ends of the spectrum, right? I'm thinking of honor killing because it's actually happened. Some of my colleagues, senior colleagues, told me how when they met the parents in the chamber and were taken in by the parents' sincerity, they persuaded the girl to go back with their parents, only to be told 3 days hence that she was killed in a village in Bihar. So that set the alarm bells ringing among the judges. But what I'm saying is about the orientation, right? This putting the constitution ahead of everything else is easily said than done. I know many judges in the country today who can spout constitutional values in public platforms, but when it comes to their child marrying outside their religion, outside their community, outside their caste, they'll put their foot down. Same way with holders of constitutional offices. Many of these politicians, many of the chief ministers, prime ministers, governors, you just have to ask, how do they react when such an issue arose within their own household? So this is a serious search, internal search that we have to do as a country. But I must say this, the more of such incidents and the more the media highlights this, and I must compliment the Hindu for this and all your sister publications, because that highlighting of these issues, the attacks on Dalits, the attacks on interfaith couples, must be kept on. You shouldn't get cowed down by whatever pressure you're brought under, because that's the only way to reform. And there is already an upsurge. You know, when the Dalits regain their political freedom and economic freedom, and naturally, therefore, the social freedom, they're going to meet with resistance at various levels. The same thing that Ambedkar spoke about, graded inequality. So we go back to Ambedkar all the time. That's why that statue of Ambedkar, which always has the book and the finger pointing ahead, is a clear sign that that's the way to go forward.
So
not just for the Dalits, for all of us.
Is that an accusatory finger at the Supreme Court?
At all of us in society, at all of us in society saying, first look at yourself. Where do you stand? What is the position you're going to take? And you'll find that's a very useful, if you to understand LGBTQ, to understand trans rights. You know, that's one reference point which is very useful. It's very useful. So I would really say that swearing by the Constitution for every citizen and for every child to be told by every parent that that's your starting point is very important.
So, taking your answer, summarizing it, it's the ideals of fraternity and equality. It predates the Constitution. It predates the Constitution, and it should be a way of life. But then we have law schools. We have mushrooming of law schools, mushrooming of different branches of law coming up. In the process, you have done a lot of pro bono work. Do you think that that human aspect of law, the litigant as a sufferer, is being is waning? Do you think that that's going down among lawyers? Do you think the focus is largely on corporate law as a money spinner?
No. I don't think this large, small point answers the issue quite adequately.
Yes.
We shouldn't go by statistics here because then it's very easy to answer your question that among, let's say, 100 lawyers in a bar, not even 2 will be having human rights orientation, right? But then we have to see that in a different context. Let's say among the 100 lawyers, 20 lawyers command 80% of the practice because they're good, they're very efficient, they're competent. So more clients want only those lawyers to appear in their cases. Let's keep that aside. Okay, that's one reality that we have to face. One can be pessimistic and say, therefore, the percentage of lawyers who will stand up for the poor, who will stand up for rights is very small. But I think the better way of looking at it is looking at the better examples in the present generation of lawyers of cases and causes being taken up, not for money, not for fame, but for belief in constitutional values. Let's take the example of what's today called Square Circle and which was earlier Project 39A.
Yeah.
Both Shadan, Gopal, they've all appeared for cases for Project 39A. Both will agree with me. It's so encouraging to see very young lawyers with complete commitment undertaking great risks in going to the prisons. You know, it's not easy to go into a prison. And for a young lady lawyer, almost you'll have to, have extra skills to be able to do that. These young lawyers are visiting prisons in the most remote corners of our country, talking to prisoners who are on death row, who are serving life sentence, getting out their stories, looking at the records, seeing how you can better argue their cases. You know, there are so many cases, and it's just not a small number, so many cases where the plea of juvenility has been overlooked. Somebody is arrested when he or she was 14. The person is now serving either a death sentence in death row in some prison or on a life sentence. These young lawyers have been able to get out those stories, been able to reopen cases, and possibly get an acquittal in many cases. Now, this is something that was a rarity when I was a practitioner. Of course, I did cases, a large number of cases for people on death row. I was part of the Legal Services Committee, and I did a lot of pro bono work. And I must say, even during my times, there were groups. There was Indira Jaisingh's group, Colin Gonzalez's group, Prashant. So that you had Sanjay Parekh. So we would call ourselves the known suspects, no? Because all cases would go to a certain bunch of lawyers who have a certain orientation. But today it's getting more dispersed. It's not happening in all high courts.
Younger people are coming.
Younger people are coming forward. It's not like a transformative sea change, but it is happening. And that's very encouraging. So we must then, highlight those examples. Because the younger people in this room should know how satisfying that work is. That's not paid work, but it's extremely satisfying to say, even after 20 years, somebody who's wrongly imprisoned for the last 15 years, 16 years is today a free person. And because of your work as a lawyer, that's been possible. That reaffirms the faith of the people in the system. So you may be just a 23-year, 24-year-old lawyer, but your work has contributed to this, right? So it's very, very reassuring. So it keeps the faith in the courts alive, because someday some judge can pick that up and say, yes, this is clearly establishes that, there was a miscarriage of justice. So every other day you do get these examples also in the papers, not as often as we would like to see it, which is why I'm saying this is a very important phase in our legal political history where lawyers will continue to play a very important role, and perhaps more important than, let's say, 20 years ago. There is greater political awareness. So social media has its ills and its benefits. So if you get the right kinds of forwards, or if you yourself use your filters to say, okay, this is fake news, this is genuine news, this is somebody's opinion I'll value, this is not somebody's opinion I will take seriously. If you have that discretion, and if you are discerning as a law student, as a lawyer, it will lead you to the right path. Follow the good examples, and you'll find law profession is very, very rewarding. Maybe not monetarily for lawyers I'm talking about, but in terms of professional satisfaction, it's tremendous. Just to see the look on the face of that client who's got justice after waiting for 15 years, 20 years, is worth all the earnings that you can think of a lifetime.
There's a legend that you came to Delhi and you had functioned initially from a blue Maruti Omni van.
So in Chinese whispers, what was white Maruti van has become blue. That's the only change. Yeah.
Right. So, when you say that, the human rights aspect of law, the
Yeah, let me
smile
start.
on the
Yeah,
lip.
I know where the question is going. So I come from a middle class family.
Right.
Mylapore, Madras 4. Okay. Anyone lawyer from here from Madras will know what that really means, that address. My parents wanted a safe life for me, get settled in life, right? So I started with BSc chemistry, not having got into engineering college despite high grades. Very, very bitter about the so-called reservations, quotas, how come merit is not honored in this country, all those prejudices, the anti-Mandal agitation prejudices. I grew up with those prejudices. But, law has a way of teaching you about life, which is why I'm saying it's a privilege to be a law student in this country, particularly, because you don't find a country as diverse as India, which every 20 kilometers, 30 kilometers, you can get a new dialect for a language, right? So law helps you actually encounter society in ways that you will not encounter in other professions. You might encounter as a doctor in the public health service if you serve in the rural countryside. So it's an enormous opportunity you get to learn about your own society, to learn about the discriminatory practices in your society, why it is necessary for affirmative action, why it is necessary to persist with reservations, what is social justice. So these concepts you learn through law. My education came through that. I started helping Mr. Mukul Mutkal, who later became a judge of Delhi High Court and then Chief Justice of Punjab. He was a secretary of the Supreme Court Legal Services Committee. I was desperate for drafting because I had registered for being an advocate and record. I literally went from lawyer to lawyer saying anything that you want to draft, counter, rejoinder, petition, give it to me, right? I'll do it for free. So that's how the whole thing started. And a lot of the Legal Services Committee even then was flooded with petitions. So that gave me a wonderful opportunity to know about, prisoners in jails, waiting for long years, and not seeing the ray of hope. So the introduction to even issues of human rights, and through that came the political orientation. So I must share with all of you, if you're working in the area of law and poverty, and you don't have a left of center orientation, you will not be able to understand it. So you should also define your own politics. The two speakers here, just on this panel before our session, had their politics very clear, right? So if anyone who's in the audience would know where they stand politically, it's very important as a lawyer to choose your politics. You may choose wrongly, and you may then float to the right way, or it can happen any other way. But you're also doing some political work. When you're doing human rights work, when you're doing law and poverty work, you're also doing political work. And you're not going to find a perfect ideal setting. You'll have to find your way amidst all of this. The good news is there's enough space for all of us. There is enough space for the idealist lawyer, for the hardworking lawyer, for the corporate lawyer. They can all rub shoulders.
But can I ask you, I mean, if you are a first generation lawyer,
yes,
and you don't have any backup, to start out in the profession, you need a certain capital, a certain expertise, people who would help you out in the initial years. Do you think that the social work, the political work, the dreams of a lawyer often come crashing down because they don't have that initial capital, which takes them through the initial years of struggle, and then
see, all professions have struggle. Okay.
Is it easier now?
No. All professions have struggle. Yeah. All professions have inequalities. All the Bollywood stars that you hear of, suddenly some opportunity comes in your 35th year. Look at the great M.G. Ramachandran. Mr. Ram is here. He can speak to you for hours on end about M.G. Ramachandran's trajectory in films. Till he was 30, he was a nobody, right? So there are for many professions, the initial years are years of struggle. I agree with you. If you're a third generation lawyer, fourth generation lawyer,
easier,
son of a judge, there is a certain platform which you get onto, which makes it easier. It's a set chamber, set clients. You're already more confident. You're already more articulate, right? But it's only up to a point. Then you have to be able to demonstrate your worth, right? So it may be that you're delayed by 2 years or 3 years, but how do you use those 2-3 years is very important. How do you equip yourself? Because this profession, just like the medical profession, there's a good comparison you can make. Unless you hone your skills on a daily basis, on an hourly basis, like the two lawyers, they could sit back and say, okay, after 25 years of practice or 20 years of practice, we become seniors. Now we can take it easy. No, they have to, in fact, do even more intensive reading. They can't afford to miss out on a judgment that's been delivered by this judge whom he's arguing. Gopal is arguing before this judge. Only yesterday morning, this judge delivered a judgment. If Gopal says, I didn't even know you delivered the judgment, he'll cut a sorry figure before the judge, right? So on a daily basis, good lawyers keep reading. Like good surgeons will not miss reading that latest medical journal or the latest advancement in science, which makes their profession, easier, or a new dimension added to treatment. Likewise, lawyers, I kept telling them, even this morning I was telling someone, if you're able to read one judgment a day and not just read, summarize what you've read and refuse to go to sleep till you do that exercise, at the end of 30 days, you will find yourself growing. To all law students here, I want to tell you this. Remember this, one judgment a day. It doesn't have to be a judgment only the Indian Supreme Court or the local High Court. It can be a judgment of the Canadian Supreme Court, the Australian High Court, any court that you want in the world. Today, all of that is on the net. One judgment a day, one summarizing in your own hand, not on a digital pad, using your pen on a notebook. One judgment a day, one summary of that judgment a day. At the end of 30 days, just like you don't forget to brush your teeth, you don't forget to have at least one meal a day. You can't go to bed without doing this. If you're able to do this, you've equipped yourself. You're one up on the next person who's failed to do this. So this constant honing of one's skills is what helps you reach a certain level. And the bar is a way of noticing you. Go to the smallest bar association, anywhere in the country. Talk to one of the senior members in the bar. Okay, so it's funny aside. A young lawyer walked into the Allahabad Bar Association. This is told to me by none other than Shanti Bhushan, who's a product of that bar. So this young lawyer goes to this, the old lawyers in any bar association will be doing what is called an adda. They'll be recounting the whole days. They'll say, this judge was like that judge was like this. And they'll be having their tea, snacks and all that. Even if you go to the Delhi High Court, there'll be one table where the old lawyers will sit. So this young lawyer approaches one of those older lawyers and he says, sir, I've just got enrolled day before yesterday. I want to know what are the prospects. He says, beta, dekho, wakalat ban gayi to Motilal, nahi bani to Jawaharlal. So there is hope for every lawyer in every bar, and the bar is a way of noticing you. You walk into that bar and you ask those chaps, who is a good cross-examiner amongst all of you? They'll give you a list of 3.
Okay.
Better still, you ask them, who are the honest lawyers? They'll give you a list of 4. You ask one of those lawyers, if you have a problem, which lawyer you'll engage and which you will not, he will tell you. So you've already developed a reputation in the bar. Why? Because Gopal Shankaranayan opposes me today, right? I know his tricks, he knows my tricks. He's already assessing who I am as a professional.
There's no conflict of interest there.
No, it's always only a conflict of interest. No, so you develop a reputation in the bar. You ask someone, which among these lawyers is a good draftsperson?
Right.
This is the other example I wanted to say. Mr. Parashan's father, Keshav Iyengar, continued practicing till he was 94 years old, 94 or 95, coming to the court every day. Was a super draftsman of a plaint. So you Keshav Iyengar, a plaint which ran to 10 pages, you'll be furious. This is told to me by Mr. Arvind Datar, and that's how I know it. He said to Mr. Datar, if you can't draft a plaint in 7 pages, you don't have a case. Only I used this with somebody else who came to show me an SLP for vetting, with a synopsis running to 20 pages. I said, if you can't prepare a synopsis in 3 pages, you don't have a case. If you're not able to state what your case is in the shortest possible way, What is all this learning as a lawyer? What are all these years of experience, right? So this is a skill that you hone and you get noticed for it. So I know busy lawyers don't have time to meet all the deadlines. They're looking to young people who can do that drafting, outsourcing. That happens in the bar. So you develop a reputation for being a good person who can draft. So there's a great demand for that.
Is this are you better equipped when you start out in the district? Because there's an adage that you start.
Yeah, earlier I was of this view that you have to start in the trial courts.
You don't go straight to the.
Yeah,
Supreme.
because now even in the trial courts, there is a shortage of lawyers who've got great forensic skills. Not that they're not there. Having watched the districts in Orissa, I traveled to every one of those 30 districts. I've interacted with the bar in every one of those 30 districts. I must say that because we found that lawyers are avoiding doing what they're supposed to do in the trial court, cross-examine witnesses. Today, lawyers want to avoid doing that. They're only bothered about winning over witnesses. If there's one eyewitness, then it's a big problem for the defense lawyer. He says, let's not go to trial only. Let's keep getting it adjourned. So the younger generation is missing out on the skill of cross-examination. So in Orissa, as a high court, we had a scheme for lawyers between the ages of 30 and 40. We said the best performing lawyer in a district, we encourage them to do at least one complete trial in a year. And we got some reasonably good results because that is a skill that's it's dying out. So I would say the earlier trial court is today's tribunals. There is a plethora of tribunals. If you join a lawyer, let's say even at the High Court, who has got work not only in the trial court, but also the tribunals, it's a good place to start. I would still encourage some lawyer to join a lawyer who has also got trial court work. But today, because there is a plethora of tribunals, I would say even tribunal work is good enough. Because it is only at that level of the court, when you make a mistake, it can still be corrected. If I send you to argue in SLP in the very first month of your practice, the results can be disastrous, right? You can't correct what happens at the level of the Supreme Court. So which is why trial court gives you the confidence, helps you develop the language, helps you understand clients. See, at the level of the trial court, your senior is interacting directly with the clients. Right? It happens in the high court also, but more in the trial court. You will find people who are at that, if you're in criminal law, you really get to see the underbelly of society. What daily struggles people have just to, be able to make ends meet. And when their child gets picked up and kept in a police lockup and not heard of for 10 days, 12 days, that struggle, what they go through, you get to know when your lawyer meets that client. You know how to convert a problem into a case that can be stated before a court. So these skills you hone at the first level of practice. So it is always useful, therefore, to start with someone not doing only appellate work at a higher court, but someone who can send you to those tribunals to say, okay, you even take a passover. So I must share a funny anecdote. There's this young lawyer, very first day of that young lawyer's work in court, and the senior has a list of 20 cases. Somebody like Gopal Shankar Narayan, for instance. And you have to run to several courts. You can't be in all courts. So Gopal tells his young colleague, you please go to that court and, ask for the case to be. There's a jargon here. So the young lawyer goes before the judge and says, my lord may kindly pass away. And the judge tells him, well, I know many litigants will be happy, but my family will be unhappy. So what the young lawyer was asked to do is ask for a passover, which is the case is kept back to be taken up at a later stage in the day. So young lawyers develop their skills by watching their seniors. There is no work day for a lawyer, because the court itself is like a huge university, right? Shadan is arguing a habeas corpus. Gopal is arguing a trademark law. I am a lawyer, 2-bit lawyer who's come and sat there. I'm not going to get a trademark case probably for the next 10 years. But Gopal's briefing counsel have prepared a wonderful note for him. And he's able to, reel out all the case law before the judge on different propositions of kit. It's like a cooked meal being served, right? All I have to do is keep my notebook and a pen And every time he cites a judgment, I have to write it down because I've never heard of this judgment. He says, for this proposition, my lord, this is the leading authority. Work is already done. All you have to do is make notes. My first lesson on learning the law of privileges was watching Mr. Parasaran argue this in some court, in the Supreme Court. I had not heard of this branch of law. But it just happened I was in court and I watched him and made my notes. Why did I make my notes? My own senior, if he saw me without that notebook, would send me back home. He would get furious if he didn't see that notebook. He said, this is your personal library. You can't survive without this. And he would pull out his notebooks when he practiced law in the district courts. So this is your learning. You're learning in the court, watching others perform, watching some of them perform well. If it is not my good day, okay, I've got 40 years of practice, doesn't mean that every day I perform well. There will be days when I'm not prepared as well as I should be. Somebody who's joined the bar only a day before yesterday could be performing brilliantly. So this is the beauty about the bar also.
Do you think that getting rid of jargon in the statute books would help,
see that,
especially litigants, to understand their case better?
Yeah. So this is a movement that started quite some years ago in England, simplifying the language of the law, and particularly in statutes. I think where we come a cropper is this. When we start to write a new statute, even today, in 2025, we begin writing it in English. Even when they had these 3 new criminal laws, they didn't write these statutes in Hindi. They first wrote it in English. And of course, they did a lot of copy paste. If somebody really reads these statutes, you'll know how much of it is a copy paste. Since we write in English and then translate it, you encounter the first level of difficulty. Legal English is heavily jargonized, like you said. So even very literate persons in English will find it difficult to understand the law. So another funny anecdote. Okay.
Yeah, please.
So this is elderly Sajaji waiting for his case in the Chief Justice's court in Punjab and Haryana, in Chandigarh. The bar is on strike, so no lawyers have entered. And this elderly Sadaji is tired of waiting for his case to be taken up. Fortunately, that day his case is called out. Usually it's never even called out. So when it's called out, he decides he will go and argue the case himself. So he steps up, starts presenting his case. So after some time, there are 2 judges, the Chief Justice and the companion judge. The companion judge has got his head in his hands. And he says, Babuji, what the judge tells the Sadaji, he says, Babuji, हमें समझ में नहीं आ रहा है क्या कह रहे हैं, आप वकील रख लो. So the Sadaji pat comes the reply, he says, कमाल है, समझ आपको नहीं आ रहा है और मुझे वकील रखना है. So as a judge, I've watched many an anxious litigant in the last row. The lawyer is appearing before me, I'm asking him a question. The litigant knows the answer, right? So he's putting up his hand desperately, saying, let me say it, And we don't say, we say, whatever you have to say it only through the lawyer. So first level of block comes. Many litigants know their case. They're not able to express it in the language that the court understands. So we have this phenomenon of what is called lost in translation. You go to a lawyer, you say, for 3 hours you talk to him to tell him what the problem is. And then when you see the affidavit, it's all reduced to some 10 paragraphs. You're wondering what happened. I told him so much. There's nothing here. So in mediation, all that comes out. And therefore, they say mediation is a useful exercise because the client speaks, the lawyer speaks less. So much is lost in translation. And so we have to work at simplifying the language of the law, the language of the statute, to make the clients understand how their case was presented, what was said about their case, and whether they've sometimes succeeded or failed. Sometimes after reading the judgment, they still come back and say, what exactly happened?
So, open, can we feel?
Yes, please. Yes, please.
So, please stand up, identify yourself, and make your question brief.
Hello, sir. So I'm Karthik. I'm a law student from VIT School of Law in 4th year. So my question is largely an extension of what you just elucidated. Like in your NAS Foundation case, the bench had mentioned about how the popular morality is vastly different from the constitutional morality. But what is going to be a roadmap in transforming our constitutional morality to be the popular morality at a time when even the young minds are, paradoxically entangled with the old and regressive ideas? So, what is going to be the practical roadmap for this?
No, see, the people who are being discriminated against are already having their battles, right? You learn from their battles. It's a daily battle for them. Today, I'm a Dalit. My marriage is happening tomorrow. I will not be allowed to ride the horse, right? Bharat can happen for everyone, not for me. How am I struggling with that? What do I do for that, right? I'm sitting in a classroom, let's say in Uttar Pradesh or Andhra Pradesh, and the teacher looks at me and says, okay, you go and sit in the last row. The upper caste kids are sitting in the first row. I'm talking of 2025. I'm not talking of some hypothetical thing. Anyone from Orissa here? Okay. So you must have seen the coverage in the Indian Express on a daily basis of this one school in Kendrapada, where the parents of the upper caste kids said, we'll shut the school down, but no way a Dalit cook can make the noon meals for our children. And it required great persuasion, I think, by the local administration to let them finally relent and get meals served by her. So today's reality is that people who are being discriminated against are struggling against those odds and fighting that injustice, right? Join hands with them. First, learn from them how they do it and see from your professional point of view how you can help. That will invariably require for you to first transform yourself. Please ask yourself, am I truly rid of prejudices? Right? So this whole thing, this engaging with that aspect of translating, your religious public morality into constitutional morality will be a self-transformative exercise too. It's happening in several places in our country. Don't think it is not happening. Some people are paying for it with their lives. This young girl yesterday challenged her father or brother saying, I will only marry Salim, where he was saying, no, you have to marry somebody that we choose for you. She got killed straight, right? So there are people prepared to stand up for that values in the constitution. Young girls, young women, young Dalits, young Muslims, young Sikhs, God knows. I mean, I'm just saying a whole range of population in this country, like Black Lives Matter, right? There are movements across the world because this is going to be a struggle. It is a constant struggle to preserve our constitution. It's a constant struggle to preserve our constitutional values. If you're not vigilant, if you do not exercise your rights, you will find yourself losing them at a rapid pace. So do something about it. You're a lawyer, a law student. It's a huge privilege. Exercise that privilege to its fullest potential. Thank you.
So, good evening, sir. I'm RJ Logopriya from VIT School of Law. With utmost respect, sir, if honor killing is clearly murder under law, why does society still treat it as a culture, and why has law still not dismantled it? Are we still progressing as a society?
No, so every time an honor killing happens, marks the failure of our society, right? But every time an interfaith marriage survives, somewhere something has worked right? So don't get, it's like half full, half empty. It's work in progress. The whole society is in a churn, as is our democracy, right? It's going to be a struggle to jostle for space. It's like that crowded public transport, right? You're getting knocked over over the place. You find your strategy to somehow survive through that, complete your journey. It's like that. So don't give up hope. Of course, these honor killings are a blot. Why? Witch hunting is a blot. I remember 25 years ago when I went for a legal aid workshop in Ranchi, they were talking about dying. And to me, from deep south, it was an eye opener. I didn't even know that in the tribal areas in Jharkhand, they still practice witch hunting. Only last week, I read a report about a mother and son getting burnt alive because the mother is suspected to be a witch. Every time I read something like that, my heart sinks. I said, where are we going as a country? Then I remember, no, there are people working, NGOs, civil society groups working precisely on this issue, right? Highlighting it, knocking at several doors, not just within the country, but even abroad. So there are many people troubled by the way you are, but they don't stop at being troubled. They say, let's do something about it. Please join them. Okay. And keep that movement alive.
Okay, we'll take this one final question.
Good evening, sir. My name is Saurav. I am from Law Faculty, Delhi University. Sir, thank you for editing a book, Incomplete Justice. I have requested my librarian to make it available, and now it is available in the library. And thank you for want to inform you. My question is that I am third finalist. Sir, a going court is very expensive for us, a student whose livelihood is at stake. Taking money from pockets is difficult. First one, you are an inspiration for me. And even one question is also from the second question is that even Supreme Court is confused. How can judges be sensitized? Just like if I become a judge after 2 year or 1 year after cracking the exam. So it's difficult is that without going courts, one can't become a judge. I am just sure, and you can must guide us, sir, please, because sometimes 3 year practice come. Sometimes even Supreme Court is about now reviewing in court. It is in the court. So how one should practice? Just recently, one of my very few protest.
Keep your question short. Let it be one question.
Please.
Yeah. What is it? What's the single question?
So question is that how can judges be sensitized at lower courts? Like protesters are sending to judicial custody, who are not even just sensitized. They are just protesting for rights. Or at Delhi University right now, we have seen that BNS 163 have been we can't protest.
So how can judges be sensitized? That's
Yes,
the question, right? So you're right about this. Judges come from various strata of society, right? Largely from the middle class, largely from sheltered households, and largely because they've, prepared themselves to pass those exams, clear the viva, and become a judge. They may not have the exposure. So one way we try to give them the exposure is through national judicial academies and state judicial academies. So they are sent for orientation programs. Some of these orientation programs are devised quite creatively. They have to visit a police lockup. They have to visit the prisons. They have to visit the Nari Niketans, the observation home for boys. So they are introduced to those intersections of what I call law and poverty. So it then depends on you as an individual how much you want to pick up from that. Even if as a lawyer, you can go and offer to intern, right? Whom you intern with will shape your outlook, right? So you also have to be discerning. When you enter your own institution, how long do you spend in the library? What kind of books do you read? Do you read the newspaper? Which newspapers do you read? Or are you looking at your screen all the time? So all this will shape you to be the kind of person you need to be to enter this profession. You have to be deeply aware of society, but you must let yourself become aware of it. You can't have all those filters where you say, oh, this man eats pork, I will not speak to him. This man wears a turban, I will not speak to him. This man sports a beard. If you have all these prejudices, this man is dark skinned, that man is fat, this woman is thin, it shouldn't matter, right? You should be able to look at the human being. If you're able to develop these qualities, and that can come not overnight, but by constant reading. Like if you want to know about the law, how much do you know about Ambedkar as a lawyer? Do you know anything about Ambedkar as a lawyer? You don't. Do you know he was a bar at law? You don't. So this is the thing. Do you know Gandhi had a very successful practice in South Africa? No, Charles DeSalvo, the man before the Mahatma. Again, to the law student here, please read The Man Before the Mahatma, Charles DeSalvo. I don't know if you've got your notebooks and pen. It's a compulsory read. So when we had the session saying great lawyers, if you look at the law books today, when they describe legends of the law, two prominent people who are absent in the legends of the law will be Gandhiji and Ambedkar. As if they're not great lawyers. So we have our own conception who's a great lawyer, right? Somebody who's successful in court, who's arguing, forensic skills are brilliant, who's succeeded in the maximum number of cases. That's all true, but these people are no less great as lawyers. So we need to inform ourselves constantly. Reading has to become a habit. The more you read, the more refined your questions will become. Okay.
Sure, we went. Thank you very much, Justice Murlita. It was, you spoke with your usual candor and the smile never fades. Thank you so much.
Well, this is a session that could have gone on, and I'm sure people were enjoying it and would have enjoyed it a whole lot more. Before you leave, sir, may I request Mr. Krishnadas Rajgopal to please present a small memento as a token of our appreciation to Muralidhar, sir, please. And Muralidhar, sir, before you leave, I'd request you to stay back on stage because I'd like to invite Dr. Raviraj C., Professor of Law and Dean, VIT School of Law, VIT Chennai, to kindly come up on stage and also present a small token of appreciation to Muralidhar, sir, for being here with us today. Thank you very much, gentlemen. Very informative session, and we thank you so much, Muralidhar, sir, once again for your time. Also, a big shout out to our sign language experts. A huge shout out to them. You know, they've been the unsung heroes so far. We've been doing a lot of talking, but they've been making sure that nothing is left unsaid for the people who need that the most. Right, ladies and gentlemen, at this point of time, I'm also going to say that we'll take a short breather, just a very short break before we reconvene for our next session. And of course, there's a fantastic fireside chat that we're all waiting for. So just a short breather, almost like a comma, not a full stop. We'll be back soon.
Next up, an in-depth review of India's foreign affairs. And speaking of foreign affairs, Jollywood star Malish was spotted with a 22-year-old Brazilian supermodel, Lana Kova. Now that's a real foreign affair. Looks like trade isn't the only thing crossing borders. So tell us, do you think this foreign affair will actually strengthen India-Brazil relations? Guess Malaysia.
And this is Worldview at the Hindu. Now, D-Day arrived this week for US sanctions on India after 25% reciprocal tariffs that came into play in early August. Another
newspaper. Shakkar Kama.
Gappu tangala, ayyo gappu tangala, heroine phone tolanga, headline news amma tangala, ayyo tangala, gappu tangala. Sahatakakileda vanda, rating print.
Philor International School, a holistic education hub designed to nurture a child's all-around development with value-rich learning beyond academics. VIT's 3+ decades of magnificent contribution to education gives birth to Valor International School. VIS is empowered by the vision to nurture and promote unhindered knowledge seeking and make it a premier institution of the nation. VIS stands out with its holistic learning, wisdom, the student profile building program, and personalized house parenting for an extraordinary educational experience. VIS Campus, immersed in natural light and surrounded by lush greenery, offers a strong connection with nature. The campus provides a serene and calm atmosphere for the young minds to flourish. The classrooms at VIS enrich experiential learning with innovative and immersive teaching techniques, where the curriculum is designed to create leaders of tomorrow. The library serves as a beacon of knowledge, a sanctuary for curious young minds, instilling a love for learning. Our labs are designed to ignite the innovative mindset in students, introducing them to a world of hands-on learning and a keen interest in science and technology. VIS residential blocks with a dedicated house parent ensure not just safety, but a nurturing environment where every need of the child is attended to at all times. VIS has a dynamic sports program to ensure students in a spirit of competition and team building, creating students ready to conquer challenges on and off the field. VIS is where safety meets nurturing care, ensuring your child takes the first step towards a life of accomplishments. Velour International School. Right place to rise.
VIT Chennai is a globally engaged, competitive, comprehensive, research-enriched university campus strategically positioned to respond to major industrial, social, economic, and environmental demands and challenges. The campus has a cosmopolitan atmosphere with students from all corners of the globe.
The curriculum at VIT is designed to help students discover their strengths and enhance their academic performance. VIT focuses on improving the uniqueness of each student.
Whether you're a coder, creator, or change maker, this is your launchpad. VIT's Incubation Center transformed my idea into a real product and helped launch my startup journey.
The fully flexible credit system at VIT gives me the opportunity to learn at my own pace. I can choose my own subjects, my own schedule, and choose to learn with the professors who work the best with my learning ability.
VIT Flagship Engineering Institute has been consistently ranked among the best engineering institute of the nation, making it one of the most preferred engineering destinations for students of the nation.
Being part of the research community means continuous learning, experimentation, and the freedom to explore new ideas.
VIT offers a wide array of schools and academic programs over various disciplines.
VIT School of Law is one of the leading law schools of the nation that is dedicated to honing and producing tomorrow's lawyers and law practitioners. The unique moot court concepts prepare today's aspiring lawyers for tomorrow's challenges. Simulated court cases are fought and debated as students develop gaining confidence, art of interrogation, communication skills, persuasion skills, and much more. VIT Fashion Institute of Technology is one of the specialized offshoots offering fashion education, where technology is being used to create uniqueness in blending the tradition and the modern designs. The school aims to impart quality fashion education to nourish the young minds with knowledge of fashion and teach them the nuances in this profession. VIT Business School has emerged as a premier business school in India. The programs are designed to infuse strong industry relevant business principles with deep insights, influencing practice, and actively collaborating with foreign universities and industry.
Joining the college as a fresher who knew nothing about tech. Now I'm leaving the college as a third year student with a 1 crore package. From start to finish, VIT helped me throughout the recruitment process with interviews and online assessments.
Spacious hostel rooms, multi-cuisine cafeteria, sports arena, state-of-the-art gymnasium, all affording an opportunity for holistic development of the student.
Come, be a pioneer of change. Be a part of something larger than life. Come to VIT.
Vellore Institute of Technology, a place to learn, a chance to grow.
Good evening, ladies and gentlemen. We'd be commencing proceedings once again, so I'd request everyone who's still standing outside the hall, please take your seats. We're going to get started in just a few moments from now.
Gappo Pangala, Ayo Gappo Pangala, Heroine phone Tolanga, headline news, Amrajana, Sayu Kangala, Gappo Kangala. Contact Vanda, breaking print.
Vellore International School, a holistic education hub designed to nurture a child's all-around development with a value. Residential blocks with a
Of
dedicated
course,
parent. Ensure not
that
just safety,
fireside chat
but a
will
nurturing
feature
environment
Mr. Kapil
where
Sibal,
every
sir.
part of the child
He's
is
here with us. So
at all
I
times.
just request everybody to please be seated soon enough as we head into that fireside chat in just a few moments from now. for mic number 2 and 7. Right, ladies and gentlemen, just about to start the session. It's going to be a fireside chat, constitutional morality and the Supreme Court of India. Has the court moved from constitutionalism to pragmatism? So we took that little breather, ladies and gentlemen, just to give you a moment to regroup. And I'm sure that's something that's happened. So we're starting that fireside chat in just a few moments from now. Some of you who may be outside the hall, I'd request you to please take your seats. Some of the prime seats still available in the house. Right, ladies and gentlemen, the moment that we've been waiting for so eagerly. We head into our fireside chat number 3, and it's my pleasure to introduce the speaker of this session, Shri Kapil Sibal, sir, Senior Advocate, Supreme Court of India, Member of Parliament, Rajya Sabha. Of course, he's been known for seamlessly balancing multiple roles as a lawyer, parliamentarian, and a poet. A graduate of Harvard Law School, he transitioned from a distinguished legal career into public life, earning recognition for his intellectual depth, versatility, and ability to engage across disciplines. Sir, it's an honor to have you here with us today. Over the years, of course, he's remained an influential voice in constitutional, legal, and public policy debates, bringing together advocacy, governance, and creative expression in equal measure. And of course, in this conversation with Kapil Sibal, sir, we have Mr. N. Ram, Director, the Hindu Group. Sir, thank you so much for moderating this session. Ladies and gentlemen, the fireside chat that we've all been waiting for, constitutional morality and the Supreme Court of India. Has the court moved from constitutionalism to pragmatism? Over to you, gentlemen, the distinguished people on stage.
Thank you. And I'd first like to thank Mr. Kapil Sibal for accepting our invitation, which at short notice, he's been good enough to come here, and we've agreed.
I can never say no to you. You know that.
Yes, in fact. Yes, the theme would be constitutional morality and the Supreme Court of India. Has the court moved from constitutionalism to pragmatism? So that's the overall theme, but several issues we'll discuss depending on. It'll be more conversational. That's what he wanted. I want to first place on record my admiration for the work that Mr. Sibal has done over decades, and in particular, after 2014, when many institutions failed, there was institutional attempts at institutional capture, and there was huge pressure on the courts in this country. And I think at his level, the very top of the legal profession, as a jurist, as a thinker, as a poet, as a philosopher, I think he has done more than perhaps anyone else to defend democratic rights, and going beyond that, yeah, the rights of minorities, religious freedom, and more than anything else, what can be called constitutional morality. So I think it would be appropriate to start, Mr. Sibal, with your idea of constitutional morality, and if I may, with your consent, let me make a few remarks on it, which perhaps will provide some basis for starting this off. Spending a few minutes on the idea of constitutional morality. It's a powerful but apparently an elusive and shape-shifting concept. It has absorbed a variety of meanings over time, over the historical time, and over different historical and socio-political settings and circumstances. And from the classical foundations in ancient Greece, with the Aristotelian concept of the rule of law versus the rule of men, and its variations on the theme in ancient Republican Rome, he then developed a more modern form and character from British constitutionalism and conventions. I don't want to elaborate on it. Many of you are students of the law or practitioners, much more knowledgeable on these matters than I am. But this is a very important question for people going beyond the legal profession. And it is significant that Dr. Ambedkar, on November 14th, 1948, used this term fairly briefly in the Constituent Assembly. And I was delighted to see one of the boards there quote him precisely on this question. That is, constitutional morality is not a natural sentiment. It has to be cultivated. We must realize that our people have yet to learn it. Democracy in India is only a top dressing on an Indian soil, which is essentially undemocratic. We heard Justice Muralidhar speak about this and this very idea earlier. And but since then, there have been several notable developments in constitutional and legal developments over, say, 78 years, I believe. And over historical time, this concept or idea of constitutional morality has evolved from the idea of civic virtue to institutional restraint to right-based transformation. That's where he excels, taking up what very few others have taken up, and pro bono, a magnificent contribution to the defense of democracy here. And beyond that, I don't have to comment on what he has done in politics as a cabinet minister and continues to do as a member of the Rajya Sabha against majoritarian power and now technological overlordship. So, Mr. Sibal, I made a rather long
I think
opening remark, but where do we stand with respect to constitutional morality?
See, morality by itself is not a static concept, right? It changes with the times. What was moral 200 years ago is no longer moral today. And what was moral in 1947 or 1950, the concept of morality itself has changed. So the beauty of our constitution is that the court has been given the power to interpret the times in the context of the need of the times. So let's look at India just after independence in 1950. You didn't have the kind of targeting of the minorities for rank of that point in time. So the concept of constitutional morality in the context of how you deal with minorities was not an issue that was to be dealt with by the court. the concept of constitutional breakdown, as we see today, was not something that the court was confronted with. So when we talk about constitutional morality, ultimately it comes down to justice without fear or favor. That's the expression, that's the oath that judges take and most public servants take. So when you talk of justice without fear or favor, then you have to decide what is justice. And justice is the ability to rise above fractious debates and to interpret the Constitution in the context of what is good for the larger community, right? Now, the problem with our court today, and that's where this question really arises, that there is a breakdown of our constitutional machinery, complete breakdown. The executive rules through the legislature because of its vast majority. The voice of the opposition is not heard, not allowed to be heard. Now, in that context, when the matter comes up in court, what is the court supposed to do? That's the issue that the court faces. You have speeches by ministers, speeches by people who are ruling the country, which are obviously communal in nature. The court doesn't take it up. There are issues of the scheduled castes and scheduled tribes, being lynched in the past. You had that in the early 2014 onwards. You could see those on video in the social media. Court didn't take it up. When it comes to the Supreme Court through an Article 32 petition that some chief minister somewhere has made this statement with a gun in his hand, the court says, go to the High Court, right? Now, the question that we ask as lawyers from the court is, why are you doing this? Because if you have to dispense with justice without fear or favor, what are you afraid of? You have a power under Article 32. 32 itself is a fundamental right. Why do you have to relegate this to the court, to the High Court? Also, the fact of the matter is that students in protest, Jain students in protest, are arrested for protesting. People protesting in Mandapam are arrested for protesting, right? Now, there is no reason to arrest them because they've not committed any crime. You use institutional mechanisms like the Enforcement Directorate under PMLA or the UAPA, and you target all there is no leader in any BJP-ruled state or at the center who is the subject matter of any investigation either by the CBI or under the PMLA by the ED, right? Only the opposition is targeted. Now, the court needs to, in the context of the times that we live in, develop issues of constitutional morality dealing with the times that we live in. Unfortunately, courts refuse to do that. They pass the buck to the high courts. The high courts don't do a thing. The lower judiciary refuses to grant bail. So we are in a situation where constitutional morality is a concept which seems to be alien to the court, unfortunately. And that's my greatest worry as far as the Supreme Court of India is concerned.
We hear observation like there's not one Supreme Court, there are several Supreme Courts or the High Courts. But is it realistic to expect a higher degree of consistency? How do you enable?
No, there can be no consistency. If you have a court with over 30 judges, how can you have consistency?
When you go by precedent, by the Constitution.
There is no such thing as precedent anymore in this court.
Yes.
You decide on practical way of doing things. And you know what that means. You want to appoint a judge, but you have to ask the government, should I send his name up to you?
Yes.
So this is the kind of thing that's happening. So there can be no precedence ultimately arises in a court which is united and which hears matters in a single sitting, like the US Supreme Court, right? They don't hear matters in benches. The moment you hear matter in benches, there's going to be difference of opinion because perceptions are different. Individuals come from different parts of the country. Somebody comes from the Northeast, somebody comes from Kashmir, somebody comes from Maharashtra, somebody comes from Gujarat. Their view of society is in the context of the society they live in. So their views will be different.
But isn't there something that binds them in terms
Conscience.
of conscience?
Yes, that's a very rare commodity nowadays.
So the judiciary is sometimes seen to be helpless. It has neither sword nor purse. It draws strength, and it's supposed to draw strength and sustenance only from the faith the public has, the people have. That's clearly weakening or eroding.
Oh, absolutely, without any doubt. It's eroding for the simple reason that they've brought it upon themselves. Now, you saw that chapter in a Class 8 book.
Yes.
Now, there is no gainsaying that there is corruption in the judiciary, right?
Yes.
There are some bad pennies everywhere in every institution, which spoil the name of the institution. So we can't sort of just brush it aside under the carpet and say, look, there's no corruption. You can't say that. There is corruption. Now, how is it that it has suddenly found its place in a Class 8 textbook? I asked myself this question. Would it have found its place in Class 8 textbooks had the judges performed their duties consistent with constitutional morality, right? When you reach a certain level where the public start believing that by and large the institution is corrupt, then you will have this narrative in a Class 8 textbook, right? So they, according to me, the judges have brought it upon themselves. That's one side of the story. The other is, why is it necessary to put it in a Class 8 textbook, right? That's not part of social science. So you selectively only target the judiciary and teach young minds, 13, 14 years old, to grow in an environment in which they feel that when they have to go to court, they believe the judge is corrupt, right? Now, we know that the political system is far more corrupt. We know that the investigating agencies are far more corrupt. We know that politicians are far more corrupt. We know the kind of constitutional immorality which actually runs through every political decision making that takes place in this country, right? We know how bills are passed. We know how bills that have nothing to do with financing the bill, or rather a finance bill,
Are smuggled into.
smuggled bills that have nothing to do with the finance bill are smuggled in. Nobody can do a thing. Matters keep pending in court, right? So people by and large feel if this is happening, obviously, they're trying to support the government. So corruption is not only corruption in terms of money,
Yes.
but in terms of intellectual corruption, intellectual dishonesty. So you are teaching young children that these people are intellectually dishonest and otherwise corrupt. Now, you don't mention the politician, the minister, the system, the agencies, the bureaucracy. Look at the kind of corruption that there is in the system throughout the country.
Yes.
You don't mention that in a Class 8 book. So your intent is to intimidate the judiciary. Your intent is to further damage the institution. Then you can capture it fully. You've been trying to capture it, but then you can capture it fully. So the intent is dishonest. It is selective. It should never have been in the Class 8 book. But the fact that there is corruption, and it has increased over the years, is something that the judiciary should be concerned about themselves.
So you would have had no objection had it been put in proper context, a whole chapter or a few chapters.
Yes. I would have no objection if it were said that the issue, there is societal corruption.
Yes.
That the system needs to address the issue of corruption. Is corruption at all levels, and it is also somehow crept into the judiciary, right? If this were, but that's also not necessarily in a Class 8 book. And you'll know that the NCERT will never put it there because they are acting on the dictate of the government. The government must have told them, put it there so that we can actually tell the judges, see, that's what children think about you.
Oh, so there's something behind it, a hand.
Absolutely, which is why I'm very happy for the Chief Justice to take up this issue and to do what he did.
Did he exceed his authority by ordering a ban and seizure of all copies?
No, if the copies are in the public domain, what is to be done? And if it's in the digital world, what is to be done? So I think that is the right thing to do because I don't think these should reach young minds.
Yeah, you've spoken up on this.
Yes, absolutely. And I feel very strongly about it. Because we can't teach our children, and I mean, they have to grow up as citizens who are imbued with a sense of purpose, who have a vision, who have a dream, and if they start sort of become adults and with the thought that judiciary is corrupt, where are we going to reach as a society?
Now, on defense of minority rights, very much part of our constitution, where do we stand? Some of this happened before 2014.
Yes.
But what's the difference?
Well, it was sporadic. Earlier, it was sporadic. It was always been there. In fact, if you look at the debates in the Constituent Assembly, you will find majoritarianism creeping into the debates as well, right? And people did not want Article 29 and 30. I mean, it's clear from the debates in the Constituent Assembly. So it has been, a subterranean theme within our majoritarian culture, but it has not shown itself, in such a blatant manner as it has done after 2014. I think the experiment in Gujarat and the success of that experiment was sought to be replicated throughout the country. And there's a lot of success to that.
You've been a champion of secular democracy, progressive secular democracy in this country, but not just as a lawyer, the senior advocate, but politically also, as a politician.
Yes.
And as a voice. Were we down a slippery slope much before 2014? What brought on? This goes beyond, this is not just a law, but I'm asking him also as in his capacity as a politician of experience. What is your analysis of, looking over the longer term, the preparatory period for the takeover that we saw, the radical far right takeover in 2014, and all that's happened subsequently where there's been attempts at institutional capture? What went wrong over the longer term, and what went right, if you like?
Okay, let's first define what is secularism. I mean, when I say that I'm secular in my thought processes, what do I mean? Essentially, what I mean is that I'm willing to listen to others. Minority issues come later, right? Secularism is a way of thinking by which I am not against listening to somebody else's point of view. So it may be a minority's point of view, it may be a Dalit's point of view, it may be a businessman's point of view. It's an women's issues. It's an attitude of mind. Secularism, an attitude of mind. Now, secularism is a concept that unfortunately is not ingrained within our family culture. We're essentially a my bap society, right? You tell the children you're not to speak when elders are talking. You tell the children, I want you to become a doctor, I want you to become an engineer. This is non-secular, right? There's a level of intolerance within our hierarchical culture, which is why we have the caste system with those hierarchies and the levels of intolerance within the hierarchical culture. So we are essentially not a secular nation. It's a fact.
This is what Dr. Ambedkar said in his final address to the
That's right. Unless you bring that social transformation, you're not going to get a democratic country. It's antithetical without the social transformation. And he was absolutely right. The question is that there has been greater stratification after 2014.
Yes.
It's just the other way. So while we are trying to bring about a social transformation through the laws that we enact, It's been going in the opposite direction after 2014. They want to stratify by using caste as a means of domination, right? And we see things happening everywhere. Dominate the minorities, dominate the Dalits, right? And if you have to buy them, buy them. If you want, so the level of intolerance that I have seen after 2014 has never existed in the history of India.
Yes.
For the simple reason that there has never been a capture of institutions at any stage or attempt to capture institution. There is no institution which is not fully captured other than the judiciary. You still had yesterday morning a judgment from a court saying that the entire prosecution against Kejriwal and others was based on absolutely no evidence, right? And I'll tell you what the real problem is and why the Prime Minister keeps on talking about colonial mindset, right? Now, the real colonial mindset, according to me, at a much higher level and more intensive level than even the British exists today. I'll tell you why. We had a law, which is the Code of Criminal Procedure, which has now, of course, been amended, which allowed the British on suspicion to arrest anybody, only on suspicion. Now, that law was meant actually to ensure that those who protested against the British were immediately incarcerated without necessarily any evidence. Now, in any modern society governed by the rule of law, you get the evidence first, and then you arrest a person. This colonial mindset allows you to arrest a person and get the evidence later, right? This has been actually converted into a master class by this government. What they do is they want, say, they've targeted Kejriwal, they targeted Satodia, they targeted the Gandhi family, they targeted Huda, they targeted Hemant Soren, right? They targeted Akhilesh Yadav, they targeted Farooq Abdullah, they targeted Omar Abdullah, they targeted, many others.
Not one of their own.
Not one of their own. Not one of their own. So they want to actually capture power where the opposition is ruling, use the instrument of law as a weapon. So if they weaponize the law, which has never happened before in this country, and they use the colonial mindset in a far more insidious way than ever before. This has never happened in the history of our country. So this country today is far from even attempting to become secular. It has nothing to do with secularism. It is just aggrandizement of power. So it's very dangerous for democracy, because if this continues, one day the pressure cooker will burst.
Yes.
Right? And we and you, all of you, will be targets. That's the real fear.
Now let's turn to something where we could be a little more hopeful. This morning we heard observations suggesting that in your profession, your main profession, where you started, a lot of young people are coming with better capabilities, better preparation, possibly better outlooks. And we heard many comments on observations or insights on that from earlier speakers, starting with the first one this morning, that thanks to the new law schools and other factors, they come in there and there's a certain idealism. Secondly, more women are coming into this field. They haven't perhaps reached the top, your level, but there are quite a lot up the ladder going up, and this will take a little time, but a lot more are coming. At some levels, they outscore the men, and so on. So all this seems to be a very positive development. Can that, when you talk about pushing back against what we discussed earlier, does that give you a lot of hope?
When I was a kid, I was extremely, starry-eyed about what the future should be. We're all passionate about the future when we are young. As we grow older and we get into families, we somehow are hesitant to take on the system. But it was easier to take on the system earlier than it is today. The state is so powerful today, that it is very difficult. It's very rare that you will see a voice of dissent, even in my profession. Even in my profession, there are leaders in the profession who don't speak up, right? Now, most of the young people who get into the profession, and the best thing is that the best minds are coming into this profession, mostly because I think there's more money in it. Let's be clear. So people get into this profession, and most of them don't want to be as litigators fighting it out, because that's a very risky proposition.
So they do backroom work.
They do backroom work. They get into the corporate sector. They get a good, cushy job. They do very well, which is fine. So they are into commercial transactions. But change in any society, and that's how our history has taught us, comes when lawyers are in the forefront of change. And I mean politics. Anywhere in the world, if you go, you will find, whether it's the UK or it's in France or it's another European countries, lawyers are in the forefront of change.
In our freedom struggle.
In our freedom struggle, they were at the forefront of change. In the American War of Independence, they were in the forefront of change.
In Sri Lanka.
In Sri Lanka, they were in the forefront of change. Unfortunately, the lawyers here, even though young people are coming in, are not really concerned about these issues. And they have not taken them up when they come into the bar, right? The part of the reason is that the entire legal profession has become oriented towards how much money I can make, right? And this is really a problem that is occurred because of the transformation of the economy when it was opened up in the 90s by Narasimha Rao,
yes,
Dr. Manmohan Singh. So when you have money flowing into the system, when you have the corporate sector making tons of money, they can hire anybody. With money, they can buy them over. And there are very few left who will fight the system. So while I have great hope for the profession, I have no great hope that the politics of this country will change.
Yeah, I think that's an important insight.
I'm a little worried about
and
that.
Differentiation from some of what we heard this morning. I think that
You have to be passionate about the law. Remember, law is not a business. Law is not a business. Law is a passion.
Yes.
And it has to be central to your life. Because you as a lawyer, incidentally, and this is my belief.
And you are a very successful lawyer, professional.
I'm lucky. I was been lucky. But let's put it that way. Be that as it may. What I think, that a lawyer's duty as a lawyer is to fight the system. We come here.
Yeah, hear that, students.
It's very important to understand that. You are pitted against the state all the time, right? Why do you go to court? Because somebody somewhere is trying to do injustice, right? That's when the client comes to you, right? So you're pitted against the state. So your first duty is to fight the state,
yes,
right? In every possible way, right? That's how you become a citizen who is responsible for change. That's how you develop that passion, that I'm here to change the system because the system is unjust. It may be qua client, it may be qua an institution, it may be qua the nature in which the state is run. That's why lawyers are in politics, because they know how the system is run at a micro level, and they understand how the system runs at a macro level. Therefore, remember this: as young lawyers, you have to be passionate about standing up against injustice, which means if our fundamental rights are violated, you don't have to worry about money. Go there and fight for the person, fight for the institution. If you don't have that, this country will not change.
Okay, since we are on the theme of, at least in part, on politics, now you had a notable role in the last Congress government.
Yes.
And then at some point, you raised a number of issues. Of course, we followed that. You expected better from the.
I've always been a dissenter in my life, so that's okay.
Yeah. And then at one point, you decided to leave that party,
Yes.
but perhaps share many of the ideals that it stood for. Could you explain your own
See, I tell you, this is a problem with
journey to movement towards that?
Yeah, it's. I came into politics. Actually, I was an accidental politician, right? Because almost every political leader in the country was my client at some stage or the other, still is. And then some of them said that, why don't you enter politics? So I won't tell you the long story, but anyway, that's how I entered into politics. The problem with politics is when you're a political party, you're under a constraint.
Yeah.
Right?
Yes.
Because you have to follow the tenets of the party. You can't say anything against the leader. You can't express your view independently. And the greatest damage that has been done to the system is the concept of what is called a directive by the political leader.
Yeah.
Right? That you have to abide by what the political leader says. I think that is the greatest damage to democracy. If you look at the difference between the United States and the UK and Europe and India, the president of the United States, even if he belongs to the Conservative Party or to the Republican Party, has to reach out to the Democrats to get his bills passed.
Yes.
Right? The Labour government or the Conservative government in England has to reach out to the opposition to get their bills passed. Right?
Yes.
This doesn't happen in India because there is the concept of a whip.
Yes.
Which means you have to obey the party. Now, that's completely undemocratic. That is what has destroyed democratic culture in our country. Because if I'm a member of a Congress party and somehow my views are inconsistent with the views of the party, I can't express them, both inside Parliament and outside Parliament. Why inside Parliament? Because I'll be subject to defection. Why outside Parliament? Because the party will say, look, what is this that you're doing? And so therefore you will be sidelined. Nobody wants that. Right? So the concept of whip has destroyed democracy in India. And this is a big problem. Therefore, there is no vibrant democracy because people can't interact with each other. We should be able to talk to the ruling party. Ruling party should be able to talk to us. But the whip doesn't allow that. This is the greatest danger to democracy. And therefore, I decided that, look, I can't do this. Because even within the government, I was protesting on many issues. Yeah. Right? And then I decided that if they don't need me, I don't need them. That's how it worked.
And yet
but I am I am wedded to the Congress cause because I think I'm wedded to the constitutional cause. The Congress cause is the constitutional cause, quintessentially.
Yes.
So I'm wedded to it. And therefore, I am perhaps as much of a congressman as anybody else, being outside the Congress. Right? And I have great relations with the Congress party. And, I fight their matters even today. And I'll continue to do so.
That's a great position to be in.
Yeah, but it's tough.
Your,
it's tough because
integrity.
I maintain my integrity, but I get 2 minutes in Parliament.
Yes.
So that's tough.
Okay. Now, back to the law. From Umar Khalid to Professor Sai Baba, has it become tougher to fight cases for the protection of individual rights, human rights, the fundamental rights against state action? And you already mentioned the draconian laws, where the basic tenets of criminal law, like the presumption of innocence, the right against self-incrimination, the right to a fair defense, all that has been turned on its head.
Oh, much worse than that. You have a law which says now, and there are several statutes which say that at the time of bail, you have to show that you are innocent of the offense. And how will you show at the time of bail that you are innocent of the offense? How can a person plead innocence if he doesn't know what the case against him is? And the law says that, right? And therefore, unless the public prosecutor is heard, and unless you're prima facie show to the court that you're innocent, you won't get bail. What kind of provision is that? And we've been fighting, but then the courts have not struck it down. See, this is the problem. Without fear or favor. That's the key. A judge doesn't have to bother. He doesn't have to be pragmatic. Pragmatism is for politicians.
Yes.
Pragmatism is not for judges. Judges have to stand. Judges have to stand by the Constitution and stand by their conscience. And that's a problem.
Has the Supreme Court consciously, me? Yeah, okay. Has the Supreme Court consciously shed its vaunted role as a constitutional court and reduced itself to being an appellate court?
Well, that's a problem. That's a real problem. And see, the Article 136 of the Constitution, the special leave to appeal, allows every decision to be appealed against. Now, there the problem arises not at the level of the Supreme Court. The problem arises at the level of the trial court. Right? Now, I don't want to really say this openly in public, but there's a problem at the trial court level. There's a real problem.
Yeah.
So when that happens and it goes to the appellate stage or the revision stage, there's a problem there also. Right? In many of these cases, the decisions are problematic. Then you go to the High Court after that, and the problem is somewhat reduced, but there's a problem there also. So therefore, when the Supreme matter reaches Supreme Court and Supreme Court says, you know, this doesn't seem to be right, what does the Supreme Court do? It has to interfere. So if the system from the bottom up was not as problematic as it is today, you wouldn't have this kind of litigation in court, in the Supreme Court. That's one problem. The other problem is a constitutional court should be a constitutional court, right? Therefore, you should have 4 regional courts, according to me, in the 4 regions in India, and you should divide India into these 4 areas, and the states proximate to each other should have a highest appellate court. And only a constitutional issue should come from that court to a constitutional court in the Supreme Court. And that constitutional court should be, say, not more than 13 judges, right? And if they decide as a court together, you won't have several Supreme Courts. And then the court will speak in one voice, right? But having said that, if they don't act in accordance with their conscience, then it can be far more dangerous.
Yes.
So you have to weigh both things and decide where you want to be.
I recall that several years ago, Mr. K.K. Venugopal wrote an article for The Hindu, something along these lines. He didn't discuss the risks and so on, but he was very clear, similar thinking on this.
You see, what happens is most of the litigants who come to Delhi are from the states proximate to Delhi. It's easier to travel. So who will come from the northeast? Who will come from Kerala? Who will come from, you know, far off places, Madhya Pradesh? No, very, 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 very difficult. So basically, you're making it difficult. That itself is injustice, because access to the court should be as much of a fundamental right as anything else. So if your court is in New Delhi and there is no access for people in the far-flung areas of India, then that itself is antithetical to the concept of justice. So I think this needs to change. But who wants the change? Nobody wants change. It's only power, political power.
Now on the collegium system, a sensitive topic, not perhaps for you, because you speak up. The union government has very unreasonably delayed or selectively segregated names recommended by the collegium. We had a distinguished Chief Justice of a High Court just before we came, who was very highly thought of, but you know what happened.
It's because of the case I argued.
Yes.
That poor chap landed where he
So
landed.
which did you not argue?
A lot of them I did, and put some judges in difficulty, unfortunately.
So transfer recommendations have been changed merely because the government wanted it done. And you've already said that.
No. It's not just the government, Ram. Let's be clear on it. Okay. So in the army, for example, in the defense services, you decide beforehand who's going to be the chief. Right?
Yeah.
Now, that's also been done away with now. Now you have a joint chief of staff person who retired, who had retired as lieutenant general.
Yes.
Right?
Yes.
And was picked up as joint chief of staff suddenly after 2 years of his retirement when he was not even a general.
Yes.
Right. So in the judiciary too, whoever the Chief Justice is, he somehow manages to decide that if I bring this person, right, as Chief Justice of this court, then he can become the Chief Justice of India. Right. So let's forget for the moment the government. There's a problem within the system itself. Right. Who should become Chief Justice of which state depends on the 4 or 5 people who sit as part of the collegium. Right. Now, they have their own, see, we are all human beings. We have all our frailties. You know, I can't claim I'm God, nor am I claim I'm as virtuous as, as white as snow. It's not, just doesn't happen. So you have your own likes and you have dislikes. And it also depends on which courts you have served. If you have served in Tamil Nadu, right, you like somebody there. If you have not served in Tamil Nadu, you won't know the judge. So if the Chief Justice is from Tamil Nadu, you'll prefer a person from Tamil Nadu, right? So this happens. So therefore, the system doesn't work on any basis which is consistent with the need to have the best man be the Chief Justice of India, right? So there's a problem within the system. Then there's a problem outside the system. Because if you choose a highly independent judicial mind, the government just will not allow it to have.
Whichever government?
No, not whichever government. I mean, I know for a time when I was law minister, I never refused any recommendation made by the judiciary. Never. Because I say it's for you to decide. Right? But now the politics of the country. Look, if you read a newspaper any day, any newspaper of this country, half of it is law.
Yes.
Half of it is law. And courts.
Yeah.
So politics in this country is run through the courts today. Right? Yeah. Elections come after every 5 years. But you destroy reputations every few months. And that happens to the court system. And that's very dangerous.
And I think the Chief Justice of India recently said something like that courts are being used as a platform
Yes.
to settle political scores.
Justice Gawai used to say that when he was Chief Justice. Don't fight your battles, for political battles in court. And I think that's a good sort of principle to hang on to for judges.
Finally, before we turn to questions, there are a lot of young people here also. Your advice or
my advice to young lawyers is that AI is going to change everything. Change everything in the profession, in the field of chartered accountancy, medicine, and law. Right. Right. And so AI is a huge, I mean, you can't even imagine the revolution that's going to take place. You can't just imagine.
But it hallucinates and it fabricated cases. We read that.
That's an aberration. That's another matter. But AI will certainly, how you draft a print, how you send a notice, everything, that work will all go, and what research you do. Now you even tell the attitude of the judge. AI knows about the judge as well. So he'll know what the AI will tell you what to argue before which judge, because AI knows who the judge is, what his proclivities are, what he thinks, what his politics is, and AI will tell you what to argue. I mean, that's the extent to which change is going to take place. We don't even know at this point what that change is going to be, but it's going to be phenomenal. I don't think in the history of the world there will ever be a revolution of the nature that we are going to see in the next few years. I would say about 3 years from now, right? You had the Industrial Revolution, it's changed a lot. You had colonialism, when India was a great, when the Mughals were ruling here, India had 20% of the global GDP even then. But when the British left us, it was reduced to 2%, right? Then we had the Internet Revolution. After that, we had the mobile revolution. Now you have the AI revolution. And that's going to young people change everything. So you better be prepared for it.
Can it empower good people?
It will. It will also empower people, but skilled people. See, the biggest danger of the AI revolution is that the unskilled will be out of work. See, if I can move away from law a bit, if you look at why AI has come, you see, every step by the Western world is intended to colonize the less developed world. Right? Yeah. This is the history of the world. Okay? Now, it's a way of colonizing India, according to me, because AI involves huge investments in what are called GPUs, graphic processing units, which require huge investments in the hardware. All those investments are happening in the West. So the IP is all controlled by the West.
To some extent, China.
Very little. China is into application of AI. In other words, robotics. China has about 8,000 patents on robotics. America has about only 4,000. India has 1,000 something, right? But that's an application of AI. We're not on application. We're at the level of creating IP. That's all with the United States of America. So if you have the IP, India will be like the BPOs, right? Will be the service-oriented, economy. In other words, we'll never control the system. So whatever they tell us, we'll have to do, like we've been doing in the past. So we need, actually, the real change we want in this country is in the education system. We need to free up education completely. We need autonomy in the education system. We need to let as much investment comes into the education system. We need huge investment in skills. We need investments in this country to create IP. And that involves learning the English language. Remember, all this is going to happen in the English language, right? And now we are saying all your medical books are going to be in Hindi. I don't mind that. I'm not against Hindi, but the fact is that you have to work globally. The Chinese students are all learning English, and we are being told not to. So this is the real problem. They are going to colonize us in another way, and we have no choice. So we need to free up the education system, free up universities, allow them to function, don't interfere, let them compete with each other, skill our people, have great faculty, pay them well. Unless you do that, no country in the world has become a great power unless it has had a quality education system. This is true of the United States of America. This is true of China today. It is true of China today. It is true of Europe. It is true of Germany, right? All countries which had a system of education which was not quality oriented will always remain poor and less developed. This is my view.
In this connection, I'd like to mention the outstanding work done by our partner in this event, the Vellore Institute of Technology, whose founder is here, Mr. Viswanathan. It started out as a technology university. Yes. They're known for it, scale as well as quality, but now they are venturing into new areas. And if you had a few minutes after this event, he may update you on their plans.
I'm passionate about technology.
And the sheer scale of it and what they're doing, and he's constantly reinventing his approach to the educational system.
We should have open platforms in technology. We should share information around the world. We should tie up with other institutions. We should do all that. And government should be nowhere near the picture. These governments are always intrusive and destructive of everything that we want to do.
So now let's say we can have half a dozen questions. Please introduce yourself. Keep the questions short and pointed, because we have to make best use of the time available. And after this, there's another session. We apologize to the panelists for shifting it at short notice. But we are all interested in that as well. But your questions, please.
Good evening, sir.
Will you regulate?
Good evening, sir. I am Nehal Mahfouz a student of public policy. I have a question. Sir, after the recent discharge of Arvind Kejriwal and Manish Sisodia, where they spent years in jail for a case the court eventually found lacked cogent evidence, and given your defense of Umar Khalid and Sonam Wangchud, who remains entangled in the legal trap of UAPA and NSA, do you believe the Indian judiciary has reached a point where the process is the punishment?
Yeah, I think they reached it long ago. No doubt about it. What you're saying, I agree entirely.
Sir, the question is, a process is the punishment.
Yes, yes, that's the answer.
So he's already given you the answer, my friend.
That's the answer to it.
Very succinctly and very directly. Can we have another question, please? Please do identify yourself before asking the question. And may I remind you one more time, remember this is a public platform, a public forum. So please keep the questions relevant and to the point. Thank you.
Good evening, sir. My name is Shraddha. I'm doing my fourth year in VIT School of Law. So, for today, my question is, can exclusive pragmatism risk and dilute the foundational constitutional principles such as liberty and equality?
What is pragmatism? Pragmatism has nothing to do with doing justice without fear or favor. It's nothing to do with this. Pragmatism is alien to the should be alien to the judicial system, according to me. Pragmatism is, as I said, for the politicians, not for courts.
Thank you.
So, good evening, sir. I'm Asram Shun from VIT School of Law. So, my question is, sir, how does legal education in a modern age help uphold constitutional values in a society where younger generation refrain to come on constitutional activism? Because sir, you spoke on how actually courage is used to fight against injustice. At the same point of time, you say how actually quality education helps in legal education as well. So, how does it relate, sir?
Understand the question. Really.
Could you slow down and ask that question one more time, a little slowly, so that all of us can?
How does legal education in a modern age helps uphold constitutional values in a society where younger generation refrain to comment on constitutional activism, sir?
Where younger generation
refrains to comment on constitutional activism.
refrains to comment.
Yes.
Yes.
On
apolitical or
Yeah, they're not commenting or not really voicing their opinion. Let me complete that question for you in case. So you're saying the younger generation is not really voicing their opinion
Yes,
or
sir.
on the communalization of constitution? Is that what you're saying?
Not like sir, but like most people, they are actually moving away from this domain to domain which is actually giving them money, like financial matters.
Well, I've already said that in my opening remarks, that you guys are more interested in money than law.
So you're pretty much quoting him again.
Yeah.
Yes, thank you, sir.
You're
Right,
endorsing my opinion, I hope.
I'm sure that. Do we have another question? Yes, we do. Yeah.
Good evening, sir. This is Parvez Rahman, and I'm an advocate practicing across the for all Delhi. So my question is, how do you effectively address a bench when it appears that a judge has already formed a firm opinion on the issue, and despite your best efforts and shows no inclination to reconsider, especially when you strongly believe in the merits of your case? Of course, with the caveat that you are the great Mr. Sibal and I am just a new advocate.
See, it's very simple. What's your job? Your job as a lawyer is to do the best for your client, right? And the judge's job is to do justice. And if the lawyer feels that the judge is doing injustice, now it depends on which forum you are arguing. Because if it's the trial court, you'll go up and appeal. Hopefully somebody will find a judge who will try and do justice consistent with your view. If you think injustice is being done, then there's another appeal. You go to the High Court, then you go to the Supreme Court. So it's hierarchical. If with the Supreme Court you feel that the judge is not being fair, there's nothing you can do. You have to just do your job. I mean, I did my job in Umar Khalid, I lost, right? As far as the other matter, Sonam Wangchu is concerned, that matter is still pending. So we don't know what the outcome is going to be. But many matters we do lose, thinking that the judgment is wrong. For example, in the electoral bonds case, the judgment went thus far, but should have gone much farther. Because if your premise was that without a quid pro quo, there would be no electoral bond, then naturally, where is the quid pro quo? And that should have been investigated, not investigated. But that's where it is. I mean,
that's pragmatism.
That's not, no, that's not pragmatism. It's just that, you surrender because there's no way out. Right? What can you do? You can't do a thing. So a time will come when this issue will be opened up. And we're waiting for that time. Hopefully it will come soon.
Right. One last question. This will be the last question that we will take.
Good evening, sir. My name is Abhinay Lakshman. I work at the Hindus Bureau in Delhi. You mentioned that there's nothing called a precedent anymore. My question is that we have seen judgments where judicial reasoning has been made, but at the end of the order, it says that this judgment cannot be a precedent. My question is, do you think such commentary is a comment on the rigor of the judicial reasoning or on ownership of the judicial reasoning, the refusal to own this judicial reasoning or the rigor of the reasoning?
Well, okay, let me tell you a thing about precedents, because which most people don't quite appreciate. See, remember, a question of law, unless it's a pure question of law, right? Otherwise, a question of law that arises in a case is contextualized by the facts of that case. No question of law arises without the underlying facts. The underlying facts may lead the judge to reach a certain conclusion of law, right? Now, you may cite this as a precedent in another case. But I can assure you, and I've done that on several occasions, that the facts of your case may allow you to persuade the judge to say that that precedent is not valid for you because your facts of your case are entirely different. So you contextualize your facts and say the precedent doesn't apply. That's one concept of, that's why most precedents are not applied in Supreme Court, because there is essentially except it's a pure question of law, you're interpreting a particular provision of the Constitution, deors the facts. I can understand that. What you're talking about is when a judge says, in the peculiar facts of this case, it should not. In what are the kinds of cases in which that happens? You give seniority to somebody, you give a pension to somebody, which you do out of your power under 142. Or you feel that this person has been unjustly treated, even though the law is against him. So the counsel for the government will say, if we are able to cite, somebody is able to cite this as a precedent, it will affect other employees, and we may be in difficulty. It's in that context that usually the court says, don't treat it as a precedent. But it's not in every case that that happens.
Maybe one or two more, sir?
Sure.
So well, we have Sybil sir here, so we will allow for two more questions, please. Very quickly. One right at the back. Yes. Can we pass the mic? This will be the penultimate question. I'm sorry, there's another panel.
Sir, I'm Advocate Vikram Arora. My question, what are your views on All India Bar exam?
All India Bar exam.
Is it really necessary?
You see, I have great concern about the number of people who are entering the profession. I have great concern about that. In New York, when I became a member of the New York Bar, there was a system by which when you sit for the bar exam, the top 60% will pass and the bottom 40% will not be declared pass, because you want to restrict the entry to the profession.
It happened with chartered accountants.
Yeah.
They used to.
Yeah, exactly. Now, the problem is if you have too many people and they all want to practice in Supreme Court, or they all want to practice in one court, you have overcrowding, and then a lot of problems arise because of practical problems arise. One, there are not enough cases. Two, you wrangle for briefs, and the quality of the profession goes down. So at some stage, as a nation, we need to think about quality in all professions, whether it's doctors or chartered accountants or lawyers. So if you have an All India Bar exam, it'll address partly that question. It'll partly address that question, but it will not still stop people from entering the profession.
Last question, and let's make this one count. Yes, we have some.
Good evening, sir. I am Shwab Rahman from Jamia Millia Islamia. Sir, you rightly talked about constitutional morality and minorities' right, and it being faded day by day. But you have also spoken about the matter being listed before a particular bench, and bench comprises of judges. Sir, I want to know, you have been in the Supreme Court for not quite since 1975. Sir, quality of judges before the collegium and after the collegium.
What will compare the quality?
Very specifically, sir.
Very difficult to compare quality of judges. There is a sort of there's a line that you can draw that that tells you that yes, some are good. That's the line that you can draw. The problem with this whole issue about which matter that comes before which judge, I think AI will solve that issue.
There's one lady right at the back of the hall she's been waiting very patiently. We'll take this as the last question.
Because this master of the roster business has to stop. And AI is the only solution for that.
Namaskar, sir. Good evening.
Sorry. Yeah, and then you conclude. And on that note, on behalf of everyone here, including Mr. Viswanathan and our editor, Suresh Nambat, all the others present, heads of institution and so on, I'd like to express our gratitude to Mr. Kapil Sibal for this session.
Thank you, sir. Thank you.
Insights.
Great to be here, Ram, with you. Thank you.
Sir, I'm going to take a moment of your time. There's a lady right at the back of the hall. She has that one last question that she's been waiting with. Please.
Namaskar, sir. Good evening. I'm Poonam Shankar Shivnani from Nasik, Maharashtra. I have one single question. I think many of them might be having. Do you see judicial judgments in India becoming time-bound in near future, so that Tariq pe Tariq becomes a thing of past?
Well, the problem is that, this is the wrong question to ask. तारीख पे तारीख क्यों लगती है कि एक जज के पास 70 केस रहते हैं, वो कहाँ डिसाइड करेगा? एक दिन में कर सकता है कोई 70 केस?
Sir, but that has to be time-bound, right?
How will it be time-bound? If a single man judge can't deal with 70 cases, what is he going to do? वो तारीख लगाएगा ना?
But
तो आप जज ज़्यादा बनाओ, इंफ्रास्ट्रक्चर दो, उनको लाइब्रेरी दो, उनको पर्क्स दो, अच्छे जज बनाओ. तुम अच्छे जज बनाते नहीं, अच्छे जज बनाते नहीं, सुविधाएं देते नहीं, इंफ्रास्ट्रक्चर देते नहीं, और फिर कहते हो तारीख पे तारीख, वो तो लगेगी.
Thank you, sir.
हम सरकार के पास जाते हैं, वो भी तारीख पे तारीख देते हैं.
Thank you so much, sir.
As eloquent as ever. Kapil Sibal, sir, thank you so much, sir, for your presence here this afternoon, this evening. I'm going to request Mr. N. Ram to please present a small token of our appreciation for the time that you've spent here with us and the views that you've shared, sir. May we have a memento presented to Kapil Sibal, sir. And that's not going to be all. That won't be all at this moment. I'm going to request the presence of Dr. G. Vishwanathan and Dr. G.V. Selvam. Sirs, to please come up on stage. And we have Dr. G. Vishwanathan, founder and chancellor, VIT, and of course, Dr. G.V. Selvam, vice president, VIT, on stage to present a token of our appreciation to Kapil Sibal, sir. Request you to please present that stole as well as a small memento. Thank you very much, sir, for your time and your views. And everyone here in this hall who was waiting so expectantly for you to arrive today and address the audience, I'm sure they've been enthralled. Thank you so much again, sir. And a big thank you to our distinguished guests who were on stage for the felicitation. Ladies and gentlemen, we do have that one more session to go. So I'm going to just quickly remind everybody to come back into your seats very quickly because we have that one more session, the final panel discussion that's still to go right after this in a few moments from now. Ladies and gentlemen, I'd request everyone who's standing outside the hall to kindly come in. Please, we're heading into our final session for the event, the panel discussion that we've got lined up for all of you. So I request everyone who just stepped out of that hall for a little breather to come right back in. We're just waiting for you to take your seats and we get the show underway one more time. Right, ladies and gentlemen, our final session for the event is improving legal access, making justice accessible to all. And this will examine key challenges that limit equitable access to justice and the practical reforms required to overcome them. It will explore how structural constraints within the legal system can be addressed to ensure that legal services are more accessible, efficient, and responsive to every citizen. And to moderate this session, I'd like to invite on stage our moderator, Mr. Kunal Shankar, Deputy Business Editor, The Hindu. Requesting your presence on stage, sir. Thank you so much for being here. And may I now invite our panelists for this final panel discussion. I'd like to request Ms. Shreya Arora Mehta, District and Additional Sessions Judge, Delhi, to please join us on stage. Thank you for your presence, ma'am, and thank you for taking time out today. May I also invite on stage Ms. Sanchita Ayan, Advocate on Record, Supreme Court of India. Pleasure to have you here with us, ma'am. Requesting the presence on stage of Ms. Karuna Nandi, Senior Advocate, Supreme Court of India. Pleasure to have you here with us, ma'am. And may I also invite on stage Dr. Tanya Sebastian, Head of the Department, BA, LLB Honors, VIT School of Law, VIT Chennai. Thank you for your presence, ma'am. Kunal, it's over to you now.
Thank you. Since introductions have already been made, I'll sort of get right to the discussion and probably just briefly introduce. So as has been discussed throughout the day, while India's constitution guarantees equality before the law and equal protection of the laws, the reality on the ground remains far from equal. Several empirical studies, including those by the Bangalore-based PACTA, reports from NALSAR, and quite a seminal book by Aparna Chandra and others, Court on Trial, a data-driven account of the Supreme Court of India. And of course, just a while back, Justice S. Muralidhar's Incomplete Justice have spoken about barriers to access being, quite a challenge in India. Of course, there are two ways we can talk about access to justice. One is the quality of access, the quality of legal services, and the fact that the process itself, as one of the questions that came here, process itself has often become the punishment. Long delays, inadequate infrastructure, and institutional insensitivity, which disproportionately often affect women, persons with disabilities, caste-oppressed communities, and sexual and religious minorities. So to discuss this, we have with us a stellar panel. We have Sanchita Ayin, advocate on record of the Supreme Court, who's widely recognized for her litigation, particularly for her work on inclusion and diversity. Judge Shreya Arora Mehta, District and Sessions, Additional Sessions Judge here in Delhi, known for her leadership in judicial reforms. Karna Nandi, Senior Advocate of the Supreme Court, has litigated key cases on gender justice, constitutional rights, and data and technology law. And we have Tanya Sebastian, who's the head of VISTOL, the VIT Chennai Legal Education Research focused on widening access to legal education. So, I'm going to sort of open the floor and really have these speakers talk about their experiences in sort of enabling greater access. Let me first start with Sanchita. Sanchita, maybe if you can, we've been speaking about this a bit. One of the main interventions that you made was at the Supreme Court, where you represented Miss Sunny, who's here, I think, in the audience, to ensure that she could argue her own case. So maybe if you can start with your own experience of attempting to be a lawyer and then representing Miss Sunny as well.
Okay, so it's a long story. I'll try to make it short. I myself have a disability. It's a chronic neurological condition. And right when I was thinking I was unfit to work, at least in the litigation space, because I thought that people around were not ready to accept someone who can work only between 15 minutes to 4 hours at that time, because litigation demands you to give long hours, and no boss would perhaps accept someone not working that long enough, however good they may be. But I was surprised when I received a call from Mr. Farasat, and he wanted me to join his office when he had just started his independent practice. And he really encouraged me, motivated me, and I really saw the impact it made. And not just encouragement and motivation, he made real changes in the office that could accommodate my requirements. He actually asked me a question one day. He asked me, "How are you?" And I said, "I'm fine." This was a conditioning that any person with disability dealing with some sort of an ailment would have, that people are actually not concerned, really concerned to know how you're actually feeling. So therefore, you end up saying, "I'm fine." He said, "Look, Sanchita, if you don't tell me what is bothering you or what your needs are, how will I accommodate them? Because it's my duty to accommodate them." So that has been the my guidance. So each time I have to make sure that a workplace or an institution is accommodative. I understand it as a proactive step that the institution needs to take in order to make it accessible. The second office I had joined was Mr. Salman Khurshid. Again, the same thing happened. Had seen my work during internship, asked me to join. For 6 months, he kept asking me to join, and he said, "You work the way you want to." I said, "I need a recliner." At that time, I used to get very exhausted while working. He was like, "Take my card, you order a recliner." A stage came when I needed a dictation software. I have been using a scribe all my life to write exams. So typing was also an issue. So I said, I need a software, but I also need a space, a quiet place. So he rented out another flat. So with all these in place, I realized two things. One was, what would have happened if I wasn't that competent? What would happen to any average lawyer with disability? Would they get the same accommodations? The second point was that in the second office, I had many colleagues and they were not as accommodative. In fact, they were competitive. So I realized the significance of the institution bringing in a system in place. Otherwise, people would behave the way they feel like or the way their conditioning is. So unless systems are put in place by the institution, things won't work for other lawyers with disabilities. So therefore, I started this work. I said I'll mentor 5 lawyers with disabilities. The first one was Saudamini Pethe. She was a hearing impaired lawyer. Unfortunately, we lost her after 1 month of her joining me. The second one was Sarah Sunny. I'm still looking for 3 more. But so therefore, I wanted to provide her with all the reasonable accommodations, not just in the office, but also kind of persuade the institutions to put a system in place. So not a system, not a kind of system where I have to run pillar to post, or she has to run pillar to post to get an interpreter. And in fact, the system was so. I mean, I kept writing to the then Chief Justice, D.Y. Chandrachud, couldn't get an appointment, couldn't get an interpreter. Finally, I got an interpreter myself, and I just told him, I've paid the interpreter for 1 hour. Can you just let the video be on of the interpreter for that 1 hour? So I didn't seek permission because she didn't need a permission for an interpreter. It was her right. The other right she had was to get it from the court, which didn't happen. Then subsequently, I really wanted a system to be in place. I again wrote for an appointment. I again wrote that it's required. Didn't happen. So then I moved an application before the registrar to get a sign language interpreter. They got an interpreter who was not competent enough. So then the issue was how to make it seamless for her. So it's still been a struggle so far with both Supreme Court as well as High Court.
Yeah, that's quite remarkable, and I think from your experience, one thing that was very obvious was uh, it's a challenge to actually not just for those with disabilities to approach the court, but actually for those who are practicing in the profession to actually practice their profession when you have disabilities. So I think that thank you so much for sharing that that experience. If I can come to Judge Arora, if I have I have, like we were talking about all the statistics before, district court infrastructure. There's severe shortages. Over 4,000 courtrooms are required nationwide. There are residences for residential units which are not available, and all of this at the district court level, which is really the site for where the common man comes to seek any redress. How what is required in a framework to sort of overcome this? Of course, also your own experience of addressing these challenges on the bench. Oh, sorry, Mehta.
With respect to the challenges, with respect to the judicial infrastructure, which you just highlighted, and all of you have taken note of, when I became a judicial officer, I'm talking about 2010, back then. So, like between the officers, there used to be a talk that if someone gets a court in a particular courtroom, there may be a possibility that there may not be an attached washroom with the judge's chamber. So, of course, everyone had like fingers crossed that will we get a courtroom which has a judge's chamber with the attached washroom. But then at the same time, the judicial educators who were there, then they gave us an insight. They said when they started their journey in judicial services, in fact, there were courtrooms sometimes with no light, nothing. So they said that how they all came a long way. And in fact, those judicial educators did a good job in providing us sensitivity. And they said that since you are here, you are a service provider. So, of course, like, yes, that somewhere it may be lacking, somewhere it may be there, but then your attitude should be of a closer or of a doer. If someone has to do it, they will do it even without the infrastructure. And if someone is not keen to do it, they will not do even then. So, but then if you talk about infrastructure in Delhi now, of course, we had this All India Judges Association case, and where the former CJI passed a lot of orders. Things are evolving. They're much better now. Of course, they are all in evolution process. I would not say everything is there, but then yes, if you compare it to 10 years before or maybe 20 years before, it is much better.
Right. Right.
We are evolving.
We are evolving. Okay. So, Ms. Nandi, if I can come to you with my next question, um, uh, you know, one of the barriers in accessing justice is also the diversity on the bench, which is sorely lacking. One of the Justice Muralidhar's book, actually, Incomplete Justice, talks about it. The Supreme Court and many high courts have generally followed the convention of appointing from the bar and then, of course, subordinate judiciary. But do you think the appointment process largely has enabled this sort of disproportionate representation? Or is there a larger role, a larger cleanup, a larger revamp that's required to enable diversity, on the bench, which can then probably enable greater access for many communities? For instance, Ms. Chandra's book mentions that there have been only two women judges on the collegium so far, Rumapal and Nagaratna. And Justice Nagaratna, sorry, Justice Rumapal and Justice Nagaratna. So that's one. Similarly, judges on the who've become CJs, who have been Dalits or from other communities, have been far underrepresented. So maybe if you can speak about that, and how that denies access.
I'm delighted that we're talking about access to justice. And the point you're making is a very important one, Kunal, right? Because, I think one of the previous panelists was speaking about the best man for the job as Chief Justice, for Chief Justice. And that kind of thing, where does it come from? The fact that it's always been a man. Always. Now, we are going to have Justice Nagaratna as chief. It's not going to be for very long. I think it's about 26 days. What is the essential problem with having straight, mostly upper caste, able-bodied men, right? Upper class men as judges across the board? And let me be clear that it's changing quite fast. And we have wonderful examples like Judge Mehta at the district judiciary, as a sessions judge. So it's changing very fast, I think, at the district level, right?
Right.
Even at the high court level, it's changing. I'd say not as fast, but it is changing. But at the Supreme Court level, it has, at the moment, it's gone backwards.
Right.
So we are currently, trying to, as a group, judges and lawyers all together, we are trying to address this problem. And on March 8th, and here's a little plug for our event, on March 8th, the Supreme Court judges and some of us senior advocates are going to have 4 panels on ways to ensure that the bench is 50-50. So the Chief Justice, Justice Suryakant, is going to be on the first panel. I am moderator on the last panel, and everyone's going to really come together to try to understand how best to address this problem. In my own personal view, I think reservation is in fact important. And when I speak of reservation, I don't just speak of women. I speak of women. I speak of within women. I speak of queer women, trans women, women of disability, women of different castes. I think this is very, very important. But also when we speak of men, I think that's same. And I'm not saying that the reservation should be across the board, but I think that in many there are many examples around the world of ways in which reservation has succeeded. People sometimes tell me that reservation is a dilution of quality. But if you see the very thin layer of people who are currently judges, right? Like, is there any reason that you should have these 5 or 6 characteristics being ascribed to a person who occupies the bench? No, there isn't.
Right.
It's just the fact that traditional power structures are willy-nilly getting replicated. Now, it's true that as a polity, we have been able to sustain quite a high level, I think, on average, of delivery of justice. And I'm going to say also that it's not true that women are always going to be the most egalitarian, right? In terms of the delivery of justice. Like, we have seen judgments from Justice Chandrachud actually, it's passed a large number of judgments that addressed disability, that addressed gender in ways that were, really wide-ranging and imaginative. And then you have other judges who've been women who have some women judges have also done the same, and then there are other women judges who haven't. It doesn't matter. Representation is a good in and of itself. Sanchita was saying that as a disabled person, but this is also true if you're a woman or if you're a Dalit or if you're queer or if you're anything other than somebody with these 6 characteristics, right?
Yeah.
You have to be much better. You have to work much harder. You have to succeed. But the point of representation is that it's important to have people of many different experiences who are very good, right?
Right.
But it's not that just because you're a woman or a Dalit or a queer person that you have to be 10 times more brilliant than the next guy, right?
Right. Right.
Yeah, I have a lot more to say, but I don't think you have a lot of time.
No, yeah, no. I was actually going to correct myself. I think on the collegium it was Justice Bhanumati, Justice Rumapalan. No, and Justice Muridhar actually makes this point where he says maybe it's time that there's a mandatory woman on the collegium and a mandatory Dalit on the, someone of the oppressed caste on the collegium as well. So an interesting suggestion there.
I mean, I will say, Kunal, that it's a bit complicated because I think you also need then the disabled person, the queer person, the trans person. So how do you grapple with this? It's not a
Right.
simple challenge, right?
Right. Yeah. Right. So, Ms. Tanya, if I can come to you, since they're all students here, and I'm sure legal education has quite a lot. So, access to justice really starts with access to legal education. And how inclusive do you think our law schools are today? Socially, economically, and what reforms are needed in curricula, in admissions, in education and outreach in general?
Thanks, Kunal. Thanks for doing all the homework and telling me what requires to be done. But that apart, I think you've put it across very correctly. And I also like the choice of words that we are using here, which typically we don't hear when we discuss anything to do with legal access. So, rightfully, inclusivity and diversity are the 2 keywords that we are aiming for. And I think we had also spoken a bit about, how these barriers are traditional, but also require a new outlook. So the barriers can be very relevant and very small, but the outlook also matters. For example, what is it that is not allowing a student who really wants to pursue law, right?
Right.
So the motivation is there, the encouragement is there. So what really stops them? Understanding those facets are very, very important. So as an example, just to give an example, let us say that the tuition fee is an issue, right? So we have to work in that direction. But that is just one challenge, right? Students today are also facing many challenges, including determination of their gender. They are not identifying it the traditional way that we have been.
Right.
Or mental health issues, for example, right? So understanding what these barriers are and creating systems that can help them gradually,
Right.
while also educating ourselves is the motive.
Right,
Yeah.
right. Thank you, thank you. Judge Mehta, if I can come back to you, we were just discussing earlier about the quality of legal aid, and we were talking about how, as you said, India is a global leader when it comes to legal aid, but at the same time, in the past 30 years, when legal services, free legal aid has existed, it hasn't quite the quality has sort of maybe ebbed and flowed, and that has also been an issue for a large section of the population to not be able to access justice. Would you agree, or would you want to speak about that?
So with respect to quality, yes, that is a need of the hour at the moment. But when we talk about India as a global leader, why we say that in the legal services institutions at the moment, India is a global leader because we are the only country where free legal services are statutory based. And then it's court annexed. So every authority at the district level, at the state level, at the national level has patron in chief, executive chairperson, and even secretary from the judges. So at national level, the patron in chief is the CJI, and the second J1 is the executive chairperson, and the member secretary NALSA is from the district judge level. And then similarly at the state level, it's the Chief Justice of the High Court, and then the J1 and the judge involved. And similarly at the district level. So it's the district judge who's there, and it is in that mechanism. But when we talk about the quality, it is, of course, we are global leaders, and India is being approached at the South Asia regional countries level because where legal services, the free legal services, is actually NGO based. So pro bono work. And in many countries, it is ministerial. So nowhere it is court annexed, which is existing in our country. But when it comes to quality, we are all working towards it. We have monitoring and mentoring mechanisms. We have now introduced mentoring lawyers. We have senior lawyers who are mentoring junior lawyers. But then quality for always has been an issue. I'll share one thing which happened when I was the district secretary, and we were interviewing lawyers for the panel. And one young lawyer with 3-year experience, because at the magisterial level we require some 3 years experience. So he came and he could not, not that, of course, it's not a complaint, but he could not answer basic questions of procedural law. After fourth question, we put it across to him that how does he plan now? Because of course he is not able to answer. Then he said, no problem, I'm a learner. I will learn. So anyone who's there on the interview panel would say, he's a learner, and why not go ahead with it?
Right.
But then what we then thought was that, like legal service institution, what matters most is, and what I take from all of them, like all what we are talking about inclusivity, it's highly linked with dignity. And we are dealing with the dignity of those people who are actually deprived. They are vulnerable. Actually, there is section 12, it lists the number of people. And when you see those category of people, we actually cover 80% of the population. And here is a young lawyer who says, I will learn. So then we put it across to him that you were going to learn at the cost of the deprived, who's actually criticizing the system, who's
Right.
actually feeling that he's not being respected, he's not getting remedy. And now here comes a lawyer is given free of cost, and who's going to learn through his case. So then we, of course, we guided him. We guided him, join a lawyer, senior lawyer. So you may do pro bono work there first and then join us.
Right.
But then quality is a concern. But there are a lot of senior lawyers who are actually assisting panel lawyers these days.
Right.
So that mechanism has now started. There is even Advocate's application now has a column, how much pro bono work you've done.
Right.
So which is great. So and spirit of volunteerism is coming in people.
Is sort of
It's coming.
Yeah. Well, thank you, thank you, Ms. Nandi. And on that question of transparency in for instance the list of how you get designated as a senior, which used to be rather opaque at a particular point, but it appears to have probably cleared up a bit now. And and do you think that that has enabled certain degree of nepotism to reduce, which probably is what shall I say, enable first-time lawyers to be practicing?
So I think these are two slightly separate questions. Your question is about designation as senior lawyers, and then there's also about first generation lawyers and practice, right?
Right.
I think he's asking me the question, folks, because I'm a first generation lawyer and I was designated senior counsel by the Supreme Court senior advocate by the Supreme Court in 2024.
That's right. Congratulations.
Oh, thank you. So, look, I think the fact that there is now, I mean, there have been changes since then. I will say that. But when my cohort applied, you had to set out how many law changing judgments and constitution of judgments that furthered constitutional law that you had supported or argued rather, not supported, in court. You had to list those. You had to list how much pro bono work you'd done. You had to list your academic accomplishments, how much you'd published, etc. And it was, so I think when all that is set out in black and white, it automatically becomes that much more objective, right? But at the same time, there is still the veto process in the so there's the three most senior judges, there's one senior member of the bar, and then there's the attorney general.
Right.
Inevitably there will be discretion at its best,
Right.
but when it's not working, sometimes there will be bias, right?
Right.
The system really worked for me because I applied the first time, but I know some excellent people who didn't get designated.
Right.
Right. But by and large, I think that that transparency and that robustness is. But when you speak of people, first generation lawyers, I think that the legal education system has expanded to such a degree that access in that sense is great. Now, in my own little my tiny little chamber where I have, I mean, not tiny, I hope in terms of impact, but tiny in terms of, I employ 4 lawyers. But who assists me when, briefing counsel has missed something. So I always give extra points if somebody is first generation, a woman, disabled, etc. And then we make reasonable accommodation.
Right.
That's just a matter of policy, mental health issues, etc. In terms of pro bono work, I think people know about my pro bono work, but I'm not now able to take those individual cases because people phone me, right?
Right.
My number is online, for better or worse. My cell phone number is online, and the reason I haven't taken it down is because sometimes I will get that one call which I feel I cannot not represent.
Right.
But in addition, but normally the pro bono work I now do is impact litigation. So it has to affect huge numbers of people. Otherwise, I won't. Otherwise, I won't do that case.
Right. Thank you. Ms. Ayn, if I can now come to you. The RPWD Act has now existed for some time. Do you think that has enabled greater access? Have you, in your own practice, seen if that has sort of, redressed grievances?
Right. So now at least we have a concrete law, a concrete provision which provides for access to justice, which calls for special courts to be appointed. One of the sessions court is a special court. SPPs are appointed, but so far we have seen it in Delhi. We haven't seen in most parts. Tamil Nadu doesn't have it. Have been conducting sensitization trainings conducted by the Judicial Academy after the SOP of Supreme Court, but again judges don't attend it. I think it's very important that Judicial Academy conducts mandatory training program on inclusion, on disability rights, sensitization needs to happen. And sensitization to an extent that we can deal with the biasness of the lawyers, of the judges. So if I can just talk a little bit about the legal education aspect. So I think it's very important that when in constitutional law class or in any other class for that matter, you look at the law from the lens of inclusivity. You see it as a constitutional principle and see if the laws can be tested on that touchstone. Because the title, if you see, is it's also justice for all. It's not just access. Access is the procedural aspect, I understand. It will take a while. We need to involve the stakeholders, and only then we should be coming up with circulars. We should not need another circular to implement that circular. I had to run from pillar to post within the Supreme Court because everyone said it's not our job to implement that circular. Then we mentioned before the Chief Justice of India, then came another circular. So this court bureaucracy, we are getting caught into that even when there are specific circulars, appointing panel of sign language interpreters, for example. Now, all of these really need to be seamless. They can be seamless only when the stakeholders are invited and we discuss it and we are open. Our intention and willingness is there to make a change. Now, legal education, you students get educated on RPWD Act. You can go and do awareness camps. You can go to the schools of where you find, still we have special schools. Unfortunately, inclusive education is still a distant dream. So go there and kind of give them legal education, encourage them to join litigation. Because right now what is happening is even firstly students think they won't be able to, because in most of these spaces they don't get quality education. That's the problem with special schools. Now that's the first hurdle, where they cannot get into the system where they can get legal education, formal legal education. The second hurdle would be even after getting it, they don't know how to sustain themselves in litigation. And that's where representation would be so important. Seeing them as being successful is so important. For us, it is important because I still don't feel I belong. If I could have someone like me around, not just one person, but a few others, that would give me a sense of belongingness that perhaps other people have. Now with women, that's not an issue. We see quite a few. Thankfully, over a period of time, we see enough women in the Supreme Court, at least, as well as I understand when I use the comparative lens, not enough. But when compared to persons with disabilities, so we need to ask that question: that why don't we see enough persons of disabilities around us? And we need to also ask the question that what is it that is missing? Because these steps ought to be taken ex ante, which means it's not like someone needs to approach you for resolution or complain about the discrimination. There needs to be proactive steps that need to be taken in order to be an inclusive society. Because see, justice is not just about punishment, it's not just about dispute resolution. It's in essence to create a kind of structure in the society so that every person can fully participate in all aspects of life with dignity. So when we approach it through that lens, it will be really helpful for us to form an inclusive society.
Great, thank you. My final question to Ms. Sebastian, taking from there, law schools, some law schools now do have legal aid cells. There is a VIT, for instance. But do you think the current law school training sufficiently equips lawyers, future lawyers, to think of justice delivery, as Ms. Ayan just said, as a systemic problem, not just, as a practice alone?
Thanks, Kunal. We are running out of time. Yeah. But because my fellow panelists raised the issue of legal education in the classroom, that itself cannot work every time, which is why we have something known as clinical legal education as well, where where because we are grounded in that one particular place, we have regional support, we have local support, and that enables us to connect more with the community. And what my perspective really is that it doesn't stop there, because we are talking about 18-year-olds and 19-year-olds who are entering the law school and how their journey will be for the next 5 years. We also have to ensure that they interact with the locals at a level that the locals can then have confidence and can build on skills. So it's not just a short term measure that we are talking about, it has to be something long term, right? And personal stories go a long way in trying to understand where are we falling short of. So let me give you an example. These chairs are made for tall people. So I am having a very hard time sitting here. Yeah. But that is just one thing, right? But we have to put it out and we have to say it. So clinical legal education, for example, goes a long way in not just addressing issues that we have in the classroom, but also in that connection that we make with people around us. Thank you.
I hadn't really thought of the fact that this could be only for tall people. Thank you. Thank you so much. And I think that's all we have time for this panel. I would really like to thank our panelists for this really. Yes, there are questions. Do we have time for questions? Okay.
Myself, I'm Siddeshwar, fourth year, VIT School of Law. I'm raising a question before this panel. Do you believe whether judiciary has expanded access of justice on rough judicial activism or created institutional strain?
Who's that question to?
Presented before this panel, sir. Question
Anyone?
before this panel.
Anyone for the panel? Do you want to take it up, Judge Mehta?
I'll say, it's always thought of that access to justice is only for stakeholders involved in the legal profession to attend to. But I am of the ardent view that access to justice is not limited to the stakeholders. It is a pathway for all the people of our country. Why I say so? Because law as a profession is linked with all and different subject matters. You cannot separate law from economics. You cannot separate law from psychology. You cannot separate law from philosophy. You cannot separate law from political science, sociology. We are all interlinked. When we are interlinked and we are working towards it, so my concern is that you as a law student, even you are a law student or even if you're not a law student, you can walk towards that door. And of course, that's such a conclave that access to justice is like, of course, we are working towards it. I started with saying that it's evolving. So yes, that because, when we started the criminal justice system, I'll say when the criminal justice process started in our country, we all know it was adversarial. It was all rights accused. And then came the rights of the accused. Then people started saying that the accused persons are treated as if they're staying in a 5-star hotel. Then a decade before, victimology came in. We became victim centric. But at this moment, where we are in the criminal justice process, we are in the hybrid integrated state where we are actually respecting criminology vis-a-vis victimology. Each and every aspect is respected. And of course, that aspect is the growth, which I say, which is happening, and where the quality also has to be maintained.
I mean, as you had sort of caveated earlier, this is what you have seen in Delhi. We don't know how it is across the country.
It's evolving.
Oh, I see.
I mean, that's a good point because I do judicial trainings from time to time. So at the National Judicial Academy in Bhopal, and I've done that twice, and then twice at the Delhi Judicial Academy. Now the thing is that I'm I'm just filtering what I can say and what I can't say. The thing is that Delhi judges are often much better, far more, at a different level from judges from some of the other parts of the country. I mean, not just Delhi, Bombay, Chennai, in the metros.
Right.
And there are obvious reasons for this. But the thing is that the quality of justice cannot be strained depending on, where you happen to be. So that's a problem that we're grappling.
Right. Right. Any further questions?
Yes, there's a question here from. My name is Sara Sani. Sanchita did mention about me, so yes, I am here. My question is, I went recently to a district court. There was a mediation matter, and it was at short notice. And after the mediation happened, I went to the DLSA office and was wondering if the remuneration for the interpreter can come from there. And the answer was, I'm sorry, I don't know. From DLSA, that's what. And the person also asked the lawyer to go out and said, can we just speak to the interpreter? So it somehow felt that I was not valued enough as a lawyer and the interpreter there was more valuable. Second thing was in Bangalore, there was a case and I went with an interpreter. The court asked who these people are, who am I? And I told them I am a deaf lawyer. I have a sign language interpreter. I'm wearing the gown. I am looking like a lawyer. They said, no, not allowed. Get out. That was what the response was. The third thing is at Supreme Court, some of the cases have live captions. I don't get an interpreter every time. So the bench, I requested if captions can be arranged, live captions. They said, why don't you look at your phone? So I'm just trying to think what could be the alternatives and possible solutions to my rights in this case.
Fantastic. Yes. Thank you, Sarah, for that question. Do you want to take it?
I asked her to ask this question.
Brilliant.
Well, I have a couple of thoughts. I think there are various committees in each court, right? That can be accessed, and the onus can't be on you. The onus has got to be on a group of willing people who are willing to kind of give their time to something like this, and I would be happy to help and give some time to it. Another way to do it, I think, is to bring a case on access, right? And there have been a number of cases on access, and there've been a number of fantastic judgments on access. And some of them are quite recent. I had occasion to look at some of the case law because I had a case. I was running a case for a young man who wanted to do the CAT, and they weren't giving him a bigger screen. All he wanted to do was to see the questions. Like literally, this is all he wanted, right? And they said, we can't give that to you. And his father was an extremely privileged person. He was CEO of a big company that was across the Asia Pacific. And so he came to us, and this was not a pro bono case at all. And we succeeded, and he's done very well, and he got interviewed by various IITs, etc. But I think the point is that there's already a whole bunch of excellent case law that brought Ronak to his computer, but that should also bring you your closed captions. That should also bring a disciplinary mechanism by which, if you are disrespected and if your dignity as a lawyer is offended, that you can go to a very easy complaints portal or something, maybe even an anonymous complaint, I don't know, where there is no backlash, right? And all the other things that you need are made a reality.
So we have been dealing with the committees, just to add to that. And therefore, I would really like people in authoritative positions to jump in and take some proactive steps in this regard. Because it's been a while and we have got stuck repeatedly in the court bureaucracy. What we have started using the term court bureaucracy, because the committee is, sorry to say, it's a blind boys club. So just if they sit with the committee head who is a judge, it may not be possible to understand what exactly she needs and where she needs it. But she needs the interpreter urgently to appear for a court proceeding. She should be able to get it. The court proceedings records the name of the interpreter. The interpreter should be able to claim their fees. So by and large, it's very simple, so long as it reaches the correct person, and also there is an intentional willingness. So yeah, more voices will definitely help. And this question was more to raise the awareness on the issue so that we have more people talking about it.
Yeah, great. No, thank you. And I'm given the cue that the question answer session is also up. I just want to ensure from our okay. Oh, there is one last question. Is that it? Okay.
Yes, yes.
Okay.
Good afternoon, everyone. I am Ananya Chaudhary from Gujarat National Law University. So earlier today, we had Mr. Kapil Sibal here, who made a point saying that judges are not expected to uphold public morality or public interest, but they are supposed to uphold constitutional morality. But then, how do courts go about protecting the rights of sexual minorities in majoritarian democracies, where it's constantly pitted against each other, public morality and constitutional morality?
Great question. Judge Mehta, would you want to begin with?
Second. So, the courts are somehow, it's a good question. The courts are dealing with it, but then, yes, constitution for all of us is the grand norm. So, preamble. So when you talk about public morality or constitutional morality, I'm of the view that it's ingrained in the constitution, in fact. Morality and law walks hand in hand. And then what our forefathers in the constitution, if you see like how it was, so the grand norm when it came, and even now when I sometime we are interpreting the statute, which has not been interpreted by because at the district court level, we are at the granular level, the things like once we decide, it goes to high court and then it goes to Supreme Court. There are still many aspects because there are many laws, so which is argued before us, and then no one has ever interpreted it. But the constitution has always answered it in somehow or the other. So you all being the students of law, I would always say that yes, like for you, it can be a food for thought. What he said may not be wrong from his perspective, but I would say because, I have worked deeper in the subject, because I deal with the subjects which are pending before me from day to day. And I've urged to all the law professionals that, once you hear something from here or something from here, before you imbibe that or get into that zone process of that thinking process, I always insist go deeper, go to the roots, research yourself, and then form an opinion. So, of course, it can be a food for thought for you. So, work
Great.
on it.
Thank you.
Also, very quickly, I strongly doubt he said that public interest is not a consideration, right? He probably said public morality and the mob are not something that should inform a judgment when it is at odds with constitutional morality. So these are two separate things.
Great. So thank you so much on that note. I would really like to thank our panelists. As they said, access to justice is a evolving thing. Hopefully, it gets better over the years. Thank you.
Thank you very much, Mr. Kunal Shankar, for moderating this session as well. And a big thank you to our panelists. I would request you, Kunal, to please present them a small memento as a token of our appreciation of them taking time out from their busy schedule to be here with us. Thank you very much, Shri Arora Mehta, District and Additional Sessions Judge, Delhi. Thank you so much, ma'am, for being here. Big thank you to Ms. Sanchita Ayan, Advocate on Record, Supreme Court of India. Also, a big thank you to Ms. Karuna Nandi, Senior Advocate, Supreme Court of India. Thank you so much, ma'am, for being here. Also acknowledging the presence of Dr. Tanya Sebastian, Head of Department, BA LLB Honors, VIT School of Law, VIT Chennai. And a big thank you to Kunal Shankarji for moderating the session. Thank you so much, sir. Wishing you well. Thank you all. And ladies and gentlemen, that brings us to the conclusion of proceedings for Justice Unplugged 2026. Of course, we trust that the perspectives exchanged today will serve as a catalyst for continued progress and deeper commitment. To formally conclude the event, I would like to invite Dr. Raviraj C., Professor of Law and Dean, VIT School of Law, VIT Chennai, to kindly come up on stage and deliver the vote of thanks.
Good evening to all the distinguished members of this august gathering. In every generation, the strength of democracy is measured by its commitment to justice. With this guiding thought, as we come close to the Justice Unplugged 2026, it is my honor and privilege as Dean of VIT School of Law to propose the vote of thanks. At the outset, we express our profound gratitude to our most respected special guest, Dr. Abhishek Manu Singhvi, Senior Advocate, Supreme Court of India, for his special address, which offered clarity, conviction, and a practitioner's realism to our deliberations. We are deeply honored by the participation of Honorable Justice Mr. S. Muralidharan, Senior Advocate and former Chief Justice of the High Court of Orissa, whose reflections on constitutional thinking enriched us profoundly. We extend our sincere gratitude to you, sir, for your presence and insights. Our heartfelt respect and thanks to Mr. Kapil Sibal, Senior Advocate, Supreme Court of India, whose engagement in the fireside conversation brought both intellectual depth and candor to the evolving debate on constitutional morality and judicial pragmatism. We extend our sincere thanks to you, sir, for this invaluable presence and thought-provoking insights. We extend our gratitude to Shri Suresh Nambat, editor, The Hindu, for delivering the welcome address and for strengthening the bridge between journalism and the law. We sincerely thank our founder and chancellor, most respected Dr. G. Vishwanathan, for presiding over the eminent gathering and for his visionary leadership in establishing VIT School of Law as a center of excellence. We extend our heartfelt thanks and profound respect to our beloved Dr. G. Selvam, Vice President, VIT, whose leadership and commitment to academic innovation continue to strengthen the foundations of progressive legal education at VIT. His emphasis on interdisciplinary learning, technological integration, and global engagement has ensured that our students are prepared to navigate the evolving demands of legal profession in the era shaped by digital transformation and emerging technologies. We are deeply indebted to Mr. N. Ram, Director of the Hindu Group, for his commitment to independent journalism and for elevating today's dialogue through his thoughtful engagement and leadership. We are grateful to Mr. L.V. Navaneeth, CEO of the Hindu Group, whose contribution in media and the public discourse has consistently upheld informed dialogue and intellectual integrity. I also take this opportunity to express my sincere gratitude to our Pro Vice Chancellor, Dr. T. Tyagarajan, for his constant encouragement and steadfast institutional support in fostering academic excellence and meaningful legal discourse. I extend my thanks to the campus director, Dr. Satyanarayan, for his guidance, which greatly contributed for this event. I would also like to acknowledge with appreciation the efforts of our public relation officer, Mr. Arun Kumar, and his team from VIT Chennai, whose coordination and outreach ensured that Justice Unplugged 2026 reached a wider audience and received the visibility it truly deserves. We would like to specially acknowledge Mr. Sundareshan, Senior VP, Mr. Rajesh Menon, VP, Mr. Ayyappan, Ms. Vrinda, for their dedicated efforts, professionalism, and seamless coordination in successfully organizing this event. Our sincere thanks to the moderators who steered this important conversation with insight and balance. Our thanks to Mr. Sandeep Pukhan, Ms. Aratika Bhaumik, Mr. Krishnadas Rajagopal, Mr. Kunal Shankar. I also extend my gratitude to all our distinguished panelists, Mr. Vishal Sinha, Ms. Neha Rati, Mr. Shadan Farasad, Mr. Gopal Shankaranarayan, Ms. Shreya Arora, Ms. Sansita Ain, Ms. Karuna Nandi, and many thanks to my beloved colleagues, Mr. Keshav Murthy, Assistant Dean, Dr. Sharmila, Dr. Jishnu, Dr. Tania, for their dedicated efforts and support in meaningfully organizing this legal conclave. My thanks goes to all our alumni, Advocates Rudraksh, Shruti Srinivasan, Karmania, and Akhil Philip. I thank my students of VIT School, whose dedication ensured the seamless execution of this program. To our knowledge partner, The Hindu, we extend our deepest appreciation. This collaboration has made Justice Unplugged not merely an academic event, but a national platform for serious legal reflection. A very special word of appreciation goes to our sign language interpreter, whose dedication ensured that the event was inclusive and accessible to everyone. Your effort reminds us that true communication goes beyond words, and we deeply are grateful for your professionalism and commitment. We also extend our sincere appreciation to the Leela Palace, New Delhi, for their exceptional hospitality. As we conclude from this forum, let us carry forward a shared resolve. As the UN Secretary General reminds us, let us move for an AI that is shaped by all of humanity for all of humanity. With deep gratitude to every speaker and every participant and every supporter who made this gathering meaningful, I now formally declare Justice Unplugged 2026 concluded. Thank you. Jai Hind.
Thank you very much, sir, for the vote of thanks. And ladies and gentlemen, before we all disperse, it's my duty to request everyone to stand for the Indian national anthem. Thank you, one and all. I hope you have a great evening ahead.
Thank you, Mark. As always. Well, thanks that you kind of put it all together. It makes my life easy.
Always good to be part of the